Here is a good example of how time ran its course despite the initial failure of the Senate to ratify the treaty. The settlers presented the government with a fait accompli, and the Senate acquiesced and belatedly ratified the treaty. The treaty is also an example of the government's insistence that it deal with an entire tribe, not with separate bands, and that a ratified treaty bound the entire tribe. The non-treaty chiefs did not sign the treaty, which had been negotiated by Lawyer and other treaty chiefs, and did not consider themselves bound by its provisions, a circumstance that laid the foundation for the dramatic encounter between Chief Joseph Spand and the United States Army in 1877.38. By the time the treaty was finally ratified and proclaimed, new complaints of white encroachments induced Lawyer and his followers to seek a new council, this time in Washington, where they could meet. 36 For a detailed account of this treaty and the conditions under which it was signed, see Alvin M. Josephy, Jr., The Nez Perce Indians and the Opening of the Northwest, 386,442. The old and new reservations are clearly delineated in Royce, Sessions, Plates 16, 51, and 60, Area NOS 441 and 442. Senate ratification is in Senate Ex. PROC, Volume 14, PT 2, 87,273. 37 Senate Ex. PROC, Volume 15, PT 2, 662, 74,849. 38 Josephy makes a good deal of this point, asserting, the treaty was a fraudulent act on the part of both Lawyer and the commissioners. On the one hand, Lawyer and his followers had no right to sign away the lands of the other bands, and they knew it. On the other hand, the commissioners followed a time-worn and deceitful procedure of extinguishing title to Indian land when the rightful owners refused to sell. Nez Perce Indians, 430. Page 279. Directly with the President. At length such a meeting was authorized, and Lawyer and a small party reached the capital in May 1868. Amidst enjoying the sights and pleasures of Washington, the Indians signed a new treaty on August 13, 1868, with Commissioner of Indian Affairs Nathaniel G. Taylor. The document preserved lands for a United States military post, provided for extra allotment lands, protected the timber resources of the Indians, and guaranteed money for teachers. 39. The United States Indian Peace Commission. The treaties of 1867 and 1868 signed by the United States Indian Peace Commission were the most important of the final Indian treaties, and they epitomized the radical reformist Indian policy that emerged in the years immediately following the Civil War. The treaties of 1865 on the southern and northern plains had proved ineffective, and new reports on the deteriorating condition of Indian tribes and their hostility sparked an intense determination by the federal government to correct these problems once and for all. The report of a joint special committee of Congress headed by Senator James R. Doolittle, submitted in January 1867, described in detail the degradation of the Indians' condition and the causes of Indian hostility, and the Powder River War along the Bozeman Trail, with the startling ambush and destruction of Lieutenant William Fetterman's command on December 21, 1866, had led to a special investigating committee, whose report reinforced the conclusions of the Doolittle Committee. 40 The Central Plains, too, were on fire, and hostile Indians terrorized the regions on both sides of the Platte River. The reports and statements of 1867 crystallized in a firm recommendation for a reservation scheme by which the Plains Indians would be moved out of the way of the whites. Although this was by no means a novel idea, officials now asserted the urgency and absolute necessity of such an arrangement in order to save the Indians. The Indians should be made to move to the reservations, where they would be given. 39 Kapler, 2:102425. C. Josephy, Nez Perce Indians, 43,840, for an account of the delegation's trip and work. 40 The Doolittle Committee report was published as Condition of the Indian Tribes, and as Senate Report Number 156, 39-2, Serial 1279. The reports on the Fetterman disaster are in Senate Ex. Document Number 13, 40-1, Serial 1308. Page 280. Livestock, agricultural implements, and spinning and weaving equipment to enable them to move toward self-support, schooling in letters and industry, and missionary instruction in Christianity. There they could be isolated from all whites except government employees and others permitted on the reservations. By an act of June 20, 1867, Congress created the United States Indian Peace Commission, intending to take the business of negotiating with the Indians out of the hands of the executive and the regular Indian office officials and give it instead to a special group of civilians and military leaders with interest and competence in Indian affairs. The body had authority to call together the chiefs of the warring tribes, find the causes of hostility, and negotiate treaties that would remove all just causes of complaint on their part, and at the same time establish security for person and property along the lines of railroad now being constructed to the Pacific and other thoroughfares of travel to the Western Territories, and such as will most likely ensure civilization for the Indians and peace and safety for the whites. For Indians who did not then occupy reservations under treaty agreements, the commissioners would select reservations for their permanent homes. 41. The act itself named Commissioner of Indian Affairs Taylor as chairman and Senator John B. Henderson of Missouri, Samuel F. Tappan, and John B. Sanborn as civilian members. The President appointed 3 high-ranking Army officers, General William Tecumseh Sherman, Major General Alfred H. Terry, and retired General William S. Harney. An extra member, Major General Christopher C. Auger, at first substituted for Sherman and then became a regular member of the commission. The Peace Commission, after an abortive attempt to deal with the Indians on the northern plains, negotiated first with the Kiowas, Comanches, Apaches, Cheyennes, and Arapahoes at Medicine Lodge Creek in southern Kansas. On October 21 and 28, 3 treaties were signed with different groups. They assigned the Indians to 2 reservations in the western part of the Indian Territory, where the United States would furnish rations and other goods needed to turn them into happy farmers. It is clear that the Indians did not want to settle down and live in houses but adamantly wanted to continue their nomadic life as buffalo hunters. The commissioners insisted that the old way of life was at an end, for the buffalo were fast disappearing. The chiefs seemed not to hear the 4115 Stat 17. Page 281. Warnings, and they signed the treaty when the commissioners agreed to allow them to hunt on any lands south of the Arkansas River so long as the buffalo may range thereon in such numbers as to justify the chase. 42. One needs only to read the treaties with their extensive provision for arable land for farming, construction of warehouses, mechanics shops, and other buildings, a land book to record individual allotments, compulsory education, agricultural seeds and implements, and a farmer, blacksmith, and physician to see the strong thrust toward civilization that dominated the documents. The treaties, annually for 30 years, provided for each male person over 14 years of age, a suit of good substantial woolen clothing, consisting of coat, pantaloons, flannel shirt, hat, and a pair of homemade socks, for each female over 12 years of age, a flannel skirt, or goods necessary to make it, a pair of woolen hose, and 12 yards of calico, and 12 yards of domestic, plus lesser provisions of the same kind for boys and girls. The Indians promised to make the reservations their permanent home, and agreed that the United States may pass such laws, on the subject of alienation and descent of property and on all subjects connected with the government of the said Indians on said reservations, and the internal policy thereof, as may be thought proper. The treaties stipulated that the land of the reservations should be held in common and that no cession of the lands should be valid unless executed and signed by at least 3/4 of all the adult male Indians occupying the same. The philosophical basis for these treaties and others made by the Peace Commission appears in its first report of January 7, 1868. Written by Taylor, the report is a denunciatory tirade against the evils of the Indian system, and it is suffused with evangelical sentiments favoring the civilization of the Indians, their mingling with white citizens, and their ultimate absorption into white society. 43. 42 Kapler, 2:97789. The work of the Peace Commission, including the treaty negotiations, was extensively reported in the public press, for a large corps of newspaper reporters was at Medicine Lodge. The reports of the journalists are examined in detail in Douglas E. Jones, The Treaty of Medicine Lodge, The Story of the Great Treaty Council as Told by Eyewitnesses. The book is a good place to get the feel of a treaty negotiation with the Plains Indians, for it provides an almost day-by-day account. Some of the proceedings of the council at Medicine Lodge Creek are printed in papers relating to talks and councils held with the Indians in Dakota and Montana territories in the years 1866-1869, 5666. 43 Report to the President by the Indian Peace Commission, January 17, 1868. Page 282. In the spring of 1868 the Peace Commission met the northern tribes at Fort Laramie. It signed treaties with the Sioux, beginning with the Brule, on April 29, with the Crows on May 7, and with the northern Cheyennes and northern Arapahoes on May 10. Other Sioux signed the treaty at the end of May at Fort Laramie. Red Cloud of the Oglala Sioux, however, refused to treat until the forts along the Bozeman Trail were demolished. The government gave in, largely because the extension of the Union Pacific made possible a new supply route to Montana west of the Big Horn Mountains. The forts were dismantled and burned in the summer, and Red Cloud finally signed the treaty in November. 44. Meanwhile, attention turned to hostile bands of Sioux along the upper Missouri, chiefly Hunkpapa's under Sitting Bull, who had little understanding or interest in what was taking place at Fort Laramie. They wanted the whites and the government posts out of their country, and they continued warring to achieve this objective. To deal with these Indians, the government enlisted the aid of the Jesuit missionary Pierre-Jean de Smet, who in June 1868 led an Indian peace delegation from Fort Rice to Sitting Bull's camp on the Powder River. De Smet spoke of peace to the Indian leaders, and Sitting Bull, in turn, urged peace as well. Some of Sitting Bull's associates, led by Gall, accompanied the peace mission back to Fort Rice, where on July 2 they signed the Fort Laramie Treaty. That Gall and the other Indian signers understood the import of the treaty with its assimilative terms is difficult to believe. 45. CIAAR, 1868, Serial 1366, pages 496,510. The report is also printed in House X. Document number 97, 42, Serial 1337. 44 Kapler, 2:9981015. Because the signing of the treaty took place at various times, the printed lists of signatures and witnesses are not completely accurate. A useful compilation of journals and other documents of the Indian Peace Commission is published in Vine Deloria, Jr., and Raymond Damali, eds, Proceedings of the Great Peace Commission of 1867-1868. The volume is intended as study material for students, however, and the texts have been edited for that purpose. See also papers relating to talks and councils held with the Indians, Passim. 45 There are accounts of the peace mission by de Smet in Life, Letters, and Travels of Father Pierre-Jean de Smet, S.J., 18011873, ed. Hiram Martin Chittenden and Alfred Talbot Richardson, 4 volumes, 3:899922, and in papers relating to talks and councils held with the Indians, 10,813. A journal kept by Charles Galpin, the interpreter, is printed in Louis Fowler, ed., The Galpin Journal, Dramatic Record of an Odyssey of Peace, Montana, The Magazine of Western History 18. Page 283. The treaty set aside the Great Sioux Reserve west of the Missouri River in Dakota, and the chiefs agreed to settle at the agencies and accept reservation life. Much has been made of the land provisions of the Fort Laramie Treaty because of modern concern of Indians to protect a community land base, but the treaty, like those at Medicine Lodge Creek, was a reformist document aimed at attaining the humanitarian civilizing goals of the Peace Commission, namely, to turn the nomadic warriors into peaceful farmers. The treaties of the Peace Commission were a triumph of theory and faith over hard reality. Aside from the fact that cultivation of the soil in quarter or half-section lots was infeasible in most of the area covered by the reservations and that successful enterprise tended to be in grazing rather than in agriculture, the tribes that signed the treaties were not prepared to conform suddenly to the philanthropists' views of the good life of English education and neat farms. Members of the Peace Commission also negotiated with the Navajos. General Sherman and Samuel Tappan in May 1868 met with these Indians at the Bosque Redondo in eastern New Mexico, where they had been forcibly moved in 1864 to prevent their raiding in New Mexico and to train them in agricultural pursuits. The commissioners could see for themselves the tragedy of the Indians in forced exile at Fort Sumner and the impossibility of moving them to the alien lands of the Indian Territory. Heeding the Indians' plea to be allowed to return to their homeland, the commissioners signed a treaty with them on June 1, which set reservation boundaries and provided for the return of the Navajos. All the customary stipulations for advancing the Indians toward civilization were included. 46 The pervasiveness of the civilization policy of the government can be seen here. Although the situation of the Navajos in New Mexico was quite different from that of the northern. 223. A recent account, which discusses the sources, is Robert M. Utley, The Lance and the Shield, The Life and Times of Sitting Bull, Chapter 7. 46 Kapler, 2:101520, John L. Kessel, General Sherman and the Navajo Treaty of 1868, A Basic and Expedient Misunderstanding, Western Historical Quarterly 12, 25172, Gerald Thompson, The Army and the Navajo, 15157. A brief account is David Lanehart, Regaining Dinta, The Navajo and the Indian Peace Commission at Fort Sumner, in John R. Wunder, ed., Working the Range, Essays on the History of Western Land Management and the Environment, 2538. Page 284. Plains tribes who signed the Treaty of Fort Laramie, the provisions for selecting homesteads, for school attendance, and the like were almost identical. Another treaty, similar in its stipulations to the others, was signed with the eastern band of Shoshones and the Bannocks at Fort Bridger on July 3, 1868. This and the Nez Perce Treaty signed in Washington on August 13, 1868, were the last of the formal treaties between the United States government and the Indian tribes. 47. The agitation that arose in Congress in the late 1860s about whether or not treaty making with the Indian tribes should continue had an effect upon treaty making activities even before treaty making was finally ended in 1871.48. There was delay in the Senate in acting upon treaties submitted by the President. Many were rejected outright by the Senate when a vote on ratification was finally taken, and some were withdrawn by the President after they had been submitted but before final Senate action. Thus, for example, on December 18, 1868, shortly after the opening of the third session of the 40th Congress, 16 treaties, dating from February 3, 1863, to May 27, 1868, some of which had been delayed by the President and others which had languished in the Senate, were recommitted to the Committee on Indian Affairs. A good number of these had been signed at Washington. A group of them were rejected by the Senate on February 16, 1869, and others were rejected on March 15 of the same year. 49. A year later, on February 8, 1870, President Grant, on the advice of Secretary of the Interior Jacob D. Cox, withdrew from the Senate the 1868 treaty with the Great and Little Osages and similar treaties of early 1869 with the Kaws, Sacs, and Foxes of the Missouri, and Iowas, all of which had provided for sale of ceded Indian lands to railroad companies. Cox spoke strongly against such sales. The possessory rights of the Indians should only be extinguished in favor of the United States, and the land to which such rights had attached should, thenceforth, be subject to the laws regulating the disposal of the public domain, including those which provide for homestead settlements and preemption entries. The policy of 47 Kapler, 2:102025. 48. See the discussion in the following chapter on the end of treaty making with the Indians. 49 Senate Ex. Proc. 16:413, 47,778, 17:7, 361. Page 285. Selling, by virtue of an Indian treaty stipulation, immense bodies of land to a corporation, is of comparatively recent origin. It seriously retards their settlement and cultivation, and should not, I submit, be hereafter sanctioned by that branch of the government, which is clothed with the power of making treaties. Cox objected to the low price per acre provided in the treaties, and for that reason also recommended the withdrawal of a treaty with the Oto and Missouri Indians. The Senate on February 14 returned the treaties to the President. 50. The stage was now set for the dramatic debate in Congress about whether or not treaty making was, after all, the proper means for doing business with the Indians. 50 Cox to the President, February 4, 1870, and Grant to Senate, February 4, 1870, Senate, Sen 41 BC 3, Senate Ex. Proc. 17:365. On April 22, 1869, the Senate had returned, at the President's request, a treaty of March 4, 1867, with the Shawnee Indians. Ibid. 243. Page 287. Part 3. Deterioration. The treaties made by the United States Indian Peace Commission were among the most important of the hundreds signed with Indian tribes. They were also almost the last. The growing feeling among white Americans that it did not make sense to treat with the Indian tribes as though they were independent sovereign nations when the Indians seemed in fact to be wards of the government finally reached its culmination. Aided by the pique of the House of Representatives that it was left out of the treaty-making process and thus had less say in Indian matters than it wanted, the attack on treaty-making came to a head in 1871. In that year Congress attached to an Indian appropriation bill a proviso that henceforth no treaties would be made with Indian tribes, although it reaffirmed the validity of those already ratified. The tasks in managing Indian relations for which treaties had been essential were then accomplished by other means. A strong movement developed both within and outside the federal government to weaken if not completely abrogate the old treaties, which were thought to inhibit the full assimilation of Indians into white society. The increasing attacks on tribalism became, of necessity, attacks upon the treaties as well. There was no sudden or complete abrogation of the treaties and their stipulations, however, for continuing reliance on treaty rights came from Indians and some of their white advocates. This was especially the case among the 5 civilized tribes in the Indian Territory, whose astute leaders knew how to cite their treaties effectively and how to. Page 288. Appeal to the sense of justice of the American people and the honor of the nation in living up to its commitments. Yet at the end of the 19th century and early in the 20th, special commissions, new laws, and Supreme Court decisions made clear that treaty provisions, once considered sacred, need no longer be adhered to. The Indians were to be individualized as yeoman farmers on their allotted lands, brought under the sway of American law, and treated as individual citizens, not tribal members. The treaty system had deteriorated to the point of collapse. Page 289. Chapter 12. The end of treaty making. After the flurry of treaty making in the decades of the 1850s and 1860s, many treaties of Commissioner of Indian Affairs George W. Penny, the Pacific Northwest treaties of Joel Palmer and Isaac I. Stevens, the Reconstruction treaties with the 5 civilized tribes, and the treaties of the Indian Peace Commission. It might seem strange that the United States suddenly and unilaterally decreed the end of treaty making on March 3, 1871. Anti-treaty sentiment. As a matter of fact, however, sentiment against treaty making had been steadily growing in the United States. there was a deepening appreciation of the anomaly, a conviction that the Indian tribes no longer possessed the attributes of sovereign nations necessary to make new treaties between themselves and the United States reasonable and acceptable contracts. Even professed friends of the Indians were loud in their condemnation of the treaty system and insisted that no more Indian treaties be negotiated. One of the earliest and most outspoken of these critics was Henry B. Whipple, Episcopal Bishop of Minnesota, who kept in close contact with the Sioux and Chippewa Indians. His sincere concern for their rights and interests was displayed. Page 290. In his courageous defense of the Sioux in the aftermath of the uprising in 1862, when his voice of reason and moderation sounded strange among the settlers' demands for vengeance. Yet Whipple had given up on treaties as the proper way to deal with the tribes. After his first visit to the Indian country, he wrote to President Buchanan on April 9, 1860, "Frankly, as a Christian bishop may write to the chief magistrate of a Christian nation, pleading for reform in the Indian system." The first of the evils he enumerated was that the government policy had been to treat the red man as an equal, and the first of his 8 recommendations was to treat the Indians as wards. When Lincoln became president, the bishop directed his campaign to him, asserting that it was impolitic for our government to treat a heathen community living within our borders as an independent nation, instead of regarding them as our wards. 1. Whipple saved his strongest blast for an article in the North American Review in October 1864, on the Indian system. "Our first dealing with these savages," he wrote, "is one of those blunders which is worse than a crime. We recognize a wandering tribe as an independent and sovereign nation. We send ambassadors to make a treaty as with our equals, knowing that every provision of that treaty will be our own, that those with whom we make it cannot compel us to observe it, that they are to live within our territory, yet not subject to our laws, that they have no government of their own, and are to receive none from us." Whipple asserted that treaties were usually conceived and executed in fraud. The real parties to the treaties, in his mind, were Indian agents, traders, and politicians, not the United States and the Indians. The real purpose, to pay the worthless debts of the Indian traders and to create jobs for political favorites, not to buy the Indian lands at a fair price and help the Indians spend the purchase money wisely to further their civilization. 2. Such opinions were strongly reflected in the views of the United States Board of Indian Commissioners, the body of religiously oriented philanthropists authorized by Congress in April 1869 to exercise joint control with the Secretary of the Interior over the disbursement of funds. 1 Henry Benjamin Whipple, Lights and Shadows of a Long Episcopate, 5053, 124, 13840. 2 Henry B. Whipple, The Indian System, North American Review 99, 45051. See also the criticism of treaties by a Presbyterian clergyman from Minnesota, Edward D. Neal, in a pamphlet published by the government, Effort and Failure to Civilize the Aborigines, letter to Honorable N. G. Taylor, Commissioner of Indian Affairs, from Edward D. Neal. Page 291. Appropriated for the Indians and to provide a lay committee to oversee Indian policy in general. 3 In its first annual report, written by the chairman, Felix R. Bruno, a Pittsburgh industrialist, the board was forthright in its condemnation of existing Indian policy and its recommendations for reform. It flatly declared, the treaty system should be abandoned, and as soon as any just method can be devised to accomplish it, existing treaties should be abrogated, and the legal status of the uncivilized Indians should be that of wards of the government. 4. The reasons for such a decision and the depth of the feeling that treaties were wrong were expressed in a statement of Bruno. The United States first creates the fiction that a few thousand savages stand in the position of equality in capacity, power, and right of negotiation with a civilized nation. They next proceed to impress upon the savages, with all the form of treaty and the solemnity of parchment, signatures, and seals, the preposterous idea that they are the owners in fee of the fabulous tracts of country over which their nomadic habits have led them or their ancestors to roam. The title being thus settled, they purchase and promise payment for a portion of the territory, and further bind themselves in the most solemn manner to protect and defend the Indians in the possession of some immense remainder defined by boundary in the treaty, thus becoming, as it were, perdiceps criminis with the savages in resisting the encroachments of civilization and the progressive movement of the age. Having entered into this last named impracticable obligation, the fact of its non-performance becomes the occasion of disgraceful and expensive war to subdue their victims to the point of submission to another treaty. And so the tragedy of war and the farce of treaty have been enacted again and again, each time with increasing shame to the nation. 5. The recurring word in condemnations of the treaty system was farce. President Grant's first Commissioner of Indian Affairs, the Seneca Indian leader Illy S. Parker, opposed further treaties with the Indians. Because treaties have been made with them, he wrote, they have become falsely impressed with the notion of national independence. 3. For the formation of the board and its activities, see Francis Paul Prucha, American Indian Policy in Crisis, Christian Reformers and the Indians, 1865190, 3346. 4. Report of the Board of Indian Commissioners, 1869, p. 10. 5. Charles Louis Slattery, Felix Reville Bruno, 18201898, a civilian in the War for the Union, President of the First Board of Indian Commissioners, 156. Page 292. Is time that this idea should be dispelled, and the government cease the cruel farce of thus dealing with its helpless and ignorant wards. Parker asserted that the tribes were not sovereign nations, for none of them have an organized government of such inherent strength as would secure a faithful obedience of its people to the observance of compacts of this character. Like other reformers, he called the Indians wards of the government and noted that the only title the law concedes to them to the lands they occupy or claim is a mere possessory one. 6. Grant, too, when he first met with the Board of Indian Commissioners, remarked that the treaty system had been a mistake and ought to be abandoned. 7. Such criticism of Indian treaties, arising in the general ferment over Indian affairs that developed during the Civil War and in the immediate post-Civil War years, was nothing new. Again and again, similar arguments had been made by responsible persons, who saw the anomaly of dealing with the Indians as dependent wards of the United States while at the same time signing formal treaties with them as though they were independent foreign nations, and by self-interested citizens, who hoped to acquire Indian lands for their own well-being and prosperity. But these arguments had been repeatedly turned aside because treaty-making, together with the regulation of Indian trade under the Commerce Clause of the Constitution, had become the principal means for conducting Indian affairs. What was new in the 1860s, the added force that finally brought the treaty house tumbling to the ground, was the resentment of the House of Representatives over its exclusion from dealing with the Indians. If Indian affairs could be handled solely by the President and the Senate under their constitutional treaty-making power, then the popularly elected House was left out in the cold. 6. CIAAR, 1869, Serial 1414, p. 448. Parker made a strong personal statement about the absurdity of the United States government making treaties with the Indian tribes in his autobiography published in Proceedings of the Buffalo Historical Society 8, 53233. 7 minutes of May 27, 1869, Records of the Board of Indian Commissioners, Minutes of Meetings, Volume 1, pages 67, National Archives Record Group 75. Grant, as Interim Secretary of War, had written in his report of November 1867, Indians have no principal chiefs, but roam in small bands, and fight independently, hence the impossibility to make treaties with them. House X. Document number 1, 40-2, Serial 1324, p. 30. Page 293. Distribution of Indian lands by treaty. The first reason for House anger and recalcitrance was the disposition of Indian lands to railroads or speculators by treaty provisions. The immediate issue was a treaty signed in May 1868 with the Great and Little Osage Indians. According to its terms, some 8 million acres of land owned by the Indians along the southern boundary of Kansas were to be ceded to the government, not to become part of the public domain and subject to disposal under the public land laws of the United States, but instead transferred to the Leavenworth, Lawrence, and Galveston Railroad. The company would pay 20 cents an acre for the land and use the proceeds from the sale of the tract for railroad construction. 8. The opposition of the House of Representatives to such a measure came to a head in the second session of the 40th Congress on June 18, 1868, in a report from the Committee on Indian Affairs. The discussion was directed largely by Representative Sidney Clark of Kansas, chairman of the committee. It was not a debate, strictly speaking, for no one spoke against the report. 9. The arguments were pointed and strongly expressed. Clark called the treaty one of the most remarkable transactions that has ever occurred in the whole history of this government. It is neither more nor less than the transfer of 8 million acres of land, which properly belong to the public domain of the United States, which belong to the landless millions in all parts of the country, into the hands of a railroad corporation, to be subjected to their supreme and unlimited control. He asserted that the details of the treaty had been all worked out in Washington by the president of the railroad company before the commissioners were sent out to negotiate with the Indians. It was not made by the commission at all, he said, but by the parties in interest. Representative George Washington Julian of Indiana, chairman of the 8. A thorough discussion of this abortive treaty and House opposition to it is in Paul Wallace Gates, 50 Million Acres, Conflicts Over Kansas Land Policy, 1854-1890, Chapter 6. The treaty is printed in Congressional Globe, 40th Cong, 2d Sess, 325,961. 9. The report, together with related documents, is in House Report Number 63, 42, Serial 1358. It appears also in Congressional Globe, 40th Cong, 2d Sess, 325,657. Page 294. Committee on Public Lands, declared that the commission was a thieving commission, organized to cheat the Indians and aid and abet the cold-blooded rapacity of railroad monopolists, a commission for swindling, spoliation, and plunder. His patience was at an end. In 1861, he asserted, we began this policy of special treaty stipulations by which the jurisdiction of Congress over the public domain has been to a very great extent overthrown in the interest of monopolists and thieves, and, sir, this Osage Indian treaty is the crowning flower and fruit, the rich culmination of the system. It has grown worse and worse and more defiant, because it has been unchecked in its course. 10. Since the Osage lands were not to be made part of the public domain, the opponents of the treaty pointed out that the granting of sections of land in each township for support of schools would not obtain, that squatters on those Indian lands could not be provided for under homestead or preemption laws, and the settlement of the southern sixth of the state of Kansas would thus be seriously obstructed. Some were upset, too, that offers for the Osage lands made by other railroad companies had simply been ignored by the Treaty Commission. 11. There is no doubt that the House represented the citizens of the United States, for whom the increasingly liberal land laws for disposition of the public domain had been enacted. Now there was shock because vast Indian lands were being disposed of by treaty outside the public land policies that the House thought were firmly in place. The move of the House, therefore, was to deny that the treaty-making power of the President and Senate extended to the disposition of Indian lands by treaty otherwise than by absolute cession to the United States, and for purposes for which Congress alone is competent to provide. 12. In the end, the House on July 18, 1868, resolved unanimously that the objects, terms, conditions, and stipulations of the aforesaid pretended treaty are not within the treaty-making power, nor are they authorized either by the Constitution or laws of the United States, and therefore this House does solemnly condemn the same. 10. Congressional Globe, Ibid, 3261, 3264. 11. See House Report Number 63. A strong protest against the treaty was made by the Kansas legislature on January 20, 1869, see Senate Miscellaneous. Document number 34, 40-3, serial 1361, or House Miscellaneous. Document number 49, 40-3, serial 1385. 12 Congressional Globe, 40th CONG, 2D Sess, 3257. Page 295. And does also earnestly but respectfully express the hope and expectation that the Senate will not ratify the said pretended treaty. Point 13. This was strong language, yet the remedy called for by the House at this point was simply non-ratification by the Senate, not abolition of the treaty-making power itself in regard to Indian tribes. The Senate heard the cries and did not ratify the Osage Treaty. The lands were disposed of by other provisions, which the House had a hand in making. Point 14. Attack on the treaty-making power. The House did not forget the issue of disposition of Indian lands by treaty, but it soon turned to another and more explosive question: did the House have a positive role in ratification of Indian treaties because of its power to appropriate money from the Treasury to fulfill treaty provisions? Here was a constitutional question that went to the very heart of the treaty system, and the debate on the question and its outcome profoundly affected the course of American Indian policy. At issue was the series of treaties negotiated in 1867 and 1868 by the United States Indian Peace Commission. When the Indian Appropriation Bill for 1870 passed the House on February 4, 1869, it authorized the payment of $2,312,260, without making specific provision for all of the stipulations in the Peace Commission's treaties, not all of which had yet been ratified by the Senate. The Senate Committee on Appropriations added a modest $540,963 to the bill, but the Senate Committee on Indian Affairs added the huge sum of $3,800,734, in order to pay for the annuities and other goods and 13 ibid, $326,566. More than a week earlier, President Andrew Johnson had sent to the House a letter of Secretary of the Interior O. H. Browning, dated June 9, 1868, in support of the negotiations of the Osage Treaty. See House Ex. Document number 310, 40-2, serial 1345, pages 13. This document, in 3 parts, contains papers relative to the treaty and its negotiation. 14 gates, 50 million acres, 21,025. Page 296. Services promised the Indians in the treaties. The Senate additions made the total appropriation under the bill $6,653,957.15. When the Senate amendments reached the House on February 27, 1869, during the third session of the 40th Congress, a violent debate exploded, which continued off and on until March 1, 1871, at the end of the third session of the 41st Congress. Not only did the members of the House refuse to accede to the appropriations added by the Senate, but they undertook a fundamental analysis and criticism of the treaty-making power of the President and the Senate under the Constitution, to which was added the question of whether the Indian tribes were apt groups for signing treaties with the United States. The Senate strongly asserted its rights, and the issue was joined. It was an extended and important congressional debate about treaty-making, and it is worth following in some detail. Point 16. The debate began as an outburst of indignation over the Senate amendments because they added so much money to the appropriations under the 1867 and 1868 treaties, much of it for items that House members thought highly inappropriate. Representative Benjamin Franklin Butler of Massachusetts, chairman of the Committee on Appropriations, went immediately to the heart of matter. The first question to be settled by us is this: whether the House by appropriations to carry out the provisions of these treaties will sanction this method of dealing with the Indians. If these treaties are to be sanctioned and appropriated, for gentlemen will see that it takes from the House the power substantially of legislating on Indian affairs. The whole matter resolves itself into this: are we in future to deal with these Indians by treaties and carry out this policy, or are we to deal with them in a different manner? The whole committee was decidedly hostile. 15 Congressional Globe, 40th Cong, 3d Sess, 1700. The treaties were ratified between July 25, 1868, and February 26, 1869, they are printed in chronological order in Kapler, 2, 982 ff. 16 Only brief accounts of the debate appear in secondary sources. See, for example, Loring Benson Priest, Uncle Sam's Stepchildren, The Reformation of United States Indian Policy, 1865-1887, 9699, Lawrence F. Schmeckabeer, The Office of Indian Affairs, Its History, Activities, and Organization, 5558. There is an account of the final part of the debate, that in the third session of the 41st Congress, in John R. Wunder, No More Treaties, the resolution of 1871 and the alteration of Indian rights to their homelands, in John R. Wunder, ed., Working the Range, Essays on the History of Western Land Management and the Environment, 3956. Page 297. To the Senate action, and one member called it the deepest villainy of anything that has been before this House for a great many years. 17. The treaties and the policy they represented, however, were not without eloquent support in the House. 3 members, especially, stood behind the treaties as a matter of public honor. Walter A. Burley, delegate from the territory of Dakota, where he had at one time been an Indian agent, spoke at great length of the responsibility owed the Indians. Representative William Windom of Minnesota insisted on honoring the treaties, confining his remarks to what he called the great question, namely, shall we comply with our treaty stipulations with these Indians or not? He noted that the House could discuss the constitutional issues involved, but that the Sioux Indians and the other wild Indians on the plains are not very good constitutional lawyers, and that however we may decide this question of constitutional law, it will not obviate the results of a breach of faith on our part. He pointed to the high quality of the members of the Peace Commission who had negotiated the treaties and made the promises to the Indians, and he feared an expensive Indian war, far more expensive than the Senate amendments, if the treaty promises were unfulfilled. He proposed that the House go along with the Senate as a matter of the wisest economy, to say nothing about the public faith and the public honor. Carrying out the treaty stipulations, he insisted, was alike due to the public faith which has been pledged and to the spirit of humanity which ought to actuate the dealings of a powerful Republican government. To Burley and Windom was added William Higbee of California, who pointed out that the very law of Congress that authorized the Peace Commission had directed the Commission to make treaties under the direction of the President, subject to the action of the Senate. 18. The sympathetic views of these men toward the provisions in the treaties did not seem to arouse much immediate support in the House. Instead, they were challenged by Representative John A. Logan of 17 Congressional Globe, 40th Cong, 3d Sess, 1699, 1701. 18 Ibid, 17015. The law authorized the Peace Commission in their discretion, under the direction of the President, to make and conclude with said bands or tribes such treaty stipulations, subject to the action of the Senate, as may remove all just causes of complaint on their part, and at the same time establish security for person and property along the lines of railroad now being constructed to the Pacific and other thoroughfares of travel in the Western Territories, and such as will most likely ensure civilization for the Indians and peace and safety for the whites. 15 Stat 17. Page 298. Illinois, who declared that the idea of this government making treaties with bands of wild and roving Indians is simply preposterous and ridiculous. It is not good judgment or statesmanship, it is child's play, nothing more and nothing less. Logan especially ridiculed the terms of the treaties that provided clothes for the Indians for a period of 30 years and a yoke of oxen to each Indian family settled on the reservation. And amid great laughter he lampooned the 3 men who had spoken in favor of the treaties. 19. The House refused to concur in the Senate amendments, and the Senate would not back down. A conference committee failed to resolve the deadlock, so the 40th Congress ended on March 3, 1869, without having passed an Indian appropriation bill. Action of the 41st Congress. The 41st Congress, which opened the following day, March 4, was faced with resolving the pressing issue. How could the management of Indian affairs be continued if no appropriation bill were passed, and how could the Indians be kept peaceful if there was no authorization for funds to meet treaty stipulations and other Indian needs? Intense and vehement debate in the House continued in March and April 1869. Representative Clark considered the whole matter a fraud from the beginning to end, manipulated, directed, and controlled by Indian agents and superintendents, who made these treaties in Washington, took them out to the Indian country, and went through the farce of having them signed by these Indians. On March 19 he offered this amendment to the bill. Provided, that from and after the passage of this act the Indian tribes in the states and territories of the United States shall be held to be incapable of making treaties with the United States, and no such treaty shall hereafter be made. 19 Congressional Globe, 40th Cong, 3d Sess, 1707. Page 299. And he reinforced this proviso with another that declared no agreement or contract made hereafter with Indian tribes would be valid unless approved by Act of Congress. 20 The motion, however, was ruled out of order as independent legislation. Then the appropriation bill, without funds to fulfill all the stipulations of the treaties of 1867 and 1868, was once more passed by the House and sent to the Senate. 21. As might have been expected, the Senate, like the House, held to its previous actions. It passed various appropriations for carrying out the treaties that were so hated by the House. It also considered in some detail the question of treaty making and of fulfilling treaties made and ratified. Senator James Harlan of Iowa spoke eloquently about the history of treaty making and about maintaining the good faith of the nation. He was seconded by Senator William P. Fessenden of Maine, who said of the Peace Commission treaties, "I do not know whether the treaties are wise, my impression is that they may be so now. They have been negotiated. The Senate has recognized them and ratified them. They are, therefore, to that extent the law of the land." While admitting the authority of the House to make or refuse to make appropriations to carry out the treaties, Fessenden insisted that good faith required fulfillment of any treaty already made with the Indians, for the Indians, not understanding the intricacies of congressional politics, would look upon the rejection of treaties by the House simply as broken faith. When he looked to the future, however, he was less sure that treaties were proper. "I am for putting an end to the idea," he said, "that these roving bands of Indians, which have now become so comparatively weak, are to be recognized longer as independent nations. I am for dealing with them kindly and wisely as well as we can, and I am opposed to the further multiplication of these treaties. I say this because I am in favor of executing in good faith those we have already made." 22. It was an accurate foreshadowing of the position that both the Senate and the House would ultimately take 2 years later. Senator Richard Yates of Illinois represented those who took a harsher view of the treaty system, for he held adamantly that the Indian tribes were not civilized nations, that they never had owned the lands they ceded in treaties, and that making treaties with them had been an egregious mistake. His extreme views were rebutted by Harlan and 20 Ibid, 41st Cong, 1st Sess, 170. 21 Ibid, 173. 22 Ibid, 41718. Page 300. Others and seemed to have little impact in the Senate as a whole. 23 The Senate, as in the previous session, passed the appropriation bill with its own amendments and returned it, as a challenge, to the House. 24. It was a challenge that the House eagerly accepted. Representative Henry L. Dawes, who, as chairman of the Appropriations Committee, directed the debate, was careful not to impugn the character of the members of the Peace Commission, but he charged them with extravagance in their provisions for Indian civilization and argued that if these provisions were approved, the United States would enter upon a policy in reference to the tribes of Indians from which it will then be too late to depart. However, we may be convinced hereafter that another and a different one would be more economical and equally just in keeping faith toward them and hastening on that day when they shall be self-reliant or semi-civilized and merge with the people of this common country under common laws. 25. Dawes's colleague from Massachusetts, Benjamin Butler, was one of the most vociferous in upholding the prerogatives of the House. He admitted that the House had no power in treaty making, but he insisted that it did in treaty ratifying. Furthermore, he challenged the power of the United States any longer to make treaties with Indians, who, he argued, had all been made citizens by the 14th Amendment. Can we make valid treaties, he asked rhetorically, with a portion of the people within our own jurisdiction? He ended with a dramatic appeal to the House, upon the question whether we will or will not stand up against these treaties. I hope the House will stand as firmly as the Rock of Ages, that we will never agree to them. Let war come, let anything come that may come, before we will agree to them, and begin again to perpetuate this vicious system of treaties with the Indians. 26. 23 Ibid, 42,122. 24 Ibid, 44,251. 25 Ibid, 557. For a discussion of Dawes's role in the Indian Treaty question as chairman of the Committee on Appropriations, see Fred H. Nicklason, The Early Career of Henry L. Dawes, 1816-1871, 36,672. 26 Ibid, 560, 561. Butler's interpretation of the effect of the 14th Amendment on Indian citizenship did not prove correct, and the Senate Committee on the Judiciary on December 14, 1870, reported its opinion that, because Indians were not under the jurisdiction of the United States, the amendment did not make them citizens, and that it follows that the treaties heretofore made between the United States and the Indian tribes are not annulled by the amendment. Senate Report No. 268, 41-3, Serial 1443. See the page 301. Meanwhile, the Indians who had signed the treaties were waiting for the goods promised them. Without an appropriation bill they would receive nothing. How could the impasse between the House and the Senate be broken or at least skirted for the time being? A compromise was offered by Dawes. He proposed a special appropriation of $2 million to allow the President to fulfill the new treaty obligations. Clark strongly protested, for such a stopgap measure did not end treaty making entirely, as he had proposed in his earlier amendment on March 19. When he urged correcting the evil once and for all by his amendment, Dawes countered that the Senate might reject the whole appropriation bill, leaving the Indian office in an impossible situation. 27 The compromise was accepted, and the bill as enacted said that there be appropriated the further sum of $2 million, or so much thereof as may be necessary, to enable the President to maintain the peace among and with the various tribes, bands, and parties of Indians, and to promote civilization among said Indians, bring them, where practicable, upon reservations, relieve their necessities, and encourage their efforts at self-support. But a proviso was added by the House and accepted by the Senate that nothing in the bill could be construed to ratify or approve the 186,768 treaties. Added, too, was the provision for the Board of Indian Commissioners to aid the President in carrying out the Act. 28 The temporary relief, however, merely postponed settlement of the issue that so violently divided the House and the Senate. In February 1870 the House turned to the new Indian Appropriation Bill, this one for the year ending June 30, 1871, and the whole drama was played out again. By then President Grant had become worried about the lack of appropriations to carry out ratified treaties, and he sent to the Senate a forceful report by Secretary of the Interior Jacob D. Cox, dated March 7, 1870, which pointed to problems on the discussion in Francis Paul Prucha, The Great Father, the United States Government and the Indians, 2 volumes, 2:68284. 27 Congressional Globe, 41st Cong, 1st Sess, 559, 56,364. Clark was explicit, however, in supporting old treaty obligations. The amendment I propose does not in any way interfere with any treaty which has been made and ratified up to the present time. It proposes that hereafter no treaty shall be made. 2816 Stat 40. Dawes strongly defended the Conference Committee report. Congressional Globe, 41st Cong, 1st Sess, 64,749. Page 302. Frontiers caused by congressional debate and action that called into question the validity of the treaties of the Indian Peace Commission and by extension of all treaties with the Indians. The resulting uncertainty, Cox said, has produced a general disorganization, white frontiersmen and the settlers denying the rights of Indians under treaties, on the one hand, and the Indians themselves upbraiding us with our breach of faith, and becoming dangerously unquiet, on the other. He pleaded for action that would uphold the provisions of the treaties and enable the Indian Office to inspire the Indian tribes with the belief that the strictest good faith would be kept with them. Cox did note, however, that no new treaties had been negotiated during the past year except those previously ordered by Congress, and that every effort has been made to prepare the Indians for a policy in which government of the tribes by law and in accordance with contracts to be made under a system of general legislation by Congress, shall be substituted for the existing condition of things, in which treaties have been made with them as if with foreign powers. But he worried that such a change in policy would not succeed with the Indians unless all existing agreements were faithfully kept. 29. House opposition to the treaty system as a whole was reinforced by the first report of the Board of Indian Commissioners, which urged the end of treaty making and the abrogation of existing treaties if a just method could be devised. Representative Clark referred explicitly to the report and declared that whereas he had previously held the sanctity of existing treaties, he was now beginning to see that the time will come in the progress of our Indian affairs, under the carrying out of an improved and liberal and just policy, when it will be necessary, not only in the interest of this government, not only for financial considerations, but in the interest of the Indians themselves, to abrogate, to a certain extent at least, the Indian treaties already existing. Then he offered again his amendment to end further treaty making and was again ruled out of order. In the same debate, Representative Aaron A. Sargent of California spoke strongly about the evil of repudiating treaties already ratified, but he suggested pre-rating annuities downward for tribes that had declined in numbers since the treaties were made. Representative William Lawrence of Ohio argued that with or without Clark's declaration prohibiting future treaties, in fact conditions were such that no more Indian treaties would be made, and he was gratified. He said that 29 Senate Ex. Document number 57, 41-2, serial 1406. Page 303. The President had recently withdrawn treaties pending before the Senate. The only strong voice speaking out in favor of treaties was that of Representative Eugene M. Wilson of Minnesota, who protested against the disposition which seems to be manifested here, to overturn our whole policy for 80 years past in relation to Indian treaties. If Indians were treated like other citizens, he feared that they would be overwhelmed by unscrupulous white settlers and speculators, and he cited Worcester v. Georgia in support of the sanctity of Indian treaties. 30. The House enacted an appropriation bill, again without providing for funds specifically to fulfill the treaties at issue but substituting this typical statement for the various tribes. For this amount to be expended in such goods, provisions, and other articles as the President may from time to time determine, including insurance and transportation thereof, in instructing in agricultural and mechanical pursuits, in providing employees, educating children, procuring medicine and medical attendance, care for and support of the aged, sick, and infirm, for the helpless orphans of said Indians, and in any other respect to promote their civilization, comfort, and improvement, $100,000. 31. It included its regular provision about not ratifying treaties still at issue. The Senate took out the general phrases and inserted specific provisions to carry out the treaties. The lower house responded to this action on June 29, 1870, by a long disquisition from Sargent, in which he reiterated the policy of the House regarding the Peace Commission's treaties. "My judgment," he said, "is that it is not wise, so far as the government is concerned, or for the Indians themselves, for us to yield our assent to the practice by which treaties are made and carried out. They open the door to frauds and corruptions without number. We must hereafter deal with the Indians by legislation and not by negotiations. It is a question, not of money, but of principle. I am prepared to recommend any reasonable appropriation to secure the peace with the Indians and save them from misery." He, in fact, urged larger appropriations than the House had made, for he realized that with the westward expansion of railroads and white settlement the Indians' hunting patterns had been inevitably disrupted. "We must restrain the Indians upon smaller reservations and 30 Congressional Globe, 41st Cong 2d Ses, 1579, 1580. 31 H.R. 1169, 41st Cong, Microfilm Publication of Bills and Resolutions, Library of Congress Photo Duplication Service, 1964. Page 304. Within smaller limits, we need to increase the amount of the appropriations which we make to feed the Indians and induce them to resort to agriculture as a means of livelihood." He reasserted his opinion that we cannot in any well-considered policy recognize the Indians as independent nations within our own midst. 32. It was clear that little by little the position of each house was hardening. There was less emphasis on Indian affairs and Indian policy in general and increasing weight given to the rights of the House and of the Senate in Indian treaty matters. Punctilio, in the minds of some of the members, seemed to outweigh all else. Garrett Davis of Kentucky was the most outspoken in the Senate as the debates resumed on July 14. "Why, sir," he cried, "the claim of the House is monstrous. What do the House propose to do? To expunge the treaty-making power as it is organized and vested by our Constitution, so far as it relates to all the Indian tribes. Shall they be countenanced or tolerated in this position of usurpation? Will the Senate submit to such an atrocious aggression upon their constitutional rights?" Senator Charles D. Drake of Missouri argued that a treaty ratified by the Senate was equivalent to an appropriation and needed no action from the House for the money to be withdrawn from the Treasury. That was his interpretation of a treaty as the supreme law of the land, and he did not propose, he said, to yield to the extraordinary, unprecedented, newfangled, and utterly indefensible position taken by the House of Representatives. 33. A conference committee was called, since neither house would agree to the other's amendments. But the conference committee, too, failed to reach agreement. At this point Dawes offered and the House passed a substitute for the appropriation bill, which would authorize a blanket grant of $5 million to enable the President to maintain the peace among the several tribes, bands, and parties of Indians, to pay the annuities of some, and to provide civilization among said Indians, and bring them where practicable upon reservations, relieve their necessities, and encourage their efforts at self-support. The Senate inserted its original appropriation bill for Dawes's bill. The House would not concur, so still another conference committee was appointed. 34. The time set for adjournment was now pressing upon Congress, and 32 Congressional Globe, 41st Cong, 2d Ses, 497,172. 33 Ibid, 5,586. 558,889. Drake's views, of course, were repudiated by the House. Ibid, 5,638. 34 Ibid, 5,589, 5,607, 560,910. Page 305. President Grant on the last day of the session personally urged the two houses to pass an Indian appropriation bill before adjourning, postponing the time of adjournment if need be. Without such appropriation, the President said, Indian hostilities are sure to ensue, and with them suffering, loss of life, and expenditures vast as compared with the amount asked for. 35. In the confusion of the last day, the House agreed to recede from disagreement with Senate amendments and to accept a proviso that read, that nothing in this act contained, or in any of the provisions thereof, shall be so construed as to ratify, approve, or disaffirm any treaty made with said tribes, bands, or parties of Indians since the 20th of July, 1867, or affirm or disaffirm any of the powers of the Executive and Senate over the subject. In this form the bill was passed and signed. 36 Representative Sargent, at the beginning of the next session, explained apologetically to the House that the Conference Committee, of which he had been a member, had accepted the form that was less emphatic in expressing the opinion of the House, in that it said the law would neither affirm nor disaffirm the validity of the treaties instead of insisting that it would not affirm, ratify, or countenance them. The slip, he said, was due to the weary closing hours of the last session, and the committee had not wanted another impasse that would necessitate the extension of the session or the calling of a special session in order to provide funds for the Indians. 37. Final action. On January 4, 1871, Sargent reported a new bill for Indian appropriations and for fulfilling so-called treaty stipulation for the year ending June 30, 1872.38. The debate in the House moved along smoothly enough in consideration of particular items in the bill, with some consideration of the nature of the government's Indian policy. Dawes spoke ardently for a change in that policy, one that would ensure 35 Senate Ex. Document number 115, 41-2, serial 1407. 36 Congressional Globe, 41st Cong, 2d Sess, 5625, 5663. Through clerical error, the disclaimer was omitted from the Act. To correct the mistake, the clause was added to the Appropriation Act for 1872. C16 STAT 570. 37 Congressional Globe, 41st Cong, 3d Sess, 763. 38 Ibid, 307. Page 306. Peace. In a foreshadowing of his later role as the proponent in the Senate of allotment of Indian lands in Severaltei, he declared that the policy for the future should be one of planting the Indian upon the soil in Severaltei, giving him an idea of the rights of property, of Miamiti Tuum, and all the associations which gather around the few acres that are his and all that is associated with the name of home. There was no specific reference to the question of treaty making until January 26. Then, when the last particular tribal item, that for the Yankton Indians, was read, Representative Lawrence immediately moved to add what was becoming the standard proviso, that nothing in this act contained shall be construed to ratify any of the so-called treaties entered into with any tribe, band, or party of Indians since the July 20, 1867. This at once triggered new discussion of the treaty-making issue. Some, like Dawes, thought such an amendment, similar to past disclaimers, would merely postpone a solution. Others debated again the two sides of the question, and Sargent had another opportunity to express his views. Now, I admit the treaty-making power with foreign nations, he said. But I deny that there can be such nations on our own soil. Are simply the wards of the government, to whom we furnish means of existence, and not independent nations with whom we are to treat as our equals. Ought not that fact to be admitted? Has not the comedy of treaties, potentates, nations, been played long enough? Is it not played out? 39. Defenders of the Indians and their treaties were not yet ready to admit defeat, but they weakened on the question of making future treaties. Wilson of Minnesota renewed his support for existing treaties. When we have treated with some poor, weak, miserable tribe, shall we refuse to make good our promises because they were incompetent to make a better bargain? We, at least, he said, were of full age. Will gentlemen tell us to repudiate our contract because we were dealing with minors? His position was firm. I believe the Indians have a vested right under the treaties which have been made with them, and I do not think we can interfere with those rights. But his concern was for treaties already ratified. I should like to see a future policy adopted in which no treaties should be made, he said. I think it would be better. But this propriety for the future does not authorize us to repudiate the past. Representative Joseph S. Smith of Oregon also defended the present. 39 Ibid, 73337, 763, 765. In the same debate, Representative Thomas Fitch of Nevada presented an extreme anti-Indian view that was not widely held. Ibid, 732. Page 307. Treaty system and move to strike out the words so-called before treaties in the amendment. A treaty made by the government of the United States, he argued, is just what a treaty is made by any other government, and when it is made in pursuance of our Constitution it binds every department of the government and the House of Representatives. The Supreme Court of the United States has sustained the treaties made by our treaty-making power with the Indian tribes ever since our government has had an existence. And it is too late to question their validity now. 40. But Lawrence's amendment to the Yankton Appropriation was in the end agreed to, and the bill with amendments passed the House on January 27.41. The bill was considered by the Senate in early February. When an amendment was offered to strike out so-called, Senator William M. Stewart, of Nevada, objected with a vigorous statement against treaties. I regard all these Indian treaties as a sham, and I want them to be spoken of as so-called treaties. The whole Indian policy of feeding drunken, worthless, vagabond Indians, giving them money to squander between them and their Indian agents, has been a growing disgrace to this country for years. Many of these treaties are made with irresponsible tribes or with no tribes at all. Many of the treaties continue to exist long after the Indians have ceased to exist, and continue for the sole benefit of speculators and peculiares. I think if we dignify them by calling them so-called treaties, that is going far enough. That phrase pleases the House. They are getting ashamed of these treaties, the country is getting ashamed of them. 42. But he gained no support for his diatribe against the treaties, and the words so-called were eliminated. After long debate over various provisions in the bill, an amended bill was passed 38-2 on February 23, with the offending words so-called removed from the title of the bill as well as the text. 43. The bill went back to the House, which refused to concur in the changes made by the Senate. Once more a conference committee was established. Both sides by this time must have been thoroughly tired of the issue, and the debates in both the House and the Senate indicated that a rough 40 Ibid, 766. 41 Ibid, 767, 790. 42 Ibid, 1112. 43 Ibid, 1480, 1600. Page 308. Consensus had been reached. The validity of past treaties was so strongly supported that it would have been impossible to pass a measure abrogating them in any way. The long history of treaty making, the decisions of the Supreme Court, and a strongly held conviction by many members that the faith and honor of the nation could be preserved only by upholding the stipulations and promises made in the treaties all contributed to this position. But the consensus, in the Senate as well as in the House, included the belief that no more treaties should be made with the Indians. This decision rested as much on the opinion that the tribes then existing did not constitute independent nations as on the adamant position the House took that treaty making eliminated it from essential participation in the regulation of Indian affairs. The conference committee worked successfully to a position that both sides would accept. The Senate in its consideration of the appropriation bill had eliminated Lawrence's amendment to the Yankton Clause concerning non-ratification of recent treaties. The House refused to concur in that change. As a compromise, the conference committee struck out Lawrence's words and substituted the final solution to the quarrel, the Great Compromise on treaty making, still clinging to the Yankton Appropriation. Provided, that hereafter no Indian nation or tribe within the territory of the United States shall be acknowledged or recognized as an independent nation, tribe, or power with whom the United States may contract by treaty, provided further, that nothing herein contained shall be construed to invalidate or impair the obligation of any treaty heretofore lawfully made and ratified with any such Indian nation or tribe. 44. The members of the conference committee then had to sell their decision to the two houses, and the reception of their report tells us something of the mood of each house. The House of Representatives rejoiced. Representative Sargent, reporting on March 1 the action of the conference committee, noted that the contest which has now proceeded for some 5 or 6 years over the question whether the 44 Ibid. 1810. The wording of this clause was taken from a separate resolution, offered in the House on February 11, 1871, by William H. Armstrong of Pennsylvania, on which no action had been taken at the time. Congressional Globe, 41st Cong, 3d Sess. 1154. Sargent, as a member of the conference committee, acknowledged the debt of the committee to Armstrong's earlier resolution. Ibid. 1811. Page 309. Senate had the right, or should continue to exercise the power, to make treaties with scattered bands of Indians within our own territory has been yielded by the Senate. The report was a matter of congratulation for the House, he said. It will save millions of money to the Treasury. It breaks up a most improvident system, and admits the right of the House of Representatives to deal with these questions by legislation. Some members questioned Sargent about whether the final version of the bill ratified any treaties, and Sargent insisted that there is not a word of ratification of any treaty in the bill. But he also declared that appropriations were made to fulfill stipulations of ratified treaties. It would be bad taste, he remarked, and I think bad faith to refuse to appropriate under treaties heretofore made, and the House will never take that position. Representative James B. Beck of Kentucky, who had also been a member of the conference committee, said that the House had gained almost everything that it had a right to expect. Representative Lawrence regarded the action as the grandest triumph, for the past 10 years, in the interest of the people, and in the interest of the power of the popular branch of the Congress over this subject. He adverted to the fact that Indian lands could no longer be disposed of by treaties contrary to the public land laws, and pointed to the economy in the management of Indian tribes that would result once the extravagant demands made by treaties were no longer possible. 45. Representative William H. Armstrong of Pennsylvania, who had provided the wording for the clause in an independent resolution he had introduced on February 11, however, stressed the point that the constitutional treaty-making authority of the President and the Senate had been left intact. What had been done had been to determine that Indian tribes were no longer fit subjects for the exercise of that power. In the future, he said, our dealings with them will be as mere domestic communities, with whom we may contract, but only with the approval of Congress. They will be contracts, not treaties. But he noted that this did not affect past treaties, and he spoke of the propriety in the distinct reaffirmation of our adherence to all our treaty obligations. Thereupon the House approved the conference committee report. 46. The reaction of the Senate, of course, was considerably less enthusiastic than that of the House of Representatives. Senator Davis Conton. 45 Ibid. 181,112. 46 Ibid. 1812. Page 310. You'd to object to ending treaty making with Indian tribes, pointing to the well-organized tribes in Indian Territory to refute the derogatory statements made by the House about the character of existing tribes, and he objected strongly to the vicious and most reprehensible practice of engrafting substantive legislation onto an appropriation bill. Senator Samuel C. Pomeroy of Kansas objected to the sort of toadyism to the House of Representatives that he viewed the conference report as representing. 47. But supporters of the report, chiefly Senators Harlan of Iowa and John P. Stockton of New Jersey, both of whom had been members of the conference committee, managed to quiet whatever objections the majority of senators might have had. They insisted that the bill did not limit the prerogative of the President and Senate to make treaties with foreign nations, but simply declared that Indians' tribes were not to be treated as foreigners. And they emphasized the proviso that nothing in the act was to be so construed as to invalidate any Indian treaty already ratified. So the Senate, on March 1, following the pattern of the House, approved the conference committee report without a roll call. The bill was enrolled, and President Grant signed it on March 3, 1871, as the 41st Congress expired. 48. It was a momentous act, but the change in Indian policy that it brought was neither as sudden nor as complete as its advocates had hoped for at the time, and as many historians and other students of Indian affairs have assumed in our own day. The anomaly simply took a new twist. Tribes were no longer to be considered sovereign political entities with whom the federal government would make treaties, but at the same time the old treaties that recognized such sovereignty were still to be in effect. The history of Indian treaties, therefore, did not end in 1871. 47 Ibid, 1821, 1822. 48 Ibid, 182,325. The proviso appears in 16 Stat 567. There was little public attention paid to the measure. The New York Times reported briefly on the Senate debate over the conference report and noted its acceptance without a roll call vote. March 2, 1871, 5. Page 311. Chapter 13. Treaty Substitutes. Congress finally ended the making of formal treaties with Indian tribes, but it did not thereby solve the Indian problem. Rather, the legislative action of 1871 created new difficulties, which were clearly seen by Francis A. Walker, the gifted and perceptive statistician who, 9 months later, became Commissioner of Indian Affairs. Writing in the North American Review in April 1873, he excoriated Congress for removing the main vehicle for dealing with the Indian tribes. In abruptly terminating thus the long series of Indian treaties, he wrote, and forever closing the only course of procedures known for the adjustment of difficulties, and even for the administration of ordinary business, with Indian tribes, Congress provided no substitute, and up to the present time has neglected to prescribe the methods by which, after the abrogation of the national character of the Indians, either their internal matters or their relations with the general government are to be regulated. He noted that the Indian Trade and Intercourse Law of 1834 was largely predicated upon tribal organization and asserted that all the life and virtue of the act had been taken away. And he spoke of the unpardonable negligence of the national legislature in failing to provide a substitute for the time-honored policy which was destroyed by the Act of 1871. Congress in declaring that Indian tribes should no longer be acknowledged. 1 Francis A. Walker, The Indian Question, 1213, the book reprinted the North American Review article as Chapter 1. Page 312. Edged as independent political entities with whom the United States might contract by treaty, did not thereby end the tribal organization of the Indian communities. Some of the Indian treaties, notably the ones negotiated and ratified in 186,768, stipulated that any new cession of lands guaranteed to the tribes in the treaties would be valid only if approved by a specified majority of the adult males of the tribe, thereby necessitating new negotiations with the tribal authorities when additional cessions were desired by the United States. Although Indian policy reformers wanted to deal only with individual Indians as wards of the government, it proved impossible to destroy the tribes all at once or to avoid treating with the Indians on a tribal basis. The proviso in the Act of 1871 that honored previously ratified treaties, a clear example of the strong force of national honor and the obligations of past promises, gave the treaties and thereby the tribes a long time and, in our own day, an increasingly vital role. The solution to the awkward situation created by the anomaly in the law of 1871 was the use of treaty substitutes too. By means of bilateral agreements, negotiated with the tribes in the manner of treaties but ratified or confirmed by both houses of Congress, by unilateral statutes, which on occasion required formal consent of the tribes, and by executive orders, which became the dominant means of establishing and modifying the Indian reservations, the federal government carried on its dealings with the tribes to the end of the 19th century and well into the 20th. As time passed, in fact, the reservations upon which tribal existence depended, came to rest less on treaties than on the treaty substitutes. The 162 Indian reservations of 1890, for example, had been established in the following ways. By executive order. 56. By executive order under authority of Act of Congress. 6. By Act of Congress. 28. By treaty, with boundaries defined or enlarged by executive order. 15. By treaty or agreement and Act of Congress. 5. 2. I first became aware of the usefulness of this phrase in Charles F. Wilkinson, American Indians, Time and the Law, Native Societies in a Modern Constitutional Democracy, which discusses these substitutes briefly on pages 8, 6368, 100,103. Page 313. By unratified treaty. 1. By treaty or agreement. 51. A report in 1952 from the Commissioner of Indian Affairs indicated that out of a total of 42,785,935 acres of tribal trust land, only 9,471,081 acres had been established by treaty, while 23,043,439 acres had been set up by executive order. 3. Agreements. Agreements, at first the chief treaty substitutes, were a direct continuation of the treaty process, despite the constitutional differences. They began in 1872 with the Shoshones and continued until 1911, when the final agreement was made with a band of Southern Utes. Some of them were specifically directed and authorized by Congress, others were negotiated by the Indian Office to solve particular needs, still others resulted from Indian initiative. Most of the agreements concerned cession of land or other modifications of reservation boundaries, but other purposes were also operative. The precise nature and processes of the agreements can be seen in the examples discussed below. 4. The system of agreements began, ironically, with a series of councils held with Western tribes by Felix R. Bruno, President of the Board of Indian Commissioners, who had been appointed to that task by the Secretary of the Interior. Bruno apparently set aside the principles he had enunciated so vehemently in the first report of the board in 1869 that the treaty system was an egregious mistake and that the Indians should be dealt with simply as wards of the nation and, with Thomas Cree, Secretary of the Board of Indian Commissioners, went first to the eastern band of Shoshones in Wyoming. There, in September 1872 he negotiated with them what he called Articles of Convention 5. Because the treaty with the Shoshones and Bannocks at Fort Bridger, concluded by the United States Indian Peace Commission in 1868, had stipulated that any cession be approved by at least a majority of the adult male Indians, the convention was careful to note that Bruno had dealt with the chief, headmen, and men of the eastern band of Shoshone Indians, constituting a majority of all the adult male Indians of said band or tribe of Indians, and duly authorized to act in the premises. The Bruno Agreement specified that this convention or agreement is made subject to the approval of the President and the ratification or rejection by the Congress of the United States. It had elements of a real treaty negotiation and was not simply a convention imposed upon the Indians by the government. Bruno's instructions were to effect an exchange of lands, but the Shoshones considered the lands to be received in exchange as worthless and subject to the incursions of other tribes. In the end, they agreed instead to sell outright the land that the government sought to free the part of the reservation into which miners had moved and made improvements. Bruno convinced the Indians to part with the land in return for $25,000, to be spent for stock cattle, plus a salary of $500 a year for 5 years to Chief Washakie. Bruno, however, was embarrassed by the Indians' acceptance of his first offer for the land. Acting upon my experience of the general habit of Indians, he reported to the Secretary of the Interior, the Shoshones were offered a sum as the basis of further negotiation, and which I supposed would have to be increased to meet the demands of the Indians. When the terms first offered were promptly accepted, I did not feel at liberty to make an addition. Instead, he asked that Congress appropriate an extra $10,000 to build houses for the Indians, an action Congress failed to take. 6. Next, in August 1873, joined now by Eliphalet Whittlesey of the Board of Indian Commissioners, and James Wright, the Crow agent, Bruno signed articles of convention with the Crow Indians at the Crow Agency in Montana. The men, appointed by the Secretary of the Interior as commissioners under congressional authorization of March 3, 1873, persuaded the Crows to agree to give up their reservation along the 5 Kapler, 1:15355. 618 STATPT 3, 29,192, Kapler, 1:15355, Bruno to Columbus Delano, October 18, 1872, in CIAAR, 1872, Serial 1560, pages 50,911. The agreement was ratified on December 15, 1874. Page 315. Yellowstone River in southern Montana and accept in its place a new reservation in the Judith Basin to the north. Bruno justified the removal on the grounds that the Crows would be moving away from the railroad and to a place better suited to their needs. But the people of Montana were delighted that one of the finest valleys in the West would be open to white settlement. The Crows, however, ultimately refused to move and Congress did not ratify the agreement. 7. Finally, Bruno signed an agreement in September 1873 with the Utes under Chief Ouray. Congress on April 23, 1872, had authorized the Secretary of the Interior to negotiate with the Utes for cession of part of the reservation set up for them in 1868, and commissioners had unsuccessfully tried to make a deal with the Indians in 1872. Bruno, who attended that council as an observer, not as an official commissioner, learned that the chief's son had been captured by Cheyennes and Arapahoes some 15 years earlier, and he and Thomas Cree were able to locate the boy and reunite him with his father in the offices of the Board of Indian Commissioners in Washington, D.C. The next year, when Bruno and another member of the Board of Indian Commissioners, Nathan Bishop, were appointed to try again to negotiate with the Utes, the kindness to Ouray paid handsome dividends. The chief's gratitude, Bruno's biographer wrote, did what a special commission could not do, and when Mr. Bruno told him he thought it right for him to sell a portion of his reservation, Ouray threw all his strong influence in favor of the sale, though a year before he intended opposition to the bitter end. The Utes ceded the southern half of their reservation in southwestern Colorado for a sum of money that would produce $25,000 a year plus a lifetime annual salary of $1,000 for Ouray. 8 There was little or nothing in the Bruno Articles of Convention to distinguish them from earlier treaties except the provision in the 7. The agreement is printed in Kapler, 4:114245. It is discussed in Charles Louis Slattery, Felix Reville Bruno, 18201898, a civilian in the War for the Union, President of the First Board of Indian Commissioners, 20,713, and in CIAAR, 1873, Serial 1601, pages 48,186, which also includes a narrative of the proceedings and a report of the Council, August 11-16, 1873. The authorization of the agreement is in 17 Stat 626. 8 Slattery, Bruno, 19,192, 21,415. The story of Uray's lost son is told in Anne Woodbury Haffen, Efforts to Recover the Stolen Son of Chief Uray, Colorado Magazine 16, 5362. The agreement was ratified on April 29, 1874. 18 STATPT 3, 3641, Kapler, 1:15152. See also Bruno's report and the council proceedings in CIAAR, 1873, serial 1601, pages 45181. Bishop did not appear for the negotiations, which were handled by Bruno and Cree. Page 316. Agreements that they were subject to ratification or rejection by Congress, and perhaps the reputation Bruno had for humanitarian interest in Indian welfare. Bruno's term, Articles of Convention, did not take hold, nor was the word contract used, even though it had been clear in the minds of the congressmen who debated the issue of treaties that they were talking about contracts between the federal government and the tribal authorities. It became official usage to refer to the results of the post-1871 negotiations as agreements. Yet, just as it was impossible to eliminate the procedures and substance that had marked the earlier treaties, so it seemed impossible to end the use of the word treaty. In the minds of many Indians and government officials alike, the new agreements were still treaties. The House document that printed a letter from Secretary of the Interior Columbus Delano in 1874 urging ratification of Bruno's convention with the Shoshones was entitled Treaty with the Shoshone and Bannock Indians. In 1876, responding to agitation for cession of the Black Hills, the legislature of Minnesota asked Congress to provide for a treaty with the Indians occupying the Black Hills. An 1888 House document requesting an investigation of the Pratt Commission was called Sioux Indian Treaty, and in 1891 the report of the House Committee on Indian Affairs relative to new negotiations with the Crow Indians used the word treaty throughout. A final example is the agreement negotiated with the Yankton Sioux on December 31, 1892. When ratification was delayed, the chiefs and headmen who had signed the Treaty of December 31, 1892, petitioned the government for ratification. The title of the pertinent House document consistently called the agreement a treaty. 9. A number of the agreements were negotiated as a result of the government's desire under pressure from advancing white settlers and miners to reduce the reservations set up by the Indian Peace Commission's treaties of 1867 and 1868. Of special concern was the Great Sioux Reserve, stretching from the Missouri River to the western boundary of Dakota, established by the Treaty of Fort Laramie. Since Article 12 of that treaty stipulated that any cession required approval of at least 3/4 of all the adult male Indians, it was necessary to begin a 9 House X. Document number 61, 43-1, serial 1607, House Miscellaneous. Document number 95, 44-1, serial 1701, 19 STAT 45, House Miscellaneous. Document number 576, 50-1, serial 2570, House Report number 3751-2, serial 2887, House X. Document number 80, 53-2, serial 3223. Page 317. Process of formal negotiations with the tribes. The first attempt was a full-scale negotiation between a council of the interested tribes and a commission headed by Senator William B. Allison of Iowa. Held near the Red Cloud Agency, the council was a failure. The commission was not clear about whether it was seeking a leasing of the Black Hills for use of miners or an outright cession, and the Indians demanded more for a sale than the commission would agree to. The commission ended its report with the recommendation that Congress should simply fix a fair price for the Black Hills and present the matter to the Indians as a finality. 10. After the Indians defeated Custer in June 1876 and while the Army was still pursuing the hostiles, Congress decided on an ultimatum to the Sioux. It ruled that the Indians would receive no more subsistence unless they relinquished the lands wanted by the whites, including the Black Hills. A new commission, headed by a former Commissioner of Indian Affairs, George W. Moneypenny, was appointed to take the message to the Indians and get their signatures on the agreement. Meeting at the Red Cloud Agency and at other agencies in September and October 1876, Moneypenny got the Indians' XS, but he ignored the requirement of approval by 3/4 of the adult males. The agreement, like the Indian Peace Commission treaties of a decade earlier, was replete with provisions for artisans to aid the Indians' move towards civilization and with pledges by the Indians to observe each and all of the stipulations herein contained, to select allotments of land as soon as possible after their removal to their permanent home, and to use their best efforts to learn to cultivate the same. 11. Similarly, commissions were sent out to treat with the Crows in 1880 for a cession of land and allotments in Severalty, to replace in part the unratified agreement made by Felix Bruno 7 years earlier, again in 1881 to obtain a right-of-way for the Northern Pacific Railroad, and 10C report of the commission appointed to treat with the Sioux Indians for the relinquishment of the Black Hills, in CIAAR, 1875, Serial 1680, pages 686,702. A full account of the Allison Commission's work is given in James C. Olson, Red Cloud and the Sioux Problem, Chapter 11. 11. The report of the Commission, December 18, 1876, is in Senate Ex. Document number 944-2, Serial 1718, which also includes the Journal of Proceedings. There is an account in Olson, Red Cloud, 22,430. The agreement was ratified by Congress on February 28, 1877. 19 Stat 15,464, Kapler, 1:16873. There is extended discussion of this agreement in relation to Sioux claims to the Black Hills in Edward Lazarus, Black Hills, White Justice, the Sioux Nation versus the United States, 1775 to the present, see Index under Treaty of 1876. Page 318. Still again in 1890 for a further reduction of the reservation and the opening of surplus lands to white settlement. 12 The 1890 agreement was modified by an agreement in August 1892, and 7 years later still another agreement for reduction of the Crow Reserve was signed. 13 The negotiations were authorized in general or in particular by Congress, and the documents specified that they would take effect only when ratified by Congress. The agreements were careful to state that a majority of adult male Indians had participated in the signing of the agreements. They were, for all practical purposes, except in method of ratification, treaties changing the provisions of the Treaty of Fort Laramie made with the Crows in 1868. For the tribes in the Indian Territory, who required special attention, 2 Blue Ribbon Commissions were appointed late in the 19th century to negotiate agreements. The first of these, originally called the Cherokee Commission, was appointed to negotiate with the Cherokee Indians and with all other Indians owning or claiming lands lying west of the 96th degree of longitude in the Indian Territory for the cession to the United States of all their title, claim, or interest of every kind or character in and to such lands. Lands ceded would become part of the public domain and be open to homesteading or other disposition under the public land laws. 14. After an initial failure to negotiate successfully with the Cherokees for the Cherokee Outlet, the commission was reconstituted in January 1890 with David H. Jerome, former governor of Michigan, as chairman. The new commission, henceforth known generally as the Jerome Commission, began its work in May 1890 and by November 23, 1892, had signed 11 agreements with Iowas, Sacs and Foxes, the citizen band of Potawatomi, absentee Shawnees, Cheyennes and Arapahoes, Wichitas and affiliated bands, Kickapoos, Tonkawas, Cherokees, Comanches, Kiowas and Apaches, and Pawnees. These Indians, by and large, opposed land cessions, but the commission persisted, sometimes threatening that if the Indians did not 12 See Appendix C, Agreements NOS 9, 11, 29. 13. The agreements appear in Kepler, 1:45053N, and 3:8797. 4. Comparable agreements with Shoshone and Bannock Indians, see Appendix C, Agreements NOS 8, 10, 19, 49, 54, 69. 1425 STAT 10056. The history of the Cherokee Commission is told in Berlin B. Chapman, The Cherokee Commission, 1889-1893, Indian Magazine of History 42, 17790, and in a series by the same author in Chronicles of Oklahoma, September 1937, June 1938, March 1939, December 1941, and Winter 194,849. Page 319. Accept the terms, they would ultimately get less. In the end, the Indians parted with more than 15 million acres. The agreements commonly provided a 160-acre allotment in severalty for each Indian on the tribal rolls, and the surplus land was bought by the government for white homesteading. The sale of the Cherokee outlet for more than $8.5 million was the largest transaction. When the outlet was opened to settlement on September 16, 1893, 100,000 persons rushed in to locate homesteads. 15. The second group sent to Indian Territory was the Commission to the 5 Civilized Tribes. The main thrust of American Indian policy at the end of the 19th century was the allotment of the reservations in severalty, an intensified drive to individualize the land holdings of the Indians as a means of assimilation into white society. The General Allotment Act of 1887 was the culmination of this drive, but the 5 civilized tribes were specifically excluded from the law, and humanitarian reformers and government officials persisted in their attempts to bring those Indians, too, under the allotment policy. The legislation of March 3, 1893, that authorized the Dawes Commission directed the Commission, first, to procure the allotment of lands for each of the tribes and, second, to arrange the cession to the United States of any lands not needed for allotments. But the Commission was given broad powers to negotiate the agreements, with the final goal of enabling the ultimate creation of a territory of the United States with a view to the admission of the same as a state in the Union. 16. The Indians at first refused to negotiate concerning any of the proposals made to them, but after heavy pressure from Indian reformers and government officials, they succumbed. In April 1897 the Dawes Commission signed the Atoka Agreement with the Choctaws and Chickasaws. Agreements were made with the 15. The agreements were ratified by Congress at different times between February 13, 1891, and June 6, 1900. See Appendix C, Agreements NOS 2428, 3134, 36, 39. Details on each of the agreements are given in Grant Foreman, A History of Oklahoma 24453. A discussion of the Jerome Commission agreements in the perspective of their effect on the collapse of the treaty system is given below, pages 35,052. 1627 STAT 64546. The work of the Dawes Commission can be followed in 2 articles by Lauren N. Brown, The Dawes Commission, Chronicles of Oklahoma 9, 70105, and The Establishment of the Dawes Commission for Indian Territory, Ibid 18, 17181. Official reports and related documents are in the Annual Report of the Commission to the 5 Civilized Tribes, 18941-905. Page 320. Creeks in September of that year, with the Seminoles in October 1899, and finally with the Cherokees in April 1900. Congress ratified and approved them at various dates between June 1898 and June 1902.17. The agreements of the Jerome and Dawes Commissions were used to carry out the increasingly strong commitment of the United States to its policy of allotment and tribal dissolution. The tribes agreed in the end because they realized that they had no other choice, even though in form an agreement looked like a treaty negotiated between competent political entities with a quid pro quo, signatures of the agreeing parties, and ratification by Congress. Other agreements of less national moment, but significant enough for the tribes involved, were negotiated not by specially appointed commissions but by Indian inspectors. The office of inspector had been established by Congress in 1873 to provide experienced men to act as troubleshooters for the Commissioner of Indian Affairs and the Secretary of the Interior. In dealing with tribes to settle some past difficulty, to arrange for removals, or to obtain land cessions, the government regularly used the inspectors as the official federal commissioners authorized to draw up a formal agreement. The task of these men was not so much to negotiate, although that term was commonly used, as to convince the Indians to accept the government's proposals and also to make sure that the Indians got as good a deal as possible given the political and economic pressures that arose. There were from 3 to 5 inspectors at any one time, and beginning in 1880 special agents were appointed who acted much like inspectors. 18 Thus Inspector Robert S. Gardner negotiated an agreement with the Yakimas in 1885 and one with the Shoshones and Bannocks in 1887. In 1896 Inspector Province McCormick negotiated with the Indians of the San Carlos Reservation. And Special Agent John Lane signed agreements with the Yakimas and with the Coeur d'Alenes in 1894.19. The work of these men, however, was greatly overshadowed by that of James McLaughlin, a longtime agent highly respected by the Indians. 17 See Appendix C, Agreements NOS 5153, 5860, 6768. The part played by these agreements in the collapse of the treaty system is discussed below, pages 35355. 18 A brief account of the inspectors appears in Francis Paul Prucha, The Great Father, the United States Government and the American Indians, 2 volumes, 1:58993. See also Paul Stewart, The Indian Office, Growth and Development of an American Institution, 1865190, Chaps. 68. 19 See Appendix C, Agreements NOS 14, 19, 4445, 48. Page 321. Who was appointed Indian Inspector in 1895.20? McLaughlin was a realist who unabashedly argued that the Indians should be forced to stand on their own in American society, but he strove to get justice for them and was able to convince the tribes he dealt with that he was getting them the best bargain possible. He spoke in his autobiography, first published in 1910, about his work in modern treaty making and declared, "Treaty making with the Indians has been my business very generally since my appointment as inspector. I have made all the treaties or agreements, as they are designated now, legally with 2 exceptions, that have been entered into in the past 13 years. 21. 10 of McLaughlin's treaties were formally ratified, with the text of the agreements printed in the statutes at large. But they were only a portion of his work with the tribes, with whom he often made agreements that did not go through the formal agreement procedures. McLaughlin found the Indians shrewder in diplomacy than might be expected by those who judge of their capacity from the manner in which they have been deprived of their native riches, but he admitted that the proposals all came from the government and that his work was to convince the Indians to accept them, a work in which he was eminently successful, by his own account, a fact that he attributed to merely a matter of being familiar with the Indian character. 22. Although most of the post-1871 agreements dealt with land cession, allotment, or opening up surplus lands for white settlement, other ends also were sought. Agreements were made for railroad rights of way or 20. It is possible to follow McLaughlin's work in some detail because of the existence of published sources. He himself published an autobiography, My Friend the Indian, New ed., and there is a useful, although uncritical, biography by Lewis L. Fowler, James McLaughlin, The Man with an Indian Heart. Fowler has edited a 36-reel microfilm edition of McLaughlin's papers, Major James McLaughlin Papers, which includes papers of McLaughlin deposited at Assumption College and selected documents from the National Archives. The papers include council proceedings with some of the tribes. 21 My Friend the Indian, 291. McLaughlin wrote, there was a treaty-making commission that was organized in President Cleveland's last term, but the commission made only 2 treaties in the several years of its existence, one known as the Fort Hall Treaty, and the other with the Crows. See Appendix C, Agreements NOS 54 and 57 for this commission's work. 22 My Friend the Indian, 293, 312, and Chapter 17 Passim. See Appendix C for McLaughlin's agreements printed in the statutes at large. His own list is in My Friend the Indian, 295. McLaughlin's work was highly praised by George Burt Grinnell in his introduction to the 1926 edition of My Friend the Indian and by Fowler in James McLaughlin. It is clear that the government placed great confidence in him and in his role as treaty maker. Page 322. For leasing of lands. 23 In other cases agreements called for the commutation of perpetual annuity payments. 24 The formally ratified agreement with the Kansa Indians in 1902 was drawn up by the tribe and then presented to the government for approval. 25 On occasion Congress gave what amounted to prior ratification. Thus a specially appointed commission of 1,889 was directed to make agreements with Chippewas in Minnesota to consolidate on the White Earth and Red Lake reservations, with the provision that they must be assented to in writing by 2/3 of the male Indians over 18 years of age, and that they would take effect when approved by the President of the United States. 26. The procedures in agreement making followed a more or less standard form. Usually there was specific or general authorization by Congress for the Secretary of the Interior to negotiate with specified Indian tribes. The Secretary appointed a commissioner or commissioners to carry on the negotiations. What the United States hoped to gain from the agreement was set forth in instructions to the commissioners, together with the limits that the government placed on payments or other benefits to the Indians, although the federal negotiators were given a relatively free hand, and they sometimes had to depart from the strict letter of their instructions in order to get the Indians to agree. The commissioners in sending the signed agreement to the Indian office or the secretary also sent certificates that the agreement had been properly interpreted to the Indians and understood by them and that the requisite percentage of adult Indians had signed. Included also was a report by the commissioners explaining in detail the important elements in the negotiations and justifying their action. Often the minutes of the councils with the tribes were submitted as well. With this material in hand, the Commissioner of Indian Affairs reported at length to the Secretary with his recommendations for acceptance, rejection, or amendment. The Secretary in turn added his comments. In sum, 23C, for example, Appendix C, Agreements NOS 6, 41, 50. 24 IBID, Agreements NOS 7172. 25 IBID, Agreement Number 65. 2625 STAT 64246, the agreements and the statements of presidential approval are printed in House X. Document number 247, 51-1, serial 2747, pages 2766. Page 323. Cases: the executive officers requested a statement from the Attorney General's office about acceptability of the legal provisions and sometimes from the Commissioner of the General Land Office, who might set forth specific provisions for the cession and disposition of the land involved. Finally, there was a draft of a bill, which included the agreement, plus recommendations for implementing the agreement. When all this material was ready, the Secretary either sent the whole docket to the President to transmit to Congress, or he himself sent it directly to the House and the Senate. When received in the House or the Senate, the material was immediately referred to the Committee on Indian Affairs, which would report the bill, and then the agreement was ready for consideration by the full House. Whereas the action in the executive branch usually moved ahead expeditiously, that was not the case in Congress. Often there was considerable delay because of more pressing business or because conflicts of interest surfaced that made it difficult if not impossible to get congressional approval. Such delays were embarrassing to the executive branch, which in some cases repeatedly resubmitted the agreement, hoping for speedy action. It was difficult to explain to tribes who had granted rights of way to railroads, for example, why the railroads had already been built but the payments promised in the agreements had not been forthcoming. A number of agreements, in the end, were never ratified. Those that were ratified carried the statement that the agreement in question had been accepted, ratified, and confirmed and were printed in appropriate sequence in the statutes at large. Some were made part of the current Indian Appropriation Act, others were separate laws. In most cases the statutes included the full text of the agreement, but in others the actual agreement was only referred to and not printed. Point 27. The procedures, however, were not cut and dried, and irregularities sometimes made it difficult to determine whether an agreement had in fact been ratified by Congress. An illustrative instance is the agreement with the Indians of the Colville Reservation signed on May 9, 1891. A bill to ratify the agreement passed the House, but the Senate, arguing against Indian title because the lands being ceded had been established as a reservation by executive order, refused to approve it. A drastically amended bill dropped the text of the 1891 agreement and 27. In the latter cases the text of the agreements is entered in a footnote in Kapler. See Appendix C for the location of ratified agreements in the statutes at large and in Kapler. Page 324. Restored the pertinent lands to the public domain without mention of payment to the Indians. The Indians repeatedly claimed compensation for the lands given up, and the Commissioners of Indian Affairs and the Secretaries of the Interior supported their claim, insisting that the Indians had title to the land under Aboriginal rights. Ultimately, in 1906, Congress provided $1.5 million to carry into effect the agreement of May 9, 1891. Actual payment was made to the tribes over a 5-year period. Each of the appropriation acts referred to ratification of the agreement by the law of 1906. Finally, in 1975, the Supreme Court in Antoine v. Washington declared that there was no doubt that these statements ratified the 1891 agreement, but even if there were doubt, the canon of construction applied over a century and a half by this court is that the wording of treaties and statutes ratifying agreements with the Indians is not to be construed to their prejudice. It had been a long and roundabout road to the ratification of the Colville Agreement. Point 28. A glance at the list of ratified agreements will show that the agreement-making process died out shortly after the turn of the century. A large number of the agreements, as we have seen, concerned cession of lands that were in some sense protected by treaties, and after the passage of the General Allotment Act of 1887 agreements were used for the cession of the surplus lands that remained in a reservation after all the Indians there had received allotments. When the Supreme Court in Lone Wolf v. Hitchcock, January 5, 1903, declared that Congress had plenary authority over Indian affairs, that consent of the Indians was not always necessary to obtain cessions of land, and that Congress had the power to abrogate treaty provisions, the need of formal treaty-like agreements for the cession of Indian lands seemed to be obviated. Point 29. Only 5 ratified agreements were signed after Lone Wolf. 2 of these were a continuation of the old procedures. 2 others concerned commutation of annuities, not land cessions. And the final agreement Com. 28 agreement and related documents in Senate Ex. Document number 15, 52-1, serial 2892, 27 STAT 6264, 420 US 194,207. Senate Report number 2561, 59-1, serial 4905, pages 13,440, provides a historical account of the affair and strong support of the Indians' claims. 29 Lone Wolf v. Hitchcock, 187 US 553. Discussion of the Lone Wolf decision appears below, pages 35,556, 36,768. Page 325. plotted a process of negotiation that had begun in 1903 for the addition of ancient Indian ruins to Mesa Verde National Park 30. The sanctity of the stipulations in the agreements came ultimately to equal that of stipulations in the treaties. In determining the rights of Indians and their protection within Indian country, the means of establishing the Indian country by treaty or by agreement has been largely considered immaterial. 31 Similarly, the preemption of state law can rest on agreements and statutes as well as on treaties. Thus, for example, in Dick v. United States, the Supreme Court upheld the validity of an article in the 1893 agreement with the Nez Perce Indians that prohibited the introduction of intoxicating liquor for 25 years into lands ceded by the agreement, even though those lands were now part of the state of Idaho. It compared the case with United States v. 43 gallons of whiskey, in which a provision in the Treaty of 1863 with Chippewa Indians had made a similar prohibition. The court, in upholding the Nez Perce Agreement, declared that it was a valid regulation based upon the treaty-making power of the United States and upon the power of Congress to regulate commerce with those Indians. 32. The clearest and most direct recognition of the force of agreements, however, came on February 19, 1975, in Antoine v. Washington. 33 The case involved the taking of deer by Indians during the closed season in the state of Washington, and the Washington Supreme Court decided against the Indians on the basis that the land on which they had hunted had been set aside, not by treaty, but by the agreement of May 9, 1891. It argued, further, that the Supremacy Clause of the Constitution did not require state acquiescence in the 1891 agreement, which was merely a contract between the tribe and the federal government to which the state was not a party. The United States Supreme Court put both of these contentions to rest, as it overturned the state court's decision. It said that the end of treaty making in 1871 meant only that henceforth Indian relations would be governed by acts of Congress, not by treaty. The change, the decision declared, in no way affected Congress's plenary powers to 30 See Appendix C, Agreements NOS 6973. 31 See Felix S. Cohen's Handbook of Federal Indian Law, 1982 ed., 12728. 32 Dick v. United States, 208 U.S. 34059. 33 420 U.S. 194207. The case is discussed in Wilkinson, American Indians, Time and the Law, 6465. Page 326. Legislate on problems of Indians, including legislating the ratification of contracts of the executive branch with Indian tribes to which affected states were not parties. Once ratified by act of Congress, the provisions of the agreements become law, and like treaties, the supreme law of the land. 34. Statutes. It is difficult to draw an accurate line between agreements and other legislation by which Congress handled Indian affairs. After 1871 many statutes accomplished what before had been the subject matter of formal treaties. Indians were moved, lands changed hands, allotments were prescribed and implemented, provisions for civilization programs were enacted, and the list goes on and on. In a sense, Congress was both continuing the treaty system by means of negotiated agreements and dealing with the Indians by direct legislation as it did with white citizens of the United States. But there was a middle ground, as well, in laws that required Indian consent before they took effect, statutes lying between negotiated agreements and unilateral congressional action. Thus in 1881, Congress authorized the Secretary of the Interior, with the consent of the Oto and Missouri tribes of Indians, expressed in open council, to sell the remainder of the tribe's reservation in Kansas. With similar consent the Secretary could secure other reservation lands for the Indians, remove them to the new reservation, and spend a limited amount of money for their comfort and advancement in civilization. In 1889 it provided for the appraisal of certain lands within the Pipestone Indian Reservation in southwestern Minnesota and their sale at auction by the Secretary of the Interior. The act would take effect so soon as, and not until, a majority of the adult male Indians of the Yankton tribe of Sioux Indians consent. At the same time, Congress directed that the allotment provisions of the Dawes Act be extended to the lands of the United Peoria and Miami Indians of the Indian Territory. Taking language from 34-420 U.S. 2034. The court quoted with approval Choate v. Trapp, which declared that in the government's dealings with Indians, the construction, instead of being strict, is liberal. Doubtful expressions, instead of being resolved in favor of the United States, are to be resolved in favor of a weak and defenseless people, who are wards of the nation, and dependent wholly upon its protection and good faith. Page 327. Treaties. The statute declared that its provisions would not take effect until the consent thereto of each of said tribes separately shall have been signified by 3/4 of the adult male members thereof. The next year Congress authorized sale of timber on the Menominee Reservation, but it declared that the act would remain inoperative until full and satisfactory evidence shall have been placed on the files of the Office of the Commissioner of Indian Affairs that the sales of timber and the manner of disposing of the proceeds of same herein authorized have the sanction of the tribe, evidenced by orders of agreement taken in full council. And in 1899 a law provided for the sale of the surplus lands on the Potawatomi and Kickapoo reservations in Kansas, with the stipulation that there be obtained the consent of a majority of the chiefs, headmen and male adults, expressed in open council by each tribe. 35. A major case was the reduction of the Great Sioux Reserve in Dakota. The agreement of 1876 by which the United States acquired the Black Hills did not end the land hunger of the whites for Sioux land. In August 1882, at the urging of the Dakota delegate, Congress authorized further negotiations with the Sioux in order to change the existing treaties, and Secretary of the Interior Henry M. Teller appointed a committee headed by Newton Edmunds to deal with the Indians. 36 With an agreement prepared beforehand, the Edmunds Commission sought signatures from the various bands of Sioux, but the Indians were strongly opposed to any land cession and the Commission got very few signatures. When Edmunds nevertheless submitted the agreement to Teller and Teller forwarded it to Congress for ratification, strong opposition developed among the Indians and the newly formed Indian reform organizations, notably the Indian Rights Association. Their complaint was that the agreement did not have the approval of 3/4 of the adult male Indians, as required by the Treaty of Fort Laramie of 1868. Senator Dawes was able to block the measure, and an attempt to get more signatures failed. Dawes and other reformers objected to the illegal procedures of the Edmunds Commission, not to the idea of reducing the Great Sioux Reserve. Dawes himself submitted a bill, known as Dawes' Sioux Bill, to bring about the changes that were desired. The bill proposed to 3521 STAT 38,081, 25 STAT 100 and 1,215, 26 STAT 14,647, 30 STAT 909. 36 documents on the Edmunds Commission are in Senate Ex. Document number 70, 48-1, serial 2165. Page 328. Divide the large reservation into 5 separate reservations, with considerable surplus land to be made available for whites, and to set up a fund from the proceeds of the sale of land to promote Indian self-support and assimilation. After much delay, Congress finally passed the measure, and the President approved it on April 30, 1888. The bill, as was expected after the strong criticism of the work of Edmunds, stipulated that the act should take effect only after consent had been given by the different bands of Sioux as prescribed by the Treaty of Fort Laramie of 1868.37. A new commission headed by Richard Henry Pratt failed to get the Indians' acceptance, for the Indians were leery of signing anything and insisted, if land was to be sold, on a substantially higher price than Dawes' bill allowed. To break the impasse, Congress on March 2, 1889, passed a new bill that provided a more generous financial arrangement, and it authorized a new commission to deal with the Sioux. This commission, of which Major General George Crook was the most influential member, by working behind the scenes got 4,463 signatures out of the 5,678 eligible to vote. 38. Indian consent, however, gradually disappeared as a major element. Of key significance was the General Allotment Act of February 8, 1887, the most important law affecting Indian affairs after the ban on treaty making in 1871. It was the culmination of a long drive on the part of reformers and of the federal government to individualize Indian land tenure by allotting the tribally held reservation lands in small parcels to Indian families and individuals. The allotment provisions of the treaties negotiated by Commissioner of Indian Affairs Penny in the 1850s clearly foreshadowed the Dawes Act, but those provisions applied only to the specific tribes with whom the treaties were made. What the reformers wanted was a general allotment law that would give the government authority to divide up reservations into allotments and dispose of the surplus land without resorting to a new piece of legislation for each case. That is what the Dawes Act, at long last, provided. The House of Representatives wanted the law to require consent of a majority of the tribe before the law's provisions were applied, but in the struggle in Congress to get approval of the bill that 3725 STAT 94104. The story of the Sioux affair and of Dawes's measure is told in Francis Paul Prucha, American Indian Policy in Crisis, Christian Reformers and the Indian, 1865190, 17287. 3825 STAT 88899, 1002. For details on the Commission's work, see Senate Ex. Document number 51, 51-1, serial 2682. There is a good account in Olson, Red Cloud, 30619. Page 329. Provision was discarded, and the President was authorized, at his discretion, to survey reservations and allot the lands in severalty to the Indians residing on them. Here was clearly a treaty function affected by unilateral congressional legislation. 39. In the first decade of the 20th century, voluminous legislation increasingly affected all aspects of the Indians' lives. 40. Executive orders. The third class of treaty substitutes was executive orders issued by the President of the United States. Whereas Indian reservations had once been established by treaty or statute, new ones were now formed and old ones modified by executive order. 41. The status of such reservations was not as clear as that for reservations established by treaty or by statute, which had a constitutional basis or came from specific congressional authority. The authority allowing the President alone to reserve land from the public domain for exclusive Indian occupancy and use is difficult to pin down, for there was no general law authorizing the President to so act. The federal courts simply sustained the executive in these actions on the basis of a long-standing acquiescence on the part of Congress and the public. 42. 39. For information on early allotment provisions in treaties, see Paul W. Gates, Indian Allotments Preceding the Dawes Act, in the Frontier Challenge, Responses to the Trans-Mississippi West, ed. John G. Clark, 14170, and Cohen's Handbook of Federal Indian Law, 1982 ed., 98102. There are 67 treaties, laws, and agreements prior to the Dawes Act listed in Schedule of Treaties and Acts of Congress authorizing allotments of land in severalty, in Royce, Sessions, 64,547. The Dawes Act is in 24 Stat 38,891. For discussion of the law, see D.S. Otis, The Dawes Act and the Allotment of Indian Lands, edited and with an introduction by Francis Paul Prucha, and Prucha, Great Father, 2:65973. 40. See Part 7, The Nation's Wards, in Prucha, Great Father, 2:7599916. 41. The executive orders are printed in Kapler, 1:801936, 3:66791, 4:100153. They are available also in executive orders relating to Indian reservations, 1855192, which reprints 2 earlier government publications. The orders are arranged by states and then by reservations. It is difficult to follow them in chronological sequence. 42C Memorandum regarding the power of the President to set aside by proclamation or executive order public lands for Indian reservations and other public purposes, and the right of the President to revoke such order, in Kapler, 3:69295. Kapler prints opinions of the Attorney General, May 27, 1924, and of the Solicitor of the page 330. Thus the Supreme Court in 1868 rejected a contention that lands could be reserved from sale and set apart for public purposes only by a specific act of Congress. The court ruled, from an early period in the history of the government it has been the practice of the President to order, from time to time, as the exigencies of the public service required, parcels of land belonging to the United States to be reserved from sale and set apart for public uses. Moreover, acts of Congress often presumed that the authority existed. The Preemption Acts of 1830 and 1841, for example, declared that the right of preemption did not extend to any land, which is reserved from sale by act of Congress, or by order of the President, or to lands included in any reservation, by any treaty, law, or proclamation of the President of the United States. And the Dawes Act of 1887 similarly implied presidential authority when it specified that the allotment process would apply to Indians located upon any reservation created for their use, either by treaty stipulation or by virtue of an act of Congress or executive order setting apart the same for their use. 43. The use of executive orders to establish Indian reservations began even before the end of treaty making in 1871, but at first many such orders had a connection of some kind with a treaty or with an act of Congress. The first use of executive order to establish a reservation was in May 1855, when the President, in anticipation of a treaty with the Ottawa and Chippewa Indians, withdrew from the market certain townships in Isabella and Emmett counties, Michigan, for Indian use. Only part of these lands were reserved by the treaty, and the remainder were returned to the public domain in 1860.44. An executive order of September 25, 1855, formally withdrew lands for the use of the Ontonagon Band of Chippewas, as provided for by a treaty of the previous year. 45 In November of the Department of the Interior, March 6, 1926, on the matter. Ibid. 4:1056664. See also Wilkinson, American Indians, Time and the Law, 6567. 43 Memorandum, Kapler, 3:693, 4 Stat 421, 5 Stat 456, 24 Stat 388. 44 Order of May 14, 1855, Kapler, 1:84647. See details on the arrangement given in Royce, Sessions, 81011, under Treaty of July 31, 1855. 45 Order of September 25, 1855, Kapler, 1:84849. The treaty specified, the Ontonagon Band and that subdivision of the Law Point Band of which Buffalo is chief, may each select, on or near the lake shore, 4 sections of land, under the direction of the President, the boundaries of which shall be defined hereafter. Treaty of September 30, 1854, Ibid, 2:649. Page 331. Same year the President by executive order set aside a reservation for Klamath Indians along the Klamath River in California, a tract selected by the Indian Superintendent as one of 2 additional reserves authorized by Act of Congress. 46 On June 30, 1857, the President established the Grand Ronde Reservation for Indians of the Willamette Valley, in accordance with the Treaty of January 22, 1855, which allowed the Indians to remain within the limits of the country ceded, and on such temporary reserves as may be made for them by the Superintendent of Indian Affairs, until a suitable district of country shall be designated for their permanent home. 47. but the executive also acted independently of treaty or statute. Thus in 1864, President Lincoln established a reservation at the Bosque Redondo in New Mexico for Apache Indians, and in 1867 President Johnson established the Fort Hall Reservation for the Shoshone and Bannock Indians in Idaho. 48 After 1871, the use of executive orders to establish and modify Indian reservations increased tremendously. An order was the chief vehicle for the purpose, although agreements ratified by Congress and other acts of Congress continued to play a part. The executive order was a convenient instrument to use. An order could be easily changed and a new one substituted as occasion demanded. Many Indian reservation boundaries were frequently changed, and some seemed to be continually in flux. An example was the Mescalero Apache Reservation. After the futile attempt to settle these Indians at the Bosque Redondo in 1864, a new reservation at Fort Stanton was established in 1873. The Commissioner of Indian Affairs drew up the specifications and sent them through the Secretary of the Interior to the President. President Grant on May 29 issued the following order. It is hereby ordered that the tract of country above described be withheld from entry and settlement as public lands, and that the same be set apart as a 46 Order of November 16, 1855, Kapler, 1:81617, 10 Stat 699. 47 Kapler, 1:886, 2:665. 48 Orders of January 15, 1864, and June 14, 1867, Kapler, 1:83537, 870. Of the Fort Hall Reservation, Royce notes, this reserve was set apart in general terms for the Indians of southern Idaho, and many of the Shoshone and Bannocks established themselves thereon. Subsequently, by Treaty of July 3, 1868, with the Shoshone and Bannock, the President was authorized to set apart a reserve for the Bannock whenever they desired. It was therefore decided to accept the Fort Hall Reserve as the one contemplated by the treaty, and it was so done by Executive Order of July 30, 1869. See Treaty of July 3, 1868, in Kapler, 2:102024, Executive Order of July 30, 1869, Ibid, 1:83839. Page 332. Reservation for the Mescalero Apache Indians, as recommended by the Secretary of the Interior and Commissioner of Indian Affairs. 49. But this was just the beginning. In February 1874 Grant cancelled the order and substituted a new one with a new boundary specification, and the same action was repeated in 1875, 1882, and 1883. The 1882 and 1883 orders set the described land aside for the Mescaleros and such other Indians as the department may see fit to locate thereon. And in 1910 small holdings within the reservation were restored to the public domain. 50. Executive orders were not uniform in terminology or in scope. The commonest form set aside a designated area for a particular tribe for its use, or use and occupancy, or as a reservation. Some set land aside as an addition to an existing reservation. On the other hand, many orders restored previously reserved lands to the public domain, in some cases substituting new lands for a reservation or as an addition to an established reservation. In other cases land was withdrawn from the public domain for an indefinite period, to extend until some specified event occurred, or it was set aside vaguely for Indian purposes. Some orders designated the reservation for a specified tribe and for other Indians at the discretion of the Secretary of the Interior, as was the case with the Mescaleros. On occasion an Indian agent or superintendent, on his own authority, set land aside for a group of Indians and then sought confirmation of his action from his superiors. If the superiors concurred, the President issued an executive order. A reservation could also be created by administrative action prior to the issuance of an order, in which case the executive order simply gave formal sanction to the action. 51. At length, after the great use of orders reaching back to pre-Civil War days, Congress prohibited further executive orders for establishing or changing Indian reservations. First, a law of May 25, 1918, provided that no additional reservations should be created or existing reservations enlarged in Arizona or New Mexico, and in the following year Congress declared that hereafter no public lands of the United States shall be. 49 Kapler, 1:87071, the recommendations of the Secretary and the Commissioner are attached. 50 Kapler, 1:87173, 3:685. The changes in the reservation boundaries are shown in Royce, Sessions, Plate 45, Area NOS 643, 644, the original executive order reservation of 1873 is shown by a blue line. 51 Any reading of the executive orders will turn up such an array of examples. I follow here the list given in Cohen's Handbook of Federal Indian Law, 1982 ed., 49799, which includes citations of orders exemplifying each category. Page 333. Withdrawn by executive order, proclamation, or otherwise, for or as an Indian reservation except by act of Congress. In 1927 Congress prohibited the changing of boundaries on executive order reservations except by statute. 52. From time to time a question arose about the legal status of the executive order reservations. How secure was the Indian title to such land? In a series of cases the Supreme Court decided emphatically that such reservations were to be equated with reservations created by treaty or by statute. Thus in Spalding v. Chandler the court decided, when Indian reservations were created, either by treaty or executive order, the Indians held the land by the same character of title, to wit, the right to possess and occupy the lands for the uses and purposes designated. Over the years the Supreme Court knocked down attempts to deny or weaken Indian control of the lands in executive order reservations. In 1913 it decided that the Hoopa Valley Reservation, set aside by executive order, was Indian country for the purposes of criminal prosecutions. In 1963 it confirmed the reservation of water as well as of land by declaring that the executive order reservations concerned had been uniformly and universally treated as reservations by mapmakers, surveyors, and the public. The court said, "We can give but short shrift at this late date to the argument that the reservations either of land or water are invalid because they were originally set apart by the executive." And in 1982 the court ruled, the fact that the Jicarilla Apache Reservation was established by executive order rather than by treaty or statute does not affect our analysis. The tribe's sovereign power is not affected by the manner in which its reservation was created. 53. The treaty substitutes at first retained the idea of negotiation with the Indians or made other provision for Indian consent, actions clearly in accord with the long-standing principles upholding the faith and honor of the United States in dealing with Indians. But that position, especially as times changed after the turn of the century, was severely eroded. Meanwhile, paralleling the use of treaty substitutes and their decline was agitation against the principle of any negotiating with Indians that filled the decades following the prohibition of treaty making in 1871. 5240 STAT 570, 41 STAT 34, 44 STAT PT 2 1347. See the debate on the first law in Congressional Record, 58:73840. Executive orders continued to be used, primarily to extend the trust status of Indian lands. 53-160 U.S. 403, Donnelly v. United States, 228 U.S. 24378, Arizona v. California I, 373 U.S. 598, Marion v. Jicarilla Apache Tribe, 455 U.S. 134 N. Page 334. Chapter 14. The collapse of the treaty system. The debate in Congress over treaties and their appropriateness in the prevailing conditions of the United States following the Civil War was carried forward on a broad scale in the decades after 1871, even as the treaty substitutes came into play. The condemnation of the old treaties as anachronistic was met by firm and often emotional support of these treaties as sacred contracts that no honorable government could break. At first the supporters of the inviolability of treaties held their own against the treaties' critics, but little by little they were broken down, until by the closing years of the 19th century and the opening years of the 20th, reliance on existing treaties all but disappeared. It was not, however, a simple story of honest and faithful men and women fighting against the forces of selfishness and evil, for many righteous Christian reformers came to see in the treaties a hindrance and a block to the advancement of the Indians that they so zealously promoted. The dream of the reformers and their government allies was the destruction of everything that held the Indians distinct from the rest of American citizens, and the chief obstacle was tribalism in all its manifestations. Unless tribalism and its remnants were destroyed, they believed, there was little chance that the Indians as individuals could be completely absorbed into mainstream America. 1. In this chapter I have drawn to some extent on Francis Paul Prucha, the Great Father, the United States government and the American Indians, 2 volumes, especially chapter 29, Liquidating the Indian Territory. A. Page 335. There had long been agitation, of course, against treating with the Indians as independent nations. Criticism of treaty making from distinguished Americans had been an important force in the decision of Congress to end the process in 1871, and it seemed that the compromise reached no more treaties but confirmation of the inviolability of treaties already ratified would quiet the issue. But the anomaly of that situation almost immediately led to a new attack upon the treaties already in existence. Opposition to treaties at the end of the Civil War can be read not only as a cry to stop making new treaties but also as a condemnation of the past system and a proposal to abrogate existing treaties. These sentiments came to the fore again after 1871. Humanitarians concerned with the rights of the Indians were forced at first to insist that treaty rights be respected at all costs, and an emphasis on the faith and honor of the government in dealing with Indians never completely disappeared. A radical hindrance to the civilization of the Indians, Commissioner of Indian Affairs Edward P. Smith pointed out in 1873, was the anomalous relation of many of the Indian tribes to the government, which requires them to be treated as sovereign powers and wards at one and the same time. Smith proposed that so far, and as rapidly as possible, all recognition of Indians in any other relation than strictly as subjects of the government should cease. Smith was honest enough to admit, however, that to carry out his proposal would require radical legislation. 3 years later, his successor as commissioner, John Q. Smith, noted, "There is a very general and growing opinion that observance of the strict letter of treaties with Indians is in many cases at variance both with their own best interests and with sound public policy too." The economic expansion after the Civil War also brought new pressures against the land holdings of the Indians. To land-hungry whites and their representatives in Congress it appeared that Indians owned more land than they could profitably use, and railroad corporations, intent on crossing Indian reservations and seeking lands along their routes, added another powerful force to cut down or break up Indian reservations. What stood in the way of these promoters were the treaties. Valuable and provocative account of the deterioration of sovereignty after the Civil War in one of the tribes in the Indian Territory appears in William G. McLaughlin, After the Trail of Tears, The Cherokees' Struggle for Sovereignty, 1839-1880, Chaps. 1013 and Epilogue. 2 CIAAR, 1873, Serial 1601, p. 371, Ibid, 1876, Serial 1749, p. 389. Page 336. That guaranteed ownership of the soil to the Indians and a measure of self-government on those lands. Attempts to organize the Indian Territory. Much of the attention focused on the Indian Territory, where there was both a growing problem with treaties in the minds of whites and a firm defense of treaty rights by an articulate group of tribal leaders. Tension arose because of the drive to create a regular territorial government for the Indian Territory. After the Civil War, both Commissioner Dennis N. Cooley's stipulations to the defeated Indians of the 5 civilized tribes at Fort Smith in 1865 and the treaties signed with the tribes the next year in Washington, D.C., referred to a consolidated, confederated government in the Indian Territory, although the treaties of 1866 also reaffirmed and declared to be in full force the provisions of the earlier treaties entered into before the Indians joined the Confederacy. 3 Ely S. Parker, President. Grant's first Commissioner of Indian Affairs, in 1869 urged that the General Council spoken of in the Reconstruction Treaties be organized. The accomplishment of this much-desired object, he said, will give the Indians a feeling of security in the permanent possession of their homes, and tend greatly to advance them in all respects that constitute the character of an enlightened and civilized people. The next progressive step would be a territorial form of government, followed by their admission into the Union as a state. Congress, in July 1866, had provided conditional land grants to railroad corporations building lines through the Indian Territory. 10 or 20 alternate sections of land along the right-of-way were granted to the companies whenever the Indian title shall be extinguished by treaty or otherwise and the lands became part of the public domain. 5 The Indians were mortally afraid that any change in their governmental status or system of land tenure, by undercutting treaty protection of the lands, would be interpreted as fulfilling the conditions for these grants. There had been some proposals for legislation to provide territorial 3 for Cooley's demands, CCIAAR, 1865, Serial 1248, pages 48283. 4 treaty stipulations c, for example, the treaty with the Creeks, in Kapler, 2:93436. 4 CIAAR, 1869, Serial 1414, pages 45051. 514 STAT 238, 291, 294. Page 337. Organization for the Indian Territory in the late 1860s, but the concerted drive began with the resolution of Representative James R. McCormick of Missouri, from the Committee on the Territories, on January 13, 1870. The resolution sought an inquiry into the expediency of establishing a territorial government over the civilized Indians inhabiting that portion of the country known as the Indian Territory. The need adduced in the resolution for such territorial government was couched in reasonable and seemingly innocuous language, but each phrase cut deep into the cherished treaty rights of the Indians to communal land ownership and tribal self-government and brought consternation if not panic to tribal leaders in the Indian Territory. The resolution read in part: whereas the Cherokee and Choctaw Indians are a civilized people, following agricultural and manufacturing pursuits, governed by written laws and evincing other characteristics of capacity for self-government, and whereas in their tribal relations they hold their lands in common and not by individuals in fee simple, which circumstance leaves their land at any time subject to be disposed of by treaty, rendering uncertain their permanence, prosperity, and perpetuity, and whereas it is desirable to give to these people a government republican in form, to secure them individually in their right to lands, and to incorporate them with the citizens of the United States under a territorial form of government, thereby securing to them full protection as citizens of the United States and securing to them a more rapid development of their civilization and country. Point 6. In subsequent years numerous bills were introduced into both houses of Congress to establish a regular territorial government. Point 7. The tone of these measures can be seen in the support for a bill introduced on March 17, 1870, by Senator Benjamin F. Rice of Arkansas, for the organization of a Territory of Oklahoma. The Committee on the Territories, in reporting favorably on the bill, indicated the desire to destroy the separateness of the Indians. It is in consonance with the new policy of the government, born of the war and matured by the 15th Amendment, that no alien race shall exist upon our soil, all shall be citizens irrespective of race, color, or previous condition of servitude. It is a part. 6 House Miscellaneous. Document number 21, 41-2, serial 1431. 7. A list of the principal bills between 1865 and 1879 to organize the Indian Territory or otherwise extend federal jurisdiction over the area appears in Roy Gittinger, The Formation of the State of Oklahoma, 180319006, 26770. Page 338. Of the inexorable logic of the times that the Indian must adapt himself to the rights and duties of citizenship. 8. At the heart of the matter was the conviction that there were too few Indians on too much land, that if the Indians could be forced to work homesteads of their own, they would find their salvation and the rest of the land could be put into profitable production by white settlers. 9. Aside from the purported advantages to the Indians from territorial government, United States citizenship, and land in severalty, the advocates of territorial organization made much of what they considered the lawlessness of the Indian Territory. The Indian governments were criticized as ineffective, the courts as inadequate, the protection of the rights of whites and former slaves as almost completely lacking. What severely complicated the matter was the growing number of whites within the 5 civilized tribes, a great majority of whom were farmers and other laborers who had been invited in by the Indians to work. Since the tribal governments pertained to the Indians alone, the demand arose for an adequate means to protect the personal and property rights of these whites. 10. As the years passed and the white population continued to increase, the complaints grew. Secretary of the Interior Zachariah Chandler declared in 1876 that the necessity of devising some simple and satisfactory form of government for the Indian Territory was growing more and more urgent and soon had to be met. His Commissioner of Indian Affairs, John Q. Smith, was more outspoken. The anomalous form of government, if government it can be called, at present existing in the Indian Territory must soon be changed. He wrote, "The idea that that territory is to consist forever of a collection of little independent or semi-independent nationalities is preposterous." 11. Congressional pressures did not subside. The Senate, in February 1878, instructed its Committee on the Territories to ascertain whether a civil form of government could not be organized over the Indian Territory for the better protection of life and property and whether the lands held in common could not be divided in severalty without con. 8 Senate Report No. 131, 41-2, Serial 1409, p. 9. See statements of this view, for example, in Senate Report No. 336, 41-3, Serial 1443, Report of the Secretary of the Interior, 1871, in House X. Document No. 1, pt 5, 42-2, Serial 1505, pages 78. 10 Report of the Secretary of the Interior, 1873, in House X. Document No. 1, pt 5, 43-1, Serial 1601, px, ibid, 1874, House X. Document No. 1, pt 5, 43-2, Serial 1639, p. 14. 11 Report of the Secretary of the Interior, 1876, in House X. Document No. 1, pt 5, 44-2, Serial 1749, pages 7-8, CIAAR, 1876, Serial 1749, p. 390. Page 339. Firming the conditional grants of lands made to railroads. The committee took its charge seriously, sending members to the Indian Territory to interview inhabitants and collecting extensive historical documentation. It recommended the establishment within the territory of a United States court having criminal and civil jurisdiction, that the Indians should become citizens of the United States, and that they should have representation in Congress similar to that of other territories. It asserted that the lands could be divided in severalty without confirming the railroad grants, but it did not press the matter of individual allotment. 12. Use of treaty rights to oppose territorial organization. Despite the widespread feeling that changes in the Indian territory were necessary and in the face of powerful economic interests, all the legislative measures introduced in the late 1860s and the 1870s failed. The opponents of territorial organization in those years were able to forestall radical change. Foremost among these opponents were the Indians themselves, who spoke through their chiefs, their councils, and most especially through the special agents or delegates maintained in the national capital by each of the 5 civilized tribes to look after tribal interests and to lobby for the protection of Indian rights. 13 These astute spokesmen, countering each move toward territorial organization with forceful memorials to Congress protesting the action, had 2 lines of defense. First, they pointed to the protection of their lands and of their autonomy in their treaties with the United States, and, concomitantly, they relied upon the sense of fairness and honor of the legislators to prevent any violation of the stipulations of the treaties. 14. 12 Resolution of February 25, 1878, Senate Miscellaneous. Document number 77, 45-2, serial 1786, Senate Report number 744, 45-3, serial 1839. 13 The work of the delegates can be seen in Francis Paul Prucha, the Board of Indian Commissioners and the Delegates of the 5 Tribes, Chronicles of Oklahoma 56, 24,764, and Thomas M. Holm, the Cherokee Delegates and the Opposition to the Allotment of Indian Lands. See also W. David Baird, Peter Pitchlynn, Chief of the Choctaws, a biography of an important Choctaw delegate. 14 A convenient listing of memorials, together with other pertinent documents, is in Grant Foreman, A History of Oklahoma. Page 340. The agitation began after McCormick's resolution. Thoroughly alarmed, the delegates of the 5 civilized tribes began their campaign of memorials and protests to the President and to Congress. The Creek delegates wrote to President Grant on February 26, 1870. It is with painful anxiety we have witnessed the introduction into Congress and the discussion of measures which, if matured and acted upon, would unavoidably result ultimately in the ruin and extinction of our people. We are jealous of the smallest infraction of our treaties, knowing it would be taken advantage of and held as a precedent by those who are anxious to get our lands, that the breach would rapidly widen, till soon our treaties would be held sacred no longer. We cling to our treaties and hope for safety in the strength and good faith of the government. With the letter went an earlier statement from the principal chief of the Creeks, which made the same point. Creeks meeting in a convention at Okmulgee on February 10, 1870, sent along their own resolutions, insisting that their national character had been recognized and confirmed again and again by the highest laws known to political societies, namely, Treaties 15. The Cherokee chief Lewis Downey, in a like appeal that he and the Cherokee delegates submitted in March 1870, spoke out against the establishment of territorial government, the abrogation of treaties, and the forcing of United States citizenship upon the Indians, and he charged that all these various movements spring from a common source and look to a common nth extinguishment of our land titles. He cited specific treaties made with the Cherokees, which not only guaranteed the right of the soil but that the lands would be for the Indians a permanent home, a home that shall never in all future time be embarrassed by having extended around it or placed over it the jurisdiction of a territory or state, nor be pressed upon by the extension in any way of any of the limits of any existing territory or state. 16. The Choctaw delegate Peter Pitchlynn similarly sent a protest from his nation, dated March 17, 1870, it was a long and eloquent recitation. 36,366. See also Stephen L. Johnson, Guide to American Indian Documents in the Congressional Serial Set, 1817-1899. 15. The documents are in Senate Miscellaneous. Document number 76, 41-2, serial 1408. 16. Senate Miscellaneous. Document number 83, 41-2, serial 1408. The quotation, not quite exact, is from the Cherokee Treaty of May 6, 1828, in Kapler, 2:288. Page 341. Of treaty rights and a charge that railroad interests were seeking the Indians' lands at the expense of the broken faith on the part of the United States. He concluded, the said Choctaw Nation doth solemnly appeal to the sense of justice and honor of the Congress of the United States, sacredly to observe the faith of treaties and to guard and to preserve their guarantees and that of the Constitution which makes them the supreme law of the land. 17. When Senator Rice's bill was introduced and when the Senate Committee on the Territories reported favorably on it, asserting that it was in all material respects in conformity to the treaties with the Choctaw and Chickasaw, Creek, Seminole, and Cherokee Indian tribes, the Indian leaders renewed and stepped up their opposition. A memorial from Cherokee, Creek, and Choctaw delegates took issue with the Senate Committee's report and raised three legal questions. First, whether Congress has the constitutional right, in view of our status, treaties, and existing laws, to establish a territorial government over us. Second, whether we are citizens under the 14th Amendment to the Constitution. Third, whether the bill does not contain provisions violative of our treaty stipulations. We believe it to be wrong in principle on all these questions, and various others, the Indians said. The memorial detailed the provisions of specific treaties and how the bill would change or violate them. 18. In June 1870 the Ocmulgee Council, the representative body organized in response to the treaties of 1866, added its voice of protest. We ask nothing from the people and authorities of the United States aside from their respect and good fellowship, but what they have promised and observance of their treaties. 19. Bills for territorial organization continued to be introduced through the 1870s, and the Indians repeated their well-argued protests, pointing to the treaty provisions protecting their land and their government and relying on the honor and integrity of the American Congress and government. 20. 17 Senate Miscellaneous. Document number 90, 41-2, serial 1408, quotation on p12. 18 Senate Report number 131, 41-2, serial 1409, Senate Miscellaneous. Document number 143, 41-2, serial 1408. 19 Address of the Ocmulgee Council, June 4, 1870, in Senate Miscellaneous. Document number 154, 41-2, serial 1408. 20 The quotation is from a protest of December 6, 1873, from the Ocmulgee Council, in House Miscellaneous. Document number 88, 43-1, serial 1618. See also protest of January 20. Page 342. The congressional committees that favorably reported territorial bills were not unaware of the treaty argument made by the Indians. Nor were they prepared to argue for an out-and-out abrogation of the treaties. But they were convinced of the need for change in the Indian Territory and did not think treaties should hamper the government in doing what was needed. Thus Senator James W. Nye of Nevada, in reporting for the Committee on the Territories in February 1871, argued for the power of Congress to legislate for Indians, saying that Indians should not be treated differently from other citizens. He admitted that the Indians opposed the bill, but he did not think that fact should be given much weight. 21 More bills were introduced in the late 1870s, and the same arguments were advanced against them by the Indian delegates. 22. The Indians were not without support, for many persons agreed with their analysis of their existing treaty rights. Initially such support came from the Board of Indian Commissioners, when that body was established in 1869 as a watchdog for Indian rights and an aid in the formulation of a just Indian policy. It was at the board's annual winter meetings with representatives of missionary groups participating in Grant's peace policy that the Indians found a forum for presentation of their views on self-government and treaty rights. Beginning with the first meeting in January 1872 and extending into the early 1880s, Indian delegates were in attendance. 23. The pleas for protection of their rights made by the Indian delegates in 1872 were well received by the Board of Indian Commissioners. In its official report to the President of the United States in November 1872, the board declared, the convictions of the board that it is the imperative duty of the government to adhere to its treaty stipulations with the civilized tribes of the Indian Territory, and to protect them. 1874, In-House Miscellaneous. Document number 87, 43-1, serial 1618, Chickasaw Memorial of January 6, 1875, Senate Miscellaneous. Document number 34, 43-2, serial 1630, Cherokee Memorial of January 20, 1875, Senate Miscellaneous. Document number 66, 43-2, serial 1630, and Creek Memorial of January 26, 1875, Senate Miscellaneous. Document number 71, 43-2, serial 1630. 21 Senate Report number 336, 41-3, serial 1443. 22C Senate Miscellaneous. Document number 82, 45-2, serial 1786, House Miscellaneous. Document number 32, 45-2, serial 1815, Senate Miscellaneous. Document number 73, 45-3, serial 1833, House Miscellaneous. Document number 13, 46-1, serial 1876, and Senate Miscellaneous. Document number 41, 46-2, serial 1890. 23 For a detailed account of the relations of the Indian delegates with the Board of Indian Commissioners, see prucha, Board of Indian Commissioners and the delegates of the 5 tribes. Page 343. Against the attempts being made upon their country for the settlement of the whites, have undergone no change. Its supporting voice was strong. If national honor requires the observance of national obligations entered into with the strong, how much more with the weak? To repudiate, either directly or by any indirection, our solemn treaty obligations with this feeble people, would be dishonor, meriting the scorn of the civilized world. Again at the 1874 conference the Indian spokesmen boldly set forth their claims, emphasizing their treaty rights of self-government, and the board in its report for that year reconfirmed the position it had taken earlier. Point 24. When the personnel of the board changed with the en masse resignation of the members in 1874, however, the Indians lost support. The new membership on the board moved increasingly to a position that the Indian ways of government and land tenure should be ended and the detribalized individual Indians absorbed into American society. So they paid scant attention to the repeated representations made at their meetings by the delegates of the 5 tribes. They sided with those who sought to impose a regular territorial government on the Indian Territory, although they initially included the disclaimer not inconsistent with existing treaties. 25. The position of Congress. The Indians from the Indian Territory fared better in Congress than they did with the Board of Indian Commissioners. Although bills for territorial organization were introduced and received some vocal support, the measures did not, in fact, advance very far in Congress. Some bills were reported back from the committees to which they had been referred, but even these were eventually postponed or tabled, and many others never came out of committee. Not a single one of the many bills was ever passed by either house, and the few debates on the measures in the House of Representatives indicated. 24 Report of the Board of Indian Commissioners, 1872, p. 11, Ibid, 1873, pages 45, 21115. 25 Ibid, 1875, p. 14. Page 344. Strong support for the Indians' position. The Indian protests and memorials found their mark, and in the 1870s the 5 tribes won their battle. The initial sentiment in Congress for territorial organization faded away as committee reports upheld the Indians' rights. Thus a House Bill of 1872 for a new government in the Indian Territory elicited a strong minority report from the Committee on the Territories, which was a scorching condemnation of the measure. They do not think any such territory should be organized, because they do not believe such action would be nationally just or honorable, wise or expedient. It is neither just or honorable because the faith of the nation has been pledged many times over against the legislation contemplated by these bills. 50 solemn treaties made with these Indian tribes guarantee them their rights over and over again. The report cited the Treaty of May 6, 1828, with the Cherokees and the Treaty of August 7, 1856, with the Creeks and Seminoles. These and similar treaties of like import, it said, are in force and binding today. If there is any binding force in solemn guarantee and written covenant, in plighted faith and national honor, then we cannot, must not, establish this territory. The agitation from the measure, it insisted, came from railroad companies' intent of gaining the land grants that were contingent on extinction of Indian titles. 26. Later bills in the 1870s made little or no headway. In February 1875 a bill was adversely reported by the House Committee on Indian Affairs. The committee asked Congress to disapprove the bill and kindred bills, which would destroy or impair the nation's obligations to the Indians. The people of this great nation ought to know, and those of the Indian Territory ought to be reassured, the report said, that the Congress of the United States cannot and will not lend its sanction to any measure tarnishing the nation's honor, especially where its faith has been plighted by solemn guarantee and written covenant. No amount of sophistry should be permitted to mystify or divert the mind from this important feature of these bills, called by whatever name. Their operation will be the subversion of the Indian nationalities in the territory. The bill was tabled. 27. When the House Committee on the Territories in March 3, 1879. 26 House Report No. 89, 42-2, Serial 1543. See also the debate in Congressional Globe, 42 DCONG, 3 DCES, 61316, 65254. 27 House Report No. 151, 43-2, Serial 1659, P1, Congressional Record, 3:1313. Page 345. Reported on one of the final bills introduced for territorial organization, it recommended against passage. After a very long discussion of all sorts of historical materials and citation of treaties and laws, often on a tribe-by-tribe basis, the committee finally reached its conclusions. 1. That the bill under consideration conflicts with existing treaty stipulations. 2. That while the right to decide in the last resort that a treaty is no longer binding is undoubtedly lodged in Congress, the exercise of that right is a judicial act affecting the honor and dignity of the nation, requiring for its justification reasons which commend themselves to the principles of equity and good conscience, particularly where the parties to the compacts with the United States are weak and powerless and depend solely on the good faith of the government. 3. That no such reasons exist for violating the treaty stipulations which reserve the Indian Territory exclusively for Indians and which secure the right of self-government under the restrictions of the United States Constitution. 28. Thus ended the long attempt to find a solution to perceived problems among the 5 civilized tribes in the Indian Territory and to open up their lands for white settlement and development by organizing a regular territory. The argument of the tribes had won out, as the House Committee on the Territories candidly admitted in February 1890, when it reported a new kind of bill for a territory of Oklahoma that excluded the 5 tribes. The committee said that it would have recommended a measure which would have embraced within the boundaries of the territory of Oklahoma the whole of the Indian Territory had it not been for the fact that the 5 civilized tribes objected and cited treaty stipulations to sustain their objection. 29. Attacks on treaties in the 1880s and 1890s. The victory for treaty rights was short-lived, for the decades of the 1880s and 1890s brought new forces that undermined 28 House Report Number 188, 45-3, Serial 1867. The quotation is on p. 37. 29 House Report Number 66, 51-1, Serial 2807. Page 346. The nation status of the Indian tribes, their communal landholding, and other elements of tribal status that gave treaties their significance. A key element in the changed situation was the appearance in the early 1880s of new groups of reform-minded Christian men and women who took a special interest in Indians. The most important of these was the Indian Rights Association, founded by Herbert Welsh and Friends in 1882, which was supported by groups such as the National Women's Indian Association and the Boston Indian Citizenship Committee. Members of these groups, beginning in 1883, met each year in conjunction with a meeting of the Board of Indian Commissioners at Lake Mohonk, New York, hosted by the owner of a resort hotel, who was a member of the board. These annual Lake Mohonk conferences of Friends of the Indian were a focal point of agitation for a new drive to finally detribalize the Indians and absorb individual Indians into social and political life as patriotic American citizens. Point 30. The tribalism of the Indians, with communal land ownership and treaty rights that perpetuated a separation from the rest of American society, was anathema to these reformers. To be sure, they were high-minded Christians, and their initial posture toward Indian policy called for a firm adherence to the rights guaranteed to the Indians by treaties. The Constitution of the Indian Rights Association, for example, said, "The object of this association shall be to secure to the Indians of the United States the political and civil rights already guaranteed to them by treaty and statutes of the United States, and such as their civilization and circumstances may justify." And there was always a strong current of opinion in their meetings that treaty rights were sacred and could not be abrogated without Indian consent. Yet it became increasingly clear that treaty stipulations perpetuated tribalism and thus stood in the way of the full implementation of the reformers' program. Little by little the weight of the reform group's influence was shifted against upholding treaty rights. The most outspoken critic was the noted clergyman and reformer Lyman Abbott, editor of the Christian Union, who was a regular participant at the Lake Mohonk Conference and frequently a member of its platform committee. Abbott thought that the solution to 30. The work of these groups is recounted in Francis Paul Prucha, American Indian Policy in Crisis, Christian Reformers and the Indian, 1865190. Their writings are collected in Francis Paul Prucha, ed., Americanizing the American Indians, Writings by the Friends of the Indian 18801900. Page 347. The Indian problem lay in the complete annihilation of the reservation system, and he did not care if that meant violating treaties. In a passionate outburst at Lake Mohonk in 1885, he noted that he was speaking to Christian men and women, friends of humanity and friends of equal rights, and that not one of them would change, or alter, or break a treaty that he may be benefited by the breaking of it. But if we have made a bad contract, it is better broken than kept. It is not right to do a wrong thing, and if you have agreed to do a wrong thing, that agreement does not make it right. If we have made contracts the result of which, as shown by later experience, is inhumanity and degradation, we are not bound to go on with them, we are bound to stop. We have no right to do a wrong because we have covenanted to. When our fathers landed on these shores, there was no alternative but to make treaties with the Indians. It was necessary. We have now passed beyond the epoch in which it is right or necessary to make treaties, and have so officially declared. We can no longer be bound by our forefathers, we must adapt our policy to the change of circumstances. We evangelical ministers, he concluded, believe in immediate repentance. I hold to immediate repentance as a national duty. Cease to do evil, cease instantly, abruptly, immediately. 31. Most of Abbott's listeners, however, were not quite ready for immediate repentance, for they were committed to maintaining formal treaty rights. Even though Abbott served on the Resolutions Committee, he was unable to swing it to his way of thinking. The platform adopted was a compromise. It agreed to the principle of allotting the lands of the reservations in severalty, and it urged that negotiations be undertaken to modify existing treaties and that these negotiations should be pressed in every honorable way until the consent of the Indians be obtained. For the present the conference rejected the proposal to abrogate the treaties or to force land in severalty upon the Indians. 32. Yet the tide of opinion was flowing in Abbott's direction. In 1886 at Lake Mohonk, Philip C. Garrett, a Philadelphia lawyer and a member of the Executive Committee of the Indian Rights Association, spoke dramatically about destroying the distinctions between Indians and whites. But the treaties, he exclaimed, we are stopped again by the 31 Lake Mohonk Conference Proceedings, 1885, 5054. 32 Ibid, 49. Page 348. Existence of hundreds of alleged treaties, which imply the perpetual existence of the tribes, or contain some obligation unfulfilled. He did not, of course, want to commend the infraction of any treaty really contracted between two powers, but he questioned whether so-called treaties were really treaties and thus solemnly binding. If they were not real contracts between two consenting parties, and he presented examples that suggested they were not, then, for the sake of the Indians, they should be cast aside. He concluded, if an act of emancipation will buy them life, manhood, civilization, and Christianity, at the sacrifice of a few chieftains' feathers, a few worthless bits of parchment, the cohesion of the tribal relation, and the traditions of their race, then, in the name of all that is really worth having, let us shed the few tears necessary to embalm these relics of the past, and have done with them, and, with fraternal cordiality, let us welcome to the bosom of the nation this brother whom we have wronged. Long enough. 33. At the same meeting, Charles C. Painter, who served as the Indian Rights Association's agent in Washington, painted a grim history of a treaty system based on the self-interests of the whites, and he concluded, these treaties in many of their provisions constitute one of the greatest obstacles in the way of Indian civilization. 34. The chief wedges to break apart the old system were, in the minds of the reformers, the allotment of reservation land in severalty and the granting of citizenship to the Indians. By this breaking up of tribal landholding and of tribal political authority over the individual, the system perpetuated by the treaties could be destroyed. In the early years of the Indian Rights Association and the Lake Mohonk Conference, allotment was foremost in the mind of the reformers, until at last they got what they wanted in the Dawes Act of 1887, a general allotment law, which authorized the President to break up the reservations without the consent of the Indians and which declared the allotted Indians to be citizens of the United States. 35. The sentiments of the reformers were well represented in Congress. 33 Ibid, 1886, pages 1011. 34 Ibid, 19. 35 There is a discussion of agitation for allotment and of the Dawes Act in Prucha, American Indian Policy in Crisis, Chapter 8. See also D.S. Otis, The Dawes Act and the Allotment of Indian Lands, ed. Francis Paul Prucha, and Wilcom E. Washburn, The Assault on Indian Tribalism, The General Allotment Law of 1887. Page 349. Perhaps the most outspoken critic of treaties there was Senator Henry M. Teller of Colorado, who had served as Secretary of the Interior from 1882 to 1885 and was considered especially knowledgeable on Indian affairs. During debate in January 1886 on a bill to divide the Great Sioux Reserve in Dakota, he said he would abrogate every Indian treaty we have ever made and simply legislate for the best interests of the Indians. He argued that many treaties were impossible to execute and had to be continually violated, it would be better to abrogate them altogether, and he did not doubt that Congress had the power to do so. 36. American Law for the Indians. While debate continued on the sanctity of treaties, the United States moved to bring the Indians, to some extent at least, within the web of American law. Indian police, as an extension of the Indian agent's authority, were appointed on the reservations to keep order, and so-called courts of Indian offenses, with Indian judges, augmented the policeman's work. These institutions worked within the tribal/reservation system. 37 Not so the extension of federal criminal jurisdiction over Indians by the Major Crimes Act of 1885. The law was the reformers' answer to the Supreme Court decision in Ex parte Crow Dog, in which the court overturned the murder conviction of Crow Dog, a Sioux Indian who had killed Spotted Tail, because federal criminal laws did not apply to crimes of Indian against Indian on the reservations. By the act, 7 crimes were made federal offenses, a heavy blow against the Indians' autonomy in their internal affairs. In 1886 the Supreme Court, in United States v. Kagama, upheld the act as within the competency of Congress. These Indian tribes are the wards of the nation. They are communities dependent on the United States. Dependent largely for their daily food. Dependent for their political rights. From their very weakness and helplessness, so largely due to the course of dealing of the federal government with them and the treaties in which it has. 36 Congressional Record, 17:81213, 947. 37 The fullest account of these institutions is William T. Hagan, Indian Police and Judges, Experiments in Acculturation and Control. Page 350. Been promised, there arises the duty of protection, and with it the power. 38. Some persons, most notably Professor James Bradley Thayer of the Harvard Law School, wanted a full-blown system of courts for the Indians to bring them as individuals under American law. It mattered little to Thayer whether or not the Indians wanted to abandon tribal relations, the United States could simply ignore the tribes and deal directly with the individuals. Thayer had support from the Law Committee of the Indian Rights Association and from the American Bar Association, but in the end he failed to get congressional authorization for his campaign, in large part because Senator Henry L. Dawes, relying on the citizenship provisions of the Dawes Act, fought the measure as unnecessary. 39. The Jerome Commission. As might be expected, affairs in the Indian Territory caught the attention of the new reformers. Whites who sought an inroad into the Indian lands, having failed to open them through establishment of a regular territorial government, now sought to open particular sections that were free of Indian settlement. The first focus was on the Oklahoma District, a central area of 2 million acres, purchased from the 5 civilized tribes but never assigned to other Indians. So-called boomers moved into the area unbidden, only to be removed by federal troops. The action was repeated over and over again until at last in 1889 President Benjamin Harrison proclaimed the region open to homesteading and whites poured in the first of the Oklahoma land runs. Congress, a year later, in the Oklahoma Organic Act, provided territorial government for the region and joined to it the largely uninhabited public lands in the Oklahoma Panhandle. This Oklahoma Territory did not touch the 5 civilized tribes. 40. The acquisition of surplus Indian lands for white homesteading was accomplished by the Jerome and Dawes Commissions. Although these specially appointed groups played a prominent role in signing formal 3823 STAT 385, 118 U.S. 38,384. 39 For a discussion of Thayer's work, see Prucha, American Indian Policy in Crisis, 33,541. 40 Ibid, 38,486, and the references cited there. Page 351. Agreements with the Indians as a continuation, in a sense, of treaty making, they were also key elements in the steady weakening of Indian tribal governments and therefore the influence of treaties in Indian life. They were instruments in the movement to end tribalism that so strongly marked the last years of the 19th century. The Jerome Commission turned its attention to the Cherokee Outlet and to the surplus lands of the Cheyenne and Arapaho, Comanche, Kiowa, Apache, and other Indian tribes in the western part of the Indian Territory. These lands were acquired with little trouble, for most of the Indians were convinced that change was inevitable. The Iowa tribe, with whom the Commission signed its first agreement on May 20, 1890, comprised only 86 members, and the commissioners found no well-organized government. They spoke of the very limited extent of the Iowas' real title and interest in and to said tract of country, which had been set aside for them by an executive order in 1883. The Sac and Fox Indians were described as progressive and prepared for allotment, and they made no appeal to treaty rights. For the Cheyenne and Arapaho Indians, who held their land under the Treaty of Medicine Lodge Creek of 1867, the commissioners managed to get signatures of 3/4 of the adult males as prescribed by that treaty. The Tonkawas, who had moved in 1885 from the Iowa Reservation to land in the Cherokee Outlet vacated by the Nez Perces, in the opinion of the commission did not have any rights at all to the surplus lands remaining after the tribal members were allotted. The sum to be paid them was to be fixed on the basis of the necessities of the situation and the destitute condition of the Indians. For most of these Indians, allotments had already been made, which were merely confirmed by the agreement. The Wichita Indians and affiliated tribes at first objected to taking lands in Severaltevy and having whites move in among them, but they ultimately capitulated to the commission. Their title is possessory only, the commission reported. They do not have a treaty or even an agreement with the United States, that it shall be their country. 41. There were complications arising from treaties in which the Choctaws and Chickasaws had reversion claims if the lands assigned to certain of the tribes were given up as surplus after allotments had been made, and there were possible treaty rights of Iowas and Sacs and Foxes not living in the Indian Territory to funds that might be paid for the surplus acres. 41 Senate Ex. Document number 171, 51-1, serial 2688, IBID number 172, 51-1, serial 2688, IBID number 1, 51-2, serial 2818, IBID number 13, 52-1, serial 2892, IBID number 14, 52-1, serial 2892. Page 352. The commissioners and the Department of Interior officials urged Congress to consider the claims, and various adjustments were made. But in the case of Indians who had not been assigned their reservations by treaty, with clear stipulations about alienation of the land, the power of Congress to dispose of Indian lands was strongly argued. Cited to back up these arguments were United States v. Kagama and the Cherokee tobacco case, a decision of the Supreme Court in 1870, in which an 1868 tobacco and liquor excise law was upheld against Cherokees despite a provision in the Cherokees Treaty of 1866 that said the Cherokees should have the right to market their products within their territory without restraint. In the Cherokee case, the court held, a treaty may supersede a prior act of Congress, and an act of Congress may supersede a prior treaty. In the cases referred to, these principles were applied to treaties with foreign nations. Treaties with Indian nations within the jurisdiction of the United States, whatever considerations of humanity and good faith may be involved and require their faithful observance, cannot be more obligatory. They have no higher sanctity, and no greater inviolability or immunity from legislative invasion can be claimed for them. 42. The most significant of the Jerome Commission agreements was signed October 21, 1892, with the Kiowas, Comanches, and Apaches. It tested the power of the federal government to dispose of Indian lands without appropriate consent of the tribe, and it was the basis for the Lone Wolf case of 1903, discussed below. All 11 agreements were signed and ratified by Congress. Where applicable, the commissioners had made an attempt to recognize treaty rights and the nationhood of the negotiating Indians. Yet the result was the individualization of the Indian lands through allotment and thus the effective destruction of the tribal base. As areas were opened, they were organized as counties and incorporated into Oklahoma Territory. 43. 4211 Wallace 621. For examples of the arguments, see letter of Secretary of the Interior John W. Noble to the President, June 27, 1890, in Senate Ex. Document number 171, 51-1, serial 2688, p. 5, letter of Assistant Attorney General George H. Shields to Secretary of the Interior, June 23, 1890, in Senate X. Document number 172, 51-1, serial 2688, p. 13. 43 details on each of the agreements are provided in Foreman, History of Oklahoma 14453. References to the published agreements are in Appendix C, Agreements NOS 2428, 3134, 36, 39. Page 353. The Dawes Commission and the Curtis Act. The problems of the 5 civilized tribes pointed to in the 1870s were much on the minds of government officials and of the Lake Mohonk Indian reformers. Commissioner of Indian Affairs John D. C. Atkins in 1885 inveighed against the political status of the Indian Territory. The idea of maintaining permanently an imperium in imperio, such as now exists, must, in some respects be abandoned, he wrote in his annual report. The idea of Indian nationality is fast melting away, and the more intelligent Indians are themselves awaking to that fact. In a word, the Indians in the Indian Territory must sooner or later break up their tribal relations, take their lands in severalty, and to all intents and purposes become citizens of the United States, and be amenable to its laws, as well as enjoy all of its high and distinguished privileges. And the next year he called attention to what he considered unconscionable land monopolies held by a few Indians. Of one land holding he exclaimed, "What a baronial estate! In theory the lands are held in common under the tribal relation, and are equally owned by each member of the tribe, but in point of fact they are simply held in the grasping hand of moneyed monopolists and powerful and influential leaders and politicians, who pay no rental to the other members of the tribe." And he asked, are these the sacred rights secured by treaty, which the United States are pledged to respect and defend? 44. The Dawes Commission was supposed to address and solve these problems. But, because the Indians of the 5 tribes were not receptive to the work of the Commission, its attempts at negotiations in the first year came to nothing. The conditions that the Dawes Commission faced were those that had long agitated the reformers, and they were emphasized anew in the report of a special Senate committee under Senator Teller, sent to investigate the situation. The reports of both groups depicted a crisis resulting from the great influx of whites into the territory and from the monopolization of land by a few individuals. The reformers at Lake Mohonk, in response to criticism that the Dawes Commission 44 CIAAR, 1885, Serial 2379, p. 13, Ibid, 1886, Serial 2467, pages 8184. The Commissioner's arguments in 1886 were supported by Secretary of the Interior L.Q.C. Lamar, Ibid, 1921. Page 354. Aimed to violate the treaty rights of the tribes, sent a special agent of their own, Charles F. Meserve, to study the conditions, and Meserve agreed wholeheartedly with Dawes and Teller. 45. These men and their supporters set the argument about violation of treaties on its head. They insisted that the government must act without consent of the Indians, for the tribes themselves had destroyed the force of the treaties by admitting whites to tribal citizenship under their laws and by inviting white people to come within their jurisdiction. The Indian lands were to have been held in trust for all Indians, but monopolists had broken the trust. After a second year of ineffective negotiations, the Dawes Committee asserted that the tribal governments were wholly corrupt, irresponsible, and unworthy to be longer trusted, and that the promises of self-government made in the treaties were no longer binding. 46. At Lake Mohonk, where he appeared regularly to report on his work in the Indian Territory, Dawes asserted that his commission asked for the violation of no treaty obligations, however questionable might have been the power to enter by treaty into any such relation. They asked that these treaty stipulations be enforced. The old reformer Bishop Whipple wanted it known that the Indians had forfeited their old treaty rights by taking the side of the Confederacy during the Civil War, and that after the war they had been received back into friendship under quite different conditions. Familiar as I am with Indian wrongs, he concluded, I have never had my heart more deeply stirred than in listening to Senator Dawes and to Mr. Meserve, and from my heart I can only say, God be praised for raising up such men to do his work. 47. Congress heeded the messages proclaimed by Dawes, Teller, and the other reformers. In June 1896 it directed the Dawes Commission to make out rolls of Indian citizens in preparation for allotment and declared it to be the duty of the United States to establish a government in the Indian Territory which will rectify the many inequalities and discriminations now existing. 48. Under this mandate the Dawes Commission moved rapidly toward the dissolution of the 5 civilized tribes, concluding agreements with all the tribes between 1897 and 45. Annual Report of the Commission to the 5 Civilized Tribes, 1894, Report of Select Committee on the 5 Civilized Tribes, May 7, 1894, Senate Report No. 377, 53-2, Serial 3183, Report of the Indian Rights Association, 1896, p. 9, Charles F. Meserve, the Dawes Commission and the 5 Civilized Tribes of Indian Territory. 46. Senate Report No. 377, 53-2, Serial 3183, Annual Report of the Commission to the 5 Civilized Tribes, 1894, 17, 20, Ibid, 1895, 20. 47. Lake Mohonk Conference Proceedings, 1896, 54, 57. 4829 STAT 33940. Page 355. 1902 The Curtis Act of June 28, 1898, abolished tribal laws and tribal courts and brought all persons in the Indian Territory, regardless of race, under United States authority. The act, entitled An Act for the Protection of the People of the Indian Territory, and for other purposes, was unilateral action by the United States that signaled the end of the tribal governments. It was practically an organic act for the establishment of the long-sought territorial government. 49. The Lone Wolf Case. Treaty rights came into full play during the negotiations and in the long subsequent history of the 1892 agreement with the Kiowas, Comanches, and Apaches that ended only with a Supreme Court decision in 1903. These tribes held their lands under the Treaty of Medicine Lodge Creek, and the Indians pointedly presented a copy of the treaty to the commissioners at the beginning of the negotiations. They noted that the benefits promised by the treaty still had 4 more years to run, and they adamantly opposed negotiating before then. They pointed, also, to the desperate conditions of the Cheyennes and Arapahoes, who had recently accepted allotments. Nevertheless, the commissioners persisted, and at least superficially adhered to the 3/4 approval stipulations of the 1867 Treaty. 50. Almost immediately, however, protests from the Indian leaders arose. They claimed that the provisions of the agreement had been misrepresented to them by the interpreters, that they had been subjected to threats, and that in fact 3/4 of the adult males had not signed. Such key federal officials as Secretary of the Interior C.N. Bliss, Secretary of the Interior Ethan Allen Hitchcock, and Commissioner of Indian Affairs William A. Jones agreed with the Indians and urged Congress not to ratify the agreement as presented. The Indian Office, in response to a 4930 STAT 495,519. A system of federal courts had already been gradually extended over the Indian Territory, see discussion in Prucha, American Indian Policy in Crisis, 39,091. 50. A recent and full account of the agreement and its subsequent history is given in N. Lacker Eston, Lone Wolf v. Hitchcock, The Long Shadow, in the Aggressions of Civilization, Federal Indian Policy since the 1880s, ed. Sandra L. Cadwallader and Vine Deloria, Jr., 21545. Page 356. Senate Resolution, presented evidence in January 1899 that the actual number of male Indians in the tribes in 1892 had been 639 who were 21 years of age or over and 725 who were 18 years of age and over, and that the number signing thus actually fell below the required 3/4. Congress, nevertheless, ratified the agreement on June 6, 1900, influenced no doubt by the insistence of whites in the region that the reservation be opened. 51. The Kiowa chief Lone Wolf and other Kiowas then resorted to the courts. With legal help from William M. Springer, former representative from Illinois and federal judge in the Indian Territory, and from the Indian Rights Association, the Indians took their case to the Supreme Court. On January 5, 1903, the court in the landmark decision, Lone Wolf v. Hitchcock, decided against the Indians and asserted the plenary authority of Congress over Indian relations and its power to pass laws abrogating treaty stipulations. The contention in effect ignores the status of the contracting Indians and the relation of dependency they bore and continue to bear towards the government of the United States. To uphold the claim would be to adjudge that the indirect operation of the treaty was to materially limit and qualify the controlling authority of Congress in respect to the care and protection of the Indians. The power exists to abrogate the provisions of an Indian treaty, though presumably such power will be exercised only when circumstances arise which will not only justify the government in disregarding the stipulations of the treaty, but may demand, in the interest of the country and the Indians themselves, that it should do so. The court said that it must presume that Congress acted in perfect good faith in the dealings with the Indians of which complaint is made, and it denied that the Indians had been deprived of their property. There had been a mere change in the form of investment of Indian tribal property, from land to money. 52. After the Lone Wolf decision, the idea of requiring Indian consent for the disposition of their lands was largely discarded in regard to statutes. 51. The Indians' protests of October 20, 1893, and January 15, 1900, are in Senate Miscellaneous. Document number 102, 53-2, serial 3167, and Senate document number 76, 56-1, serial 3850. For support from federal officials, see Senate document number 77, 55-3, serial 3731, pages 12, and Senate document number 76, 56-1, serial 3850. The calculation of numbers of adult male Indians is in Senate document number 84, 55-3, serial 3731. 52-187 U.S. 56,368. The case is discussed in Report of the Indian Rights Association, 1903, 2024. Page 357. As well as to agreements, and Congress unilaterally provided for the sale of surplus lands remaining after allotments had been completed. An early and notable example was the disposition in 1904 of a portion of the Rosebud Sioux Reservation in South Dakota. On September 14, 1901, the Sioux had signed a formal agreement with Indian Inspector James McLaughlin for sale of the unallotted lands for $1,040,000, and McLaughlin acquired signatures of the required 3/4 of the adult male Indians. But between the signing of the agreement in 1901 and its amendment and ratification in 1904, a new situation had developed, and the bill submitted for ratification of the agreement eliminated the direct payment by the government for ceded lands and substituted a new procedure whereby the lands were paid for by settlers at specified prices, which were reduced as time passed, with the money received deposited in the treasury for the benefit of the Indians. There was no provision for getting Indian approval of the new arrangements. 53. This elimination of Indian consent was consciously done. The House Committee on Indian Affairs, in its report on the bill, admitted that the legislation presented a new idea in acquiring Indian lands, and it raised the question whether Congress had the right to dispose of Indian lands without the consent of the Indians and whether it would be proper to pass the bill without providing for submitting it to the Indians for their ratification and approval, in accordance with existing treaty stipulations. The committee, however, argued that the new bill provided as much money for the Indians as the original agreement had, and in the end it decided, in any case, that Indian approval was not needed. Its justification was the Lone Wolf decision. The committee relied heavily, too, on the testimony of Commissioner of Indian Affairs William A. Jones before the committee. 54. Both the committee and the commissioner, in accepting the authority to act without Indian consent, asserted the responsibility of the government to act in good faith in the Indians' best interests, but these statements did not satisfy the watchdogs of Indian rights. Soon harsh criticism of the Rosebud Bill arose from the Indian Rights Association and other Indian advocates. The association, forced to accept the 53. Both McLaughlin's original agreement and the amended agreement are printed in 33 Stat 25458. 54 House Report Number 443, 58-2, Serial 4578, pages 15. See the discussion of Jones's strong opinion that the Indians' consent was unnecessary, below pages 36,364. Page 358. Principle of plenary legislative power asserted in the Lone Wolf case, now turned its attention to the fairness of the proposed legislation and argued for a higher price to be set on the lands taken. Although it broadcast its plea through newspaper articles and a special pamphlet, the association was unable to prevent the passage of the measure and could not persuade the president to veto it. 55 Congress, with the continued support of Commissioner Jones, similarly revised an earlier agreement with the Crow Indians and provided for opening their lands in the pattern of the Rosebud legislation, and other measures followed suit. 56. Thus the treaty system, upon which the tribes in the Indian Territory had so long depended for protection, collapsed. And there were few outside of the Indians themselves who mourned its passing. The Indian Rights Association in 1896 opted for a middle course, it said, between land grabbing and spoliation on the one side, a sentimentalism which takes no account of facts on the other. But ultimately the Indian Rights Association was quite content to let the tribe go. It noted that all recent Indian legislation had contemplated the extinction of the tribes and that the great majority of Indian reformers were agreed on that policy. The association wanted to do all that could be done wisely to save and guard the individual Indian. 57. Tribes outside the Indian Territory had already largely fallen under the domination of the United States wards confined on Indian reservations, with the power and dignity of independent nations supported by treaty guarantees all but forgotten. Step by step the treaty system had faded away as the United States sought conformity and rejected alien enclaves within the boundaries of its sovereignty. Congress asserted its plenary power over Indian affairs, and that power was upheld by the courts. 55 Memorial of the Indian Rights Association on behalf of the Rosebud Indians, February 15, 1904, Senate Document Number 158, 58-2, Serial 4590, Another Century of Dishonor. 56 The Crow Agreement in question was that of August 14, 1899, the amended ratification is dated April 27, 1904. House Report Number 890, 58-2, Serial 4579, 33 Stat 35262. See the discussion in Frederick E. Hoxie, A Final Promise, The Campaign to Assimilate the Indians, 18801920, 15458. It might be noted that when a new cession of land on the Rosebud Reservation was arranged in 1907, there was no formal agreement similar to the one of 1901. Congress simply legislated the opening of the lands, following the procedures established in 1904. 57 Report of the Indian Rights Association, 1896, 12. Page 359. Part 4. Renewal. The 20th century. The anti-tribalism that undercut the force of Indian treaties at the end of the 19th century carried into the 20th century. Government officials and reformers alike assumed that the assimilation of the Indians signaled by the allotment and citizenship provisions of the Dawes Act and the fulfillment of that policy by an enhanced and aggressive national Indian school system was to be the destiny of the Indians. Treaties were indeed only relics of the past. Nor did the Lone Wolf decision in 1903 bode well for the fate of the treaties in the new century. The old treaties, nevertheless, still had life in them, and as the century advanced, there was a resurgence of tribal spirit and a reawakening of tribal sovereignty, in which treaty rights came to play a vital role once again. John Collier's Indian New Deal of the 1930s rehabilitated tribal governments and tribal cultures without much regard for treaties. But in subsequent decades the sparks kept alive by traditionalist Indians once more broke into flame, and treaty rights became a rallying cry in the 1960s and beyond. An important element in the renewal was agitation about Indian claims against the federal government for payments or other benefits arising out of the old ratified treaties. At first the claims came before the United States Court of Claims, with which the tribes had little success. Then, with the establishment of the Indian Claims Commission in 1946, a new forum appeared, and all the tribes entered cases. A great. Page 360. Many of the dockets concerned claims for land or additional payments for land, and treaty stipulations became the foundation for most of the cases. Moreover, the late 20th century saw a Red Power movement modeled on Black Power that sought to restore recognition of tribal sovereignty and to revitalize or recreate the status of Indian tribes, enabling them to deal once more with the United States by means of treaties. These hopes, at least in their extreme form, may never be realized, but the existence of the old treaties and the rights they stipulate is a political reality, which the anomaly embodied in their circumstances cannot destroy. Page 361. Chapter 15. Treaties in the New Century. Judgments about Indian treaties during the early decades of the 20th century, like judgments about other elements of Indian affairs in that period, are difficult to make. It was the time in which Edward S. Curtis produced his monumental The North American Indian with its photographs of the vanishing race, and in which the Philadelphia dry goods magnate Rodman Wanamaker sent expeditions into the West to photograph the final gatherings of the tribes but also to applaud the assimilation of the passing race into American society. The theme was powerfully presented in the book of Wanamaker's protege Joseph K. Dixon, The Vanishing Race. And at the Panama Pacific International Exposition in San Francisco in 1915 the sculptor James Earl Fraser exhibited his famed portrayal of a pathetic head-bowed Indian on a worn-out pony, The End of the Trail. It was the period, as well, in which the positive assimilationist legislative program of the late 19th century reformers was carried out in administrative detail. 1. A full account of Indian affairs in these decades is given in Francis Paul Prucha, The Great Father, the United States Government and the American Indians, 2 volumes, pt. 7. For other approaches to the period, see Frederick E. Hoxie, A Final Promise, The Campaign to Assimilate the Indians, 18801920, and Thomas M. Holm, Indians and Progressives, From Vanishing Policy to the Indian New Deal. The place of Curtis, Wanamaker, Dixon, and Fraser in the enduring American myth of the disappearing Indians is well described in Brian W. Dippa, The. Page 362. On the level of government officialdom there was little question that tribalism was a thing of the past and that whatever remnants might still remain should be quickly and efficiently stamped out. In this respect these decades were a continuation, in fact, a culmination of the movement that had been gathering force in the last decades of the previous century. The Indian reform organizations, which had sparked the changing views toward the proper place of Indians in American society, did not break out of the old mold. But the policies of the federal officials and humanitarian groups were not easily implemented among the reservation Indians, many of whom held conservatively to their traditions and looked upon the treaties as the guarantee of the old ways. In addition, unsatisfied Indian claims against the United States, based chiefly on treaty stipulations, maintained the treaties as still living documents that could not be ignored. Continuing anti-tribalism. Official Indian policy turned away from dealing with Indians as tribes and dealt with individual Indians about their allotments, schooling, and health. It was a situation in which treaties and subsequent agreements were not important, and little attention was paid to them. Most federal officials considered the treaty system nearly if not totally defunct. The early 20th century was marked by strong-minded commissioners of Indian affairs, who held office for long terms, and they had a common goal of assimilating the individual Indians into white society, with little regard for tribal holdovers and the treaties once made with the tribes. William Jones, in his obsession with moving the Indians toward self-support, hit hard at the rations delivered to Indians, often in pursuance of treaty stipulations, and he fought against per capita payment of annuities based on treaty provisions. He declared in 1901 that the indiscriminate issue of rations was an effectual barrier to civilization, that the periodical distribution of vanishing American, white attitudes and U.S. Indian policy, 20,815, 21,820. Page 363. Large sums of money was demoralizing in the extreme. He set about to put all able-bodied Indian men to work despite what treaties or agreements might have promised them, and he adopted a policy of reducing rations for such Indians. Point 2. Jones felt it was time for a change. Heretofore the dealing had been with the tribe, he wrote, it would now be with the individual. He would no longer be looked upon simply as one of a dependent community to be dealt with as a whole, but would be considered independently and treated as one capable of developing those qualities which would lift him above the level of a pauper and fit him to become a useful member of society. Jones noted that there was criticism of this move, but in the end the results were favorable even beyond expectation. 3. It might be argued that Jones's policy on rations was a reasonable one, but he had a cavalier approach to treaty rights that might obstruct the sale of surplus reservation land. His advice to Congress in the reduction of the Rosebud Reservation in 1904 was unequivocal. In an interchange with Representative Charles H. Burke of South Dakota, Jones spoke bluntly. If you depend upon the consent of the Indians as to the disposition of the lands where they have the fee to the land, you will have difficulty in getting it, and I think the decision in the Lone Wolf case, that Congress can do as it sees fit with the property of the Indians, will enable you to dispose of that land without the consent of the Indians. If you wait for their consent in these matters, it will be 50 years before you can do away with the reservations. Mr. Burke, would you make that statement general, or would you accept reservations where there may be in existence treaty relations that provide directly to the contrary? For instance, do you know there is in existence among the Sioux, I think in the Treaty of 1868, a provision that the Indians will not be deprived of their lands without the consent of 3/4, and that provision was reenacted, I think, in the Treaty of 1889. Commissioner Jones, I will go to the extreme. I do not think I would ask the consent of the Indians in that case. Supposing you were the guardian or ward of a child 8 or 10 years of age, would 2 CIAAR, 1901, Serial 4290, p1. For Jones's views on of the matter of rations and annuities, see Ibid, 1900, Serial 4101, pages 512, Ibid, 1902, Serial 4458, pages 28. In the next year Jones provided lists of treaties and of agreements, as if he were in a sense making a final accounting of a now obsolete policy. Ibid, 1903, Serial 4645, pages 3234, 46979. 3 Ibid, 1902, Serial 4458, pages 78. Page 364. You ask the consent of the child as to the investment of its funds. No, you would not, and I do not think it is a good business principle in this case. Point 4. Jones's successor, Francis E. Loop, was firm in his conviction that Indians should be individualized and assimilated. Point 5. After he left office, he set forth his candid views about Indian affairs in a book called The Indian and His Problem. He had no use for so-called treaties, which assumed that the reservation belonged absolutely to the Indians. Although not a few of the treaties contained figurative language designed to convey to the tribes concerned the idea of perpetuity of physical possession, he wrote, every allotment law, and every moral argument made in behalf of allotment as a remedy for some of the more crying evils of the reservation system, plainly recognized that system as but a passing phase in the history of Indian development, and to such extent discredited the notion of a permanent tribal title. Loop thus welcomed the decision in the Lone Wolf case and saw benefits in the disposal of surplus reservation lands without the hindrance of seeking Indian consent. He made fun, too, of petty items in treaties, which were now outgrown and absurd, and all of them annoying. His proposed solution was to obtain Indian consent to capitalize the various annuities provided for by their treaties. 6. Robert G. Valentine, who acted as Loop's assistant commissioner and then followed him in office, held the same view about proper policy in dealing with Indians, to do everything possible to educate them for citizenship. One bar to success in his efforts came in the perpetual annuities provided for in the treaties of various groups of Indians, monies that kept the Indians in a state of dependence and assured them of income without labor. Valentine, with some success, worked for the commutation of these annuities into a one-time payment to be distributed to the individual Indians. Well into his term of office, he rejoiced at the outcome. Tribal organization is breaking up and the office, in its administrative activities, has its work greatly increased through the necessity of dealing separately with many individuals where formerly it dealt with groups, the point of evolution thus reached in transacting. For House Report number 443, 58-2, serial 4578, p4. 5 CCIAAR, 1905, serial 4959, p3, IBID, 1908, serial 5453, pages 1112. 6. Francis E. Loop, The Indian and His Problem, 81, 17678, see Chapter 5, Disposing of the Surplus, 7995. Page 365. Business is almost epical, for it marks the time when each Indian begins to stand forward as his own businessman, and, in a measure, reaches the status of white citizens. 7. With Cato cells the detribalization of the Indians moved forward rapidly. Under the provisions of the Burke Act of 1906, which allowed granting of fee patents for allotments to Indians who were competent to handle their own affairs before the end of the 25-year trust period set by the Dawes Act, large numbers of Indians were severed from government supervision and thrown out into the white world. It is my fixed purpose to bring about the speedy individualizing of the Indians, Sells said in his first year in office, and to this end I shall continue to devote my best efforts. In 1917 he issued his famous Declaration of Policy in the Administration of Indian Affairs, in which he noted that the solution to the Indian problem was individual and not collective, and in which he pushed aggressively to separate competent Indians from government concern by setting up categories of such Indians on the basis of blood quantum and English education. 8. Sells's program was disastrous for many Indians, who quickly lost or disposed of their individual lands as soon as they were declared competent and received patents in fee, but Sells seems not to have noticed. His successor, Charles H. Burke, slowed down the patenting process, but he was as much an assimilationist as his predecessors. He supported the aim of inducing by this transfer of tribal to individual holdings a departure from old communal traits and customs to self-dependent conditions and to a democratic conception of the civilization with which the Indian must be assimilated if he is to survive. 9. Indian reform groups, likewise, paid little attention to treaties and protection of the Indians' treaty rights as they moved into the 20th century. The Lake Mohonk Conference of Friends of the Indian, the 7 CIAAR, 1910, serial 5976, p27, IBID, 1911, serial 6223, pages 3, 45. See also his laudatory evaluation of the Indians' new status in A Decade of Indian Affairs, Ibid, 1912, serial 6409, pages 34. 8 Ibid, 1913, serial 6634, p. 45, Ibid, 1917, serial 7358, pages 34. For Selz's policy on speeding up the declarations of Indian competency, see Janet McDonnell, Competency Commissions and Indian Land Policy, 1913-1920, South Dakota History 11, 2134. 9 Report of the Commissioner of Indian Affairs, 1921, 25. See Sean J. Flynn, Western Assimilationist, Charles H. Burke and the Burke Act, Midwest Review, 2D Ser, 11, 115, which emphasizes Burke's assimilationist views both as representative and as Commissioner of Indian Affairs. Page 366. Board of Indian Commissioners, and the Indian Rights Association, which had carried on a drive for assimilation in the closing decades of the 19th century, saw their main goals fulfilled in legislation and thought the remaining problems were simply those of efficient administration. The Lake Mohonk Conference, which continued its annual meetings until 1916, replayed over and over its old record from the previous century: detribalization, individualization, and assimilation of the Indians. If treaties were noted at all, it was as an obstacle to progress of the Indians toward the goal of complete citizenship. In 1901 the conference listened to an address by James M. Taylor, president of Vassar College, who posed a rhetorical question: if there are treaties with Indian tribes which are standing absolutely in the way of the interests of the Indian, then is it fair, because of the mere abstract love of truth, that we continue to pauperize the Indian, to make less and less of a man of him, to threaten him, indeed, with effacement, simply that we may keep a treaty that our fathers made with him? The audience seemed to approve. Point 10 Protection of treaty rights was not a part of the Lake Mohonk agenda. The Board of Indian Commissioners, still tightly associated with the Lake Mohonk Conference, independently echoed these views in its annual reports, and it pushed a number of policies toward detribalization. It hammered on the idea of breaking up the tribal trust funds, as the Dawes Act allotments had broken up the tribal land. There is an essential difference between the old method of dealing with Indians and the new method, the board declared in 1900. The old method dealt with them in the mass and as tribes. The new method proposes to deal with them as individuals. It saw the tribal funds as the rallying point and the shelter for the spirit of conservatism which seeks to keep the Indians out of the life-giving current of American civilization, American public school life, and citizenship. 11. Yet the Board of Indian Commissioners, as might be expected of Christian philanthropists, was not unaware of the obligation of justice toward the Indians. It saw in the Lone Wolf decision the danger of greedy whites moving into Indian lands, and it demanded that Congress make every effort to secure the best price for the Indians in the disposal of the surplus reservation lands. The tendency to tamper with ethical standards of trusteeship in such leges. 10 Lake Mohonk Conference Proceedings, 1901, 126, 128. 11 Report of the Board of Indian Commissioners, 1900, 6, 910, Ibid, 1901, 8, emphasis in original. Page 367. Lashon, it warned, while it is unjust to the Indians, entails upon the whites in Congress and throughout the country an infinitely heavier loss in the degradation of moral standards and of the sense of public honor. 12. Limited concern for treaty rights. Of the Indian reform groups from the 19th century that carried over into the 20th, only the Indian Rights Association was still concerned about treaty rights. That is understandable, for one of the main purposes of the association at its founding in 1882 had been to secure to the Indians of the United States the political and civil rights already guaranteed to them by treaty and statute. And in the early years of the new century this devotion to treaty rights was still in evidence. In 1901 the association supported claims of Indians on Puget Sound to tide lands under the treaty made with Governor Stevens in 1855, and in 1902 it warned, the present tendency of Congress to disregard the solemn rights guaranteed to the Indian by treaty is alarming. The association's Washington agent, in the same year, asserted, that the legislative and executive branches of our government are seeking to enter upon a new policy in the treatment of our Indian wards. There can be no doubt. The tendency seems to favor the abrogation and violation of solemn treaty obligations. 13. The confirmation of congressional abrogation of Indian treaties by the Supreme Court in Lone Wolf v. Hitchcock was an especially sore point with the Indian Rights Association, which had actively supported the Indians in the case. It called the preliminary decision by the Court of Appeals of the District of Columbia a doctrine of a very disquieting nature, and, while admitting a defective title to executive order reservations, it stoutly maintained that the treaty reservations were quite different. To their maintenance as an inviolate home for Indians, the United States has always been pledged, as everybody has considered and supposed, in the most solemn manner possible. In a tone of pique, it asserted. 12 Ibid, 1906, 16. 13 Report of the Indian Rights Association, 1901, 6566, Ibid, 1902, 3, 5, S. Ambrosius, A New Indian Policy, The Red Man's Rights in Jeopardy, 1. Page 368. It is now distinctly understood that Congress has a right to do as it pleases, that it is under no obligation to respect any treaty, for the Indians have no rights which command respect. What is to be hoped for by an appeal to Congress can readily be anticipated from the history of the legislation by which Lone Wolf and his tribe have been deprived of that which had by express treaty stipulations apparently been secured to them. 14. Although the Indian Rights Association was forced to acquiesce, albeit reluctantly, in the Lone Wolf decision, it continued to support Indian rights in other ways, relying on treaties when the occasion arose. Thus it fought for Yakima Indian fishing rights and water rights under the Treaty of 1855.15, and it demanded that Congress appropriate money for Navajo schools under the provision of the Treaty of 1868. It would seem, it said in 1912, that Congress cannot in good faith longer delay in providing liberally for schools in view of its solemn obligations of treaty to this neglected people. 16. Yet the thrust of the Indian Rights Association's program in the 20th century did not differ greatly from the movement toward assimilation advocated by the Lake Mohonk Friends and the Board of Indian Commissioners, and though it fought with Commissioner Loop, it in general publicly supported the programs of the government to cut the Indians loose from government supervision as self-supporting citizens. We are convinced, the Executive Committee said in 1914, that there will be no substantial or satisfactory solution of the Indian question until the red man is set free. 17. The white reform groups were joined in the second decade of the century by the Society of American Indians, a group of educated Indians, mostly professionals, who sought to promote the Indian heritage and Indians' pride in their race, while at the same time taking part fully in white society. They sought to free the Indians from the restraining hold of the Indian Bureau. Beginning in 1911 and stretching into the 1920s, the Society held annual meetings and published a quarterly, and the members appeared to be a useful complement to the white reformers. They were not concerned. 14 Report of the Indian Rights Association, 1902, 17, Ibid, 1903, 24, see also Ibid, 1910, 1920. 15 Ibid, 1905, 3941, 1912, 4952, 1913, 7275. 16 Ibid, 1912, 6566, see also the report of the Association's Washington agent, Ibid, 1913, 54. 17 Ibid, 1914, 1819. Page 369. About tribal treaty rights, for they were a pan-Indian group, with little focus on tribal communities on reservations. 18. Treaty provisions were upheld, however, in two significant Supreme Court cases in the first decade of the century. In 1908, in the case of Quick Bear v. Loop, the court approved the use of treaty funds for Indian schools run by Catholic missionaries. Against the arguments of the Indian Rights Association, which acted in the name of Reuben Quick Bear, a Rosebud Sioux, claiming that such use of the funds was contrary to congressional prohibitions on the use of federal funds for sectarian schools, the court said that the treaty funds were not public money but rather Indian money and that the Indians could determine if they wanted to use some of it for Catholic schools. 19. Earlier in the same year, in Winters v. United States, the Supreme Court in a landmark case with many ramifications for Indian water rights decreed that where land was reserved to an Indian tribe, there was an implied reservation of water necessary for the irrigation of the lands. The Indians of the Fort Belknap Reservation, the court decided, in giving up some land did not thereby relinquish the right to appropriate the waters of the Milk River necessary for agricultural and other purposes upon the reservation. Although the particular case rested on a treaty substitute, an agreement with the Indians in 1888, the principle was later applied to all reservations, whether established by treaty, agreement, act of Congress, or executive order. 20. Even federal officials intent on destroying tribalism called upon the treaties when it served their purposes, notably in their continuing campaign against the liquor traffic. The obsession of many Indians with intoxicating liquors and their ability to satisfy their thirst in areas. 18. For a full discussion of the Society of American Indians, see Hazel W. Hertzberg, The Search for an American Indian Identity, Modern Pan-Indian Movements, pt. 1. For a biography of one notable member of the Society of American Indians, see Peter Iverson, Carlos Montezuma, and the Changing World of American Indians. 19-210 U.S. 7782. The court also approved the use of trust funds for the same purpose. There is a full discussion of the matter in Francis Paul Prucha, The Churches and the Indian Schools, 18881912. 2207 U.S. 56478. See also Arizona v. California, 373 U.S. 546602. Winters and its implications are fully examined in two articles by Norris Hundley, Jr., The Dark and Bloody Ground of Indian Water Rights, Confusion Elevated to Principle, Western Historical Quarterly 9, 45582, and The Winters Decision and Indian Water Rights, A Mystery Re-Examined, Ibid 13, 1742. Page 370. Surrounding the reservations frustrated the best efforts of the Indian Office. One particular point of infection appeared at the Chippewa reservations in the state of Minnesota. In 1909, Commissioner Valentine noted that when lands had been ceded by the Indians, the treaties had prohibited the manufacture and sale of intoxicating liquors within the ceded areas until Congress or the President removed the prohibition, and he asserted that neither Congress nor the President had so acted. 21 Valentine declared that the Indian Office was acting upon the policy that these treaty provisions were made for the protection of the Indians, and their aid will be invoked to whatever extent is necessary. And he acted forcefully. Circulars were issued warning liquor distributors in the affected counties of Minnesota that the stipulations of the treaties of 1855 and 1863 would be enforced, and he reported that about 125 saloons had been closed, much whiskey destroyed, and many convictions secured. This vigorous action, he noted, has had great deterrent effect. 22. This early success soon suffered a setback, for the whiskey sellers got an injunction against the enforcement of the Treaty of 1855 from the United States Circuit Court, Minnesota District, 4th Division, which argued in 1911 that when Minnesota entered the Union in 1858, it did so on an equal footing with other states, including the power to regulate the liquor traffic, and that thus the treaty provisions had been repealed by implication. Enforcement was held in abeyance, and the problem fell to Valentine's successor, Cato Sells. Finally, on June 8, 1914, the Supreme Court of the United States upheld the enforcement of the treaties prohibiting liquor and denied a rehearing of the case, and Sells successfully renewed enforcement activities. Neither Valentine nor Sells seemed to be disturbed by their eager and energetic reliance on old treaties, which in general they opposed. 23. 21 Valentine cited 6 treaties, 185,163, with Sioux, Chippewa, and Winnebago Indians and 2 agreements with Yankton Sioux and Nez Perces of 1,894. CCIAAR, 1909, Serial 5747, pages 1315. 22 CIAAR, 1909, Serial 5747, p15, Ibid, 1910, Serial 5976, p12. 23. The Circuit Court decision is in 183 F 61126, the Supreme Court case is Johnson v. Gilds, 234 U.S. 42248. See also CIAAR, 1911, Serial 6223, pages 3536, Ibid, 1914, Serial 6815, p45, Ibid, 1915, Serial 6992, pages 1112, and Ibid, 1916, Serial 7160, pages 6162. Page 371. Residual tribalism and reliance on treaties. On some reservations, tribalism and interest in treaties had by no means disappeared. While Indians like those in the Society of American Indians wanted to maintain their heritage without regard for tribal reservation boundaries, most Indians in the period were not yet inclined or prepared to pull away completely from the past, even though they lost much of their customary way of life under the bombardment of land allotment, fee patents, white education, division of tribal funds, and citizenship aimed at assimilating the Indians into white society. Indian ways were forced to change, and although some Indians progressive they were called accepted the changes as inevitable and even desirable, for many the old life was still what they wanted. The diversity of views was well demonstrated among the 5 civilized tribes in the Indian Territory as the area moved toward statehood. A Senate Select Committee was appointed in 1906 to investigate conditions in the territory. Between November 11, 1906, and January 9, 1907, the 5-member committee held public hearings in the Indian Territory. These meetings were open and free. The committee's report said, "Special effort, and with marked success, was made to have the Indians, both those of the full and those of the mixed bloods, fully represented. Educated Indians, often mixed bloods, were willing if not eager to accept allotments and have restriction on their land removed, but the traditional full bloods resisted change. The committee members tried to convince them that it was no longer possible to maintain tribal communal land tenure and that they should accept allotments and make the best of the new conditions, but some Indians were adamant. 24. 24 Report of the Select Committee to investigate matters connected with affairs in the Indian Territory, with hearings, November 11, 1906, January 9, 1907, Senate Report Number 5013, 59-2, Serials 500 and 6263. The committee held public hearings in the Indian Territory at Veneta, Muskogee, McAllister, Ardmore, Tulsa, and Bartlesville. The formal report covers 8 pages, to which are appended 2,132 pages of hearings. A summary of conservative testimony is given in Angie Debo, and Still the Waters Run, Chapter 5, The Voice of the Indian Territory. I have followed Debo's lead, perhaps unwisely. W. David Baird has used the same Senate report to show effectively that Oklahoma Indians favored modernization and acceptance of. Page 372. At the committee's hearing at Veneta on November 13, Eufaula Harjo, a full-blood Creek, reported, "I am here asking for the treaty, and the treaty that I am here asking for, I will never stop asking for this treaty, the old treaty that our fathers made with the government which gave us this land forever, as long as the grass grew and water ran. I will keep on asking for it, for my old fathers and your old fathers made that treaty with us away back there on the other side of the Mississippi, and they said that this land out here was to be ours as a nation forever, and that is the treaty I want, for we are to have it as long as the grass grows, water runs, and the sun rises, we should have this land, and we are still asking for this land just as the treaty says." Point 25. Similarly, Redbird Smith, a full-blood Cherokee, asked for adherence to the old treaties. "I live under these respective treaties that have been made between the government of the United States and the Indians," he said, "and I am resting now under these treaties, and I am suffering from the infraction of them." 26. The committee members explained that subsequent agreements had been made by the Indians which changed conditions, but they could not convince these men and those they represented that allotment was there to stay nor weaken the hope of the Indians that the Great Father would be the guarantor of their old treaty rights. Outside the 5 civilized tribes, there was less organized or articulate reliance on treaty rights. Allotment and assimilation policies were resisted, but to a large extent the old ways were suppressed, even though the new did not take hold quickly or completely. Nevertheless, when Indian policy changed in the 1930s, there was a strong tribal persistence that was amenable to restoration and revitalization. One force that made this possible was the continuing life of the old treaties. When Congress in 1871, conscious of the good faith and honor of the nation, added to its prohibition of further treaty making the proviso that nothing in the new law should be construed to invalidate or impair the obligation of any treaty heretofore lawfully made. Industrial society without becoming any less Indian. See his article Are the 5 Tribes of Oklahoma Real Indians? Western Historical Quarterly 21, 1011. All one can conclude is that some Indians in Oklahoma held firmly to reliance on their treaty rights. 25 Report of the Select Committee, 93. 26 Ibid, 97. Page 373. And ratified, it set the course for a perpetuation of Indian tribalism that at the time it could hardly have foreseen. Treaties were still on the books. They had not been abrogated across the board, as some reformers had suggested. They presupposed some sort of tribal organization, and they provided a minimal sort of tribal identity inherited from the Indians by whom the treaties had been signed. Such groups still looked for the fulfillment of the promises made in the treaties by the United States government. The treaties were there to be called into play as occasions demanded. John Collier. A new Indian reform figure, John Collier, emerged in the early 1920s. Collier was a New York social worker who became interested in Indian culture and Indian rights after a visit to Taos Pueblo in 1920, and he devoted the rest of his career to Indian affairs. He found in the communal life of the Pueblos an antidote to the individualism of industrial life in the United States and thought he had found a solution to the ills of the nation. He thus rejected the drive for individualization and Americanization of the Indians represented by the Dawes Act and carried on by the traditional Indian reform organizations and the government officials of the progressive era. His goal, instead, was the protection and restoration of Indian cultural ways, with an emphasis on communal tribal practices. Working with like-minded friends, especially through the American Indian Defense Association, of which he was the directing force, Collier sought to hold back and reverse the tide that was moving the Indians willy-nilly into white civilization. 27. Treaties, however, were not on Collier's mind. He was interested in human rights, not treaty rights, perhaps because the Pueblo Indians, who were his primary contact with the Indian world, had not had a treaty relationship with the federal government. In the dozen years before he became Commissioner of Indian Affairs in 1933, Collier was an aggressive and articulate critic of all the Indian Bureau stood for, leading campaigns to protect the lands of the Pueblos from white 27 Collier's activities are thoroughly treated in Kenneth R. Philp, John Collier's Crusade for Indian Reform, 1920-1954, and Lawrence C. Kelly, The Assault on Assimilation, John Collier and the Origins of Indian Policy Reform. Page 374. Encroachment, to support and glorify the traditional religious ceremonies of the Indians against critics who wanted to stamp them out as pagan and immoral, and to prevent white exploitation of Indian resources, but one searches in vain for explicit reliance on treaties in his efforts. Collier's campaign against the Indian Bureau could not be ignored, and Secretary of the Interior Hubert Work instituted discussions and investigations into the Bureau's Indian policy. Thus in December 1923 Work called together the Advisory Council on Indian Affairs to advise him on Indian matters. The 100 people invited were a broad cross-section of people interested in the Indians. Collier was there, mixing with representatives of the Board of Indian Commissioners, the Indian Rights Association, the Society of American Indians, missionary groups, and a miscellaneous array of other notables. The resolutions of the committee dealt with such topics as Indian art and music, health, education, Pueblo lands, and the evils of Indian dances and of peyote, but, except indirectly in a discussion of Indian claims against the government, there was no interest shown in Indian treaties. Point 28. The Committee of 100 did little if anything to correct the evils perceived in the management of Indian affairs, and later in the decade Secretary Work instigated, through the Brookings Institution, a more thorough study, conducted by Lewis Merriam and a staff of experts. The result was the Problem of Indian Administration, submitted in February 1928. It was a forthright indictment of the administration of Indian affairs, which, rather than attacking the traditional policies themselves, demanded a more efficient carrying out of the Indian Bureau's functions. Like the Committee of 100, it ignored the treaties, aside from their basis for unsettled claims of Indian groups against the United States. 29 Treaties had all but disappeared from public consciousness. As Commissioner of Indian Affairs, John Collier aggressively promoted a new policy in Indian affairs that revived tribalism and Indian. 28 The Indian Problem, resolution of the Committee of 100 appointed by the Secretary of the Interior and a review of the Indian Problem, House Document No. 149, 68-1, Serial 8273, Hubert Work, Indian Policies, Comments on the Resolutions of the Advisory Council on Indian Affairs. 29 Lewis Merriam and Others, The Problem of Indian Administration. Page 375. Cultures. In the Indian Reorganization Act of 1934, Congress adopted much of his program, for the law authorized the renewal or strengthening of Indian tribal governments and provided, as well, for tribal corporate economic organization. Not all Indians, however, were eager to accept Collier's vision of their future, which included in its original form a return of allotted lands to communal ownership, and Collier ran into considerable opposition from Indians who had adjusted to the allotment policy and from others who were afraid of the new ways. Hearings in 1934 before the House and Senate committees considering the original Wheeler-Howard bill included considerable testimony of Indians against the measure. Very little was said about treaty rights, although in a couple of instances treaties were referred to. The Yakima Tribal Council in opposing the bill submitted a statement that said in part, "We feel that the best interests of the Indians can be preserved by the continuance of treaty laws and carried out in conformity with the Treaty of 1855, entered into between the fathers of some of the undersigned chiefs and Governor Stevens of the Territory of Washington." And the Quapaw Indians in a memorandum of objections to the bill listed the treaties upon which their rights to their land rested and quoted from their Treaty of 1833.30. In the hearings and in the regional congresses of Indians called by Collier to explain his proposals, Collier perceived substantial support, and he made amendments in his original proposal to eliminate strands of opposition among the Indians and the lawmakers. In the end, the law created a new structure of tribal councils and elected officials. Although the new forms were not without their faults, and traditionalists among some of the tribes would come to ridicule these tribal governments as puppets of the Bureau of Indian Affairs, the councils and their elected heads became a continuing and powerful force in Indian affairs. The emphasis of Collier and his Indian New Deal on tribal government made possible 30 to grant to Indians living under federal tutelage the freedom to organize for purposes of local self-government and economic enterprise. Hearings before the Committee on Indian Affairs, United States Senate, 73rd Congress, 2nd Session, on S. 2755 and S. 3645, 35,455 and 408. Rupert Costo cited such evidence in 1983 and left the impression that reliance on treaties was more widespread in the Indians' opposition than it actually was. See Kenneth R. Philp, ed., Indian Self-Rule, First-Hand Accounts of Indian-White Relations from Roosevelt to Reagan, 49. Page 376. The perpetuation of the concept of tribal sovereignty that came to play a dominant role in relations between the Indians and white society. 31. It is hard to tell how deeply ingrained Collier's views on Indian self-government were in the minds of legislators and the general public. Long before Collier resigned his office in 1945, there had been growing opposition to his policies and programs in Congress, and support for treaties was weak or missing. In the late 1940s, a statement by a white friend of the Indians from the 1920s provided a broad account of Indian treaty making in the Chronicles of Oklahoma, which ridiculed the treaties as outmoded and largely responsible for the peculiar wardship status of the American Indian. It condemned the segregation of the Indians and asserted, to hold them in the grip of a treaty made generations ago is indeed a dead hand laid upon their future. 32. Indian claims. Despite the general lack of interest in the old treaties on the part of government officials and Indian reformers, there nevertheless remained among the Indians a strong undercurrent of reliance on them and the rights they guaranteed. This arose from the continuing claims that Indian tribes had against the United States, claims that were based largely on the treaties signed in the past. Many Indians expected to receive an economic windfall if their claims were resolved in their favor, and reservation tribal groups continued to see in the treaties a basis for autonomy and sovereignty. The treaties gave a boost to tribal persistence, which many persons of the period were denigrating. The government had to face tribal action from Indians whose tribalism it thought had 31. See the legacy of the Indian New Deal, in Prucha, Great Father, 2, 100,912. This view is not universally accepted. Rupert Costo, a Cahuilla Indian from California and a violent opponent of the Indian Reorganization Act, said in 1983, the IRA did not allow the Indians their independence, which was guaranteed in treaties and agreements and confirmed in court decisions. It did not protect their sovereignty. Collier did not invent self-government, the right of Indians to make their own decisions, to make their own mistakes, to control their own destiny. The IRA had within it, in its wording and in its instruments, such as the tribal constitutions, the destruction of the treaties and of Indian self-government. Philp, Indian Self-Rule, 48. 32. G. E. E. Lindquist, Indian Treaty Making, Chronicles of Oklahoma 26, 416, 438. The article was written in collaboration with Flora Warren Seymour. Both authors had been members of the Board of Indian Commissioners. Page 377. Been pretty well quashed. For Indians and their lawyers, treaties were still vital documents. The claims kept tribal consciousness alive during a dark period when detribalization and total assimilation were in vogue. Various Indian groups insisted that land guaranteed them by treaty had been taken from them illegally, that land ceded by treaties had not been adequately paid for, that promises of services and benefits made in treaties had not been kept, and that in other ways formal treaty stipulations had been violated. Such Indian claims had a long and convoluted history. Although the sovereignty of the United States protected the government from suits, Congress from time to time specifically authorized such suits. A law of 1855 created a court of claims with authority to render judgments, but an amendment in 1863 accepted from the court's jurisdiction any claim against the government, growing out of or dependent on any treaty stipulation entered into with foreign nations or with the Indian tribes. 33. Tribes with claims against the government had to seek a remedy directly from Congress, and they had trouble persuading Congress to pass the necessary legislation. Then, beginning in 1881 with a petition of the Choctaws, Congress passed special jurisdictional acts authorizing the Court of Claims to accept Indian cases. From that time until the establishment of the Indian Claims Commission in 1946, more than 200 Indian claims were handled by the court. 34. The vast majority of suits instituted by the Indians dealt with the construction of treaties and with questions about their fulfillment, but the failure of the government to live up to its trust responsibilities was also a subject of the litigation, and there were some personal claims for services rendered Indians. The Court of Claims, like other federal courts, construed the Indian treaties and agreements liberally in favor of the Indians, but the court interpreted strictly the authorization given in the pertinent jurisdictional acts. 3310 Stat 61214, 12 Stat 767. 34C Indian tribal claims filed in U.S. Court of Claims arranged by dates when petitions were filed, in House Report Number 2503, 82-2, Serial 11582, pages 156,371. A compilation of the claims, made in 1947 by E. B. Smith, Chief of the Indian Tribal Claims Section, U.S. General Accounting Office, was published as Indian Tribal Claims Decided in the Court of Claims of the United States, briefed and compiled to June 30, 1947, 2 volumes. House and Senate hearings on Indian Claims Commission bills in 1935 and 1945 also furnish useful information. For a brief historical account, see Glenn A. Wilkinson, Indian Tribal Claims Before the Court of Claims, Georgetown Law Journal 55, 51128. Page 378. The Indian cases before the Court of Claims between 1881 and 1920 were relatively few, they proceeded without extreme delay, and in many cases the Indians received a favorable judgment, although not always what they had claimed. From 1920 on the whole business tremendously expanded. In the decade of the 1920s, 65 new dockets were entered, in the 1930s, 83 dockets, and in the 1940s, 21 more, some of which had not been decided by the time the Indian Claims Commission was established. With the increased caseload, delays in adjudication mounted, and a large proportion of the claims were dismissed because of lack of prosecution or because offsets equaled or exceeded the established claim. 35. Agitation thus arose for some better and more expeditious way to handle the Indian claims. The motivation came not from a devotion to treaties and an intention to preserve or reinstate their validity, but from a desire to end what the Board of Indian Commissioners in 1930 called the lethargy of expectancy, the unwillingness of the Indians to work for self-support because they kept hoping for some large windfall from successful claims. As early as 1910, ex-Commissioner Loop saw the problem. The claims, whether good, bad, or indifferent, all had a common flaw. Morally, he argued, it would be a happy day for the dependent race if Congress were to obligate itself irrevocably never to entertain any more of them. They only serve to keep a multitude of Indians in a state of feverish expectancy of getting something for nothing, which is fatal to their steady industry and peace of mind. Loop recommended creation of a special court or the addition of a branch to the Court of Claims to handle Indian claims exclusively, and he wanted a time limit set for the final adjudication of all claims. 36. Then, in 1913, the Board of Indian Commissioners, in view of the numerous claims asserted by Indian tribes or attorneys interested in their behalf, in connection with alleged breach of treaty obligations, recommended the appointment of a proficient group to study the treaties and how they had been administered, so that the Secretary of the Interior, where prima facie grounds for claims are found to exist, might push for the necessary jurisdictional legislation. The goal was not only to determine promptly the just claims of Indian tribes against the government. 35 These figures are taken from House Report number 2503, serial 11582, 15371. For an extended discussion of the matter, see H. D. Rosenthal, Their Day in Court, A History of the Indian Claims Commission, 346. 36 Loop, The Indian and His Problem, 19496. Page 379. Meant, but to make sure that the Indians did not employ attorneys under unconscionable contracts to handle their claims. 37. Secretary Works Committee of 100 in 1923, noting the denial of easy access to the Court of Claims to Indians tribes, recommended legislation to enable every group or tribe of Indians to obtain through the Court of Claims a judicial and final accounting with their guardian, the United States. The increase in the number of jurisdictional acts and cases filed with the Court of Claims in the 1920s, with delays and negative judgments, made the problem more visible. In the Merriam Report of 1928, an urgent plea was made for new procedures to speed up the cumbersome and unsatisfactory process of handling the Indians' claims. What the Merriam staff wanted was creation of a special group to study the outstanding claims and then to submit its recommendations to the Secretary of the Interior, who in turn would draft a suitable jurisdictional bill to forward to Congress. 38. The Board of Indian Commissioners at the same time echoed the concern expressed by the Merriam Report. It noted that the honor of the nation was involved as well as the rights of the tribes, and it repeated its earlier warning that great expectations are injuriously affecting the industrial and social progress of the Indians. 39. The board was encouraged by the initial stand taken by the new Commissioner of Indian Affairs, Charles J. Rhodes, appointed by President Hoover on April 18, 1929. Rhodes came into office pledging to follow the Merriam Report, and he was greeted enthusiastically, even by John Collier and his American Indian Defense Association. Rhodes recommended a special Indian Claims Commission and noted that unless something like this were done, the claims might well run on for another century. There can be no liquidation of the government's guardianship over Indians, he declared, until this inheritance of treaties and alleged broken treaties and governmental laches of the past is absorbed. 40. The movement to speed up the Indian claims action gathered momentum, not out of concern for treaties and the Indian rights stipulated in them as a basis for continuing or strengthening tribal status, but rather, in a sense, to wipe out remaining remnants of tribal authority. Congress, however, refused to act. An Indian Claims Commission remained high on Collier's agenda, but even he, as Commissioner of Indian Affairs, was unable to push a measure through Congress. Although a number of bills were introduced between 1935 and 1945, none was able to overcome the strong opposition of members of Congress, some of whom looked upon the measure as a raid upon the Treasury intended to benefit not the Indians but their lawyers. 41. Finally, after a long and bitter legislative battle, the Indian Claims Commission Act became law on August 13, 1946. It provided for a commission of 3 persons, with appropriate staff, to hear claims against the United States on behalf of any Indian tribe or other identifiable group of Indians. The commission could deal with a broad variety of claims arising under laws, treaties, or executive orders, including those that would result if the treaties, contracts, and agreements between the claimant and the United States were revised on the grounds of fraud, duress, unconscionable consideration, mutual or unilateral mistake, whether of law or fact, or any other ground cognizable by a court of equity. No statute of limitations or laches would have effect, but the United States could use all other defenses, and in the determination of relief, deductions were to be made for payments made on the claims and for other offsets, including all money or property given to or funds expended gratuitously for the benefit of the claimant. 42. Nearly all of the 176 tribes or bands that were notified of the act filed one or more claims on old grievances. In the end there were 370 petitions, which were broken down into 617 dockets. The commission was nearly overwhelmed, for the adversarial proceedings that developed between the tribal lawyers and the Justice Department greatly slowed down the process. The life of the commission had to be extended in 1956, 1961, 1967, 1972, and 1976. The body finally went out of existence on September 30, 1978.43. 41. The struggle to enact a measure is well described in Rosenthal, Their Day in Court, 47109. 4260 STAT 104,956. 43. An alphabetical list of cases and an index by docket number are given in United States Indian Claims Commission, August 13, 1946, September 30, 1978, Final Report, 23,123. An administrative history of the working of the Commission is in Rosenthal, Their Day in Court, Chaps. 37, and in a shorter piece by Rosenthal, Indian Claims and the American Conscience, A Brief History of the Indian. Page 381. By that time hardly a treaty existed that had not come into play in determination of Indian claims. Arthur V. Watkins, then Chief Commissioner on the Indian Claims Commission, was queried in 1965 by the House Committee on Interior and Insular Affairs about the need for a comprehensive study of Indian treaties. He replied negatively and said, "This commission has been in existence now for 18 years and most of the major treaties have been before us and have been studied, interpreted, and argued to great lengths. The attorneys for the Indians and for the Department of Justice have had to make comprehensive studies of every treaty in every treaty case that has been filed with us. They have spent years on these matters and we have the benefit of their work. There is no doubt that if a study had been made before the Indian Claims Commission came into being then it might have been of some help, but it is doubtful that any study made now could take the place of the intensive work already done by the lawyers, anthropologists, historians, and others who have had to prepare themselves on these treaty matters. Most of the 852 causes of action filed with us involve treaties of one kind or another. 44. With such a large number of dockets, of course, it is impossible here to cover the full use of treaties in the arguments of the cases, but two brief examples will give some insight into the reliance on the treaties in adjudicating the tribal claims. One example is Docket 18S, the claim made by a group of Chippewa Indians identified as Chippewas of Lake Superior and Chippewas of the Mississippi, for land ceded by the Treaty of October 4, 1842, an area designated as Royce Area 261.45. The Indians claimed recognized title to this land under the Treaty of Prairie du Chien, August 19, 1825, confirmed by subsequent treaties of 1826 and 1827. The Commission in August 1968 considered this question, and after noting similar Indian Claims Commission and Court of Claims judgments made earlier, it declared that the Chippewas did indeed hold the land in Royce Area. Claims Commission, in Imre Sutton, ed., Irredeemable America, The Indians' Estate and Land Claims, 3570. See also Decisions of the Indian Claims Commission, Microfiche ed. 44. Federal Opinion on the Need for an Indian Treaty Study, House Report No. 1044, 89-1, Serial 12667-2, pages 1067. 45. In land cases, the Indian Claims Commission relied on the area designations employed in Royce, Cessians. Page 382. 261 by recognized title and could now present proof that they had received inadequate payment for its cession. 46. But not until January 1976 did the Indian Claims Commission again take action on Docket 18S. Then it found that Royce Area 261 contained 10,538,000 acres, divided roughly equally between the present states of Michigan and Wisconsin. The Commission, as was usual in these cases, heard detailed and conflicting testimony from the Indians and from the United States about the value of this land as of March 28, 1843, which the Commission selected as the date of proclamation of the treaty. The appraisers for the Chippewas set the surface value of this land at $14,500,000 and the mineral value at $12,784,000, a total of $27,284,000. The Justice Department countered these figures with greatly reduced values from their own appraisers, leaving the commissioners the difficult task of arriving at a decision about the cession's fair market value in 1843. In the end, the commission decided that the surface value had been $7,262,818 and the mineral value, $1,600,000, a total of only $8,862,818. This was a far cry from the more than $27 million claimed by the Indians, but considerably above what the Justice Department had argued for. 47. It was necessary, next, to decide how much the United States had paid to these Indians, following the stipulations of the treaty for cash annuities, goods, and services. The Commission, after deciding what the promised goods and services had been worth, determined that the United States, in the treaty, had agreed to a consideration of $875,000 for the cession. Then it asked how much of this sum had actually been paid to the Indians over the years. The Justice Department lawyers were hard-pressed to produce accurate figures, for vouchers were missing and it was often difficult to separate the monies due under the 1842 treaty from lump sums paid under more than one treaty, and the Commission repeatedly disallowed considerations claimed. In the end, offsets amounting to $346,689.68 were authorized payments for cash annuities, blacksmithing, tribal debts, pay of farmers and carpenters, and education. With the concurrence of the defendant, the Commission on April 28, 1976, had dismissed any claims for gratuitous offsets. The final award, made on November 23, 1977, was $8,516,128.32, divided. 46. Recognized title required a particular act of Congress, a treaty or a statute that declared that the tribe had a permanent legal interest in the land, not merely a title resulting from exclusive aboriginal occupancy. The early deliberations of the Commission are in Decisions of the Indian Claims Commission, 19:31940. 47 Ibid, 37:14692. Page 383. As follows: $5,677,418.88 to the Chippewas of Lake Superior and $2,838,709.44 to the Chippewas of the Mississippi. 48. A second example is the suit brought by the Nez Perce tribe for additional payment for land ceded in the Treaty of June 9, 1863, which it claimed had been paid for at far below the market value of the lands at time of cession. It was accepted that the tribe had recognized title to these lands arising from the Treaty of June 11, 1855. The Commission, from an examination of articles in the treaty with an appraisal of what the non-monetary payments were worth, found that the consideration paid by the United States to the Nez Perce Indians under the treaty amounted to $352,394.94. For this amount the Nez Perces ceded 6,932,270 acres, which the Commission, after breaking down the land into various categories, grazing land, mineral land, timber land, farming land, and the like, determined had a fair market value of $4,650,000 as of April 17, 1867, the date of the proclamation of the treaty. The payment of the government to the tribe for the land was thus found to have been grossly inadequate and unconscionable. The tribe was entitled to recover the difference between the consideration paid and the value of the lands, or $4,297,605.06. From this sum, according to the rules of the Commission, were to be deducted gratuitous payments made to the tribe from the United States Treasury. The attorneys on the two sides reached an out-of-court compromise on the amount of these offsets, namely, $140,000. When this was subtracted, The final judgment on June 17, 1960, allowed the tribe $4,157,605.06. Indian attorneys' fees of $415,760.50 were authorized on April 30, 1962.49. The Indian Claims Commission never achieved the finality in dealing with the claims that its proponents envisaged. The idea was to wipe the slate clean, end the Indians' expectations of large sums of monies due them, and make possible the new initiatives of the Indian Office without the dead hand of past treaty provisions as a hindrance. Senator Watkins wrote in 1957 that a basic purpose of Congress in setting up the Indian 48 Ibid, 41:10229. 49 Ibid, 8:26970, 29,899, 778, 780. Other Nez Perce claims were settled in other dockets, that concerning that 1,855 reservation in docket 175 and that concerning the amount of gold extracted from Nez Perce lands by white intruders in docket 180. An article by an expert witness in the cases is Francis Haynes, The Nez Perce Tribe vs. the United States, Idaho Yesterday's 8, 1825. Page 384. Claims Commission was to clear the way toward complete freedom of the Indians by assuring a final settlement of all obligations real or purported off the federal government to the Indian tribes and other groups. 50. This vision was never fulfilled. Instead of satisfying the Indians, the adversarial proceedings and the limited awards created new Indian dissatisfaction, and the sole remedy of money payments precluded the return of land that the Indians desired. The money's total awards of $818 million were distributed largely in per capita payments and were quickly dissipated. The treaties and their stipulations were not eliminated, they remained as a vital and increasingly important source for a variety of Indian rights. 50 Arthur V. Watkins, Termination of Federal Supervision, the Removal of Restrictions over Indian Property and Persons, Annals of the American Academy of Political and Social Science 311, 50. Page 385. Chapter 16. Treaties before the Supreme Court. The United States Supreme Court, like the Court of Claims and the Indian Claims Commission, relied heavily on treaties in deciding Indian-related cases. The most important single element in the Supreme Court's thought about Indian affairs, one thoughtful historian has concluded, is the crucial importance of treaties, with the result that Indian rights, immunities, and special privileges have been upheld with some consistency. 1. Although conditions in the United States in the 1960s, 1970s, and 1980s in many ways were radically different from conditions in the days when the treaties were negotiated and ratified, and although the Indian tribes themselves were hardly the same communities that signed the treaties, the Supreme Court, by and large, has gone out of its way to protect rights that were either explicitly or implicitly promised in the treaties. The treaties, which reformers at the end of the 19th century considered an obstacle to the progress of the Indians, have turned out, in the late 20th century, to be one of the principal bastions of protection for the lands, the political autonomy, and the hunting and fishing rights of present-day reservation Indians. 2. 1. Robert H. Keller, Jr., William O. Douglas, The Supreme Court, and American Indians, American Indian Law Review 3, No. 2, 33334. 2. The use of treaties by the Supreme Court has been extensively discussed by Charles F. Wilkinson in American Indians, Time and the Law, Native Societies in a Modern Constitutional Democracy, and our conclusions are generally in agreement. Wilkinson is more concerned than I, however, to see how the page 386. Construing Indian Treaties. The principles followed by the Supreme Court and the criteria adopted for construing Indian treaties have again and again been expressly stated by the Court in its decisions. The Court, to be sure, has adamantly upheld the power of Congress to abrogate Indian treaties unilaterally, relying on Lone Wolf v. Hitchcock, but the modern stance of the court has been to insist that Congress's intention to abrogate the provisions of a treaty must be beyond doubt. Absent explicit statutory language, the justices said in 1979, we have been extremely reluctant to find congressional abrogation of treaty rights. Congressional intention to abrogate or modify a treaty must be clear and plain, it is not to be lightly imputed to the Congress. Statutes cannot be construed as abrogating treaty rights in a backhanded way. In sum, the court declared, Indian treaty rights are too fundamental to be easily cast aside. Thus the court, while realizing that the treaties were contracts between two parties, has understood their uniqueness. Point 3. In 1973 the court quoted with approval an earlier decision that asserted, doubtful expressions are to be resolved in favor of the weak and defenseless people who are the wards of the nation, dependent upon its protection and good faith. And treaties were not to be read as an ordinary contract agreed upon by parties dealing at arm's length with equal bargaining positions. When it was a question of grants of land, the treaties were not to be considered as exercises in ordinary conveyancing. Treaties, moreover, were to be interpreted as the Indians would have understood them. Point 4. Court handled the problem of interpreting old and to some extent time-bound treaties and statutes so that they would apply reasonably to the changed circumstances of the tribes and of American society in general in the last half of the 20th century, a major theme of his study. See also the valuable material in Keller, William O. Douglas, 33,345, 35,355, which focuses on a single justice but which nevertheless has much to say about the court's treatment of Indians between 1939 and 1975. For an extended discussion of Supreme Court action on Indian matters that is unduly harsh in its judgment of the court, see Milner S. Ball, Constitution, Court, Indian Tribes, American Bar Foundation Research Journal, 1987, 1140. 3 United States v. Dion, 476 U.S. 73840, with citations of pertinent cases on which the court relied and from which it quoted. 4 McClanahan v. Arizona State Tax Commission, 411 U.S. 17375, Choctaw. Page 387. The standards for determining how a clear and plain intent can be demonstrated have varied from case to case, as the court admitted in 1986 in United States v. Dion. In some cases the court looked for an express declaration of intent to abrogate treaty rights. In others it relied not only on the face of the law but also on the statute's legislative history and surrounding circumstances. Thus, while the court considered explicit statements by Congress preferable, it did not rigidly hold to that preference if other evidence was sufficiently compelling. What is essential, the court declared, is clear evidence that Congress actually considered the conflict between its intended action on the one hand and Indian treaty rights on the other, and chose to resolve that conflict by abrogating the treaty. 5. The result was a series of decisions about land claims, tribal sovereignty and jurisdiction, and hunting and fishing rights that greatly benefited Indian tribes and helped tremendously to re-establish and revitalize Indian reservation communities. It should not be assumed, however, that all this was accomplished without controversy or that the treaty provisions were so clear and plain that unanimity in the courts came as a matter of course. In fact, the provisions in the treaties pertinent to the issues in the cases were frequently vague and seldom spoke precisely to the points that the court needed to decide. Treaties negotiated in the 18th and 19th centuries were usually explicit enough on the issues they were drawn up to provide for. Precise boundaries of cessions were noted, explicit payments to be made were set down, and criminal jurisdictional lines were drawn. But the federal commissioners and the Indian signers of a treaty could not be expected. Nation v. Oklahoma, 397 U.S. 631. The Supreme Court in recent cases has relied on a rich arsenal of previous decisions to show that treaties should be interpreted in favor of the Indians. The question of court action relative to abrogation of treaties is studied thoroughly and competently from a legal standpoint in Charles F. Wilkinson and John M. Volkman, Judicial review of Indian treaty abrogation. As long as water flows, or grass grows upon the earth, how long a time is that? California Law Review 63, 60161. Some of the key decisions on which a liberal interpretation of treaties in favor of the Indians is based are discussed in Russell Lawrence Barsh and James Youngblood Henderson. Contrary jurisprudence, tribal interests in navigable waterways before and after Montana v. United States, Washington Law Review 56, 65154. These authors, however, see a judicial assault on liberal construction of Indian laws and treaties that began in 1978. See also Craig A. Decker, The Construction of Indian Treaties, Agreements, and Statutes, American Indian Law Review 5, No. 2, 299,302. 5476 U.S. 73940. The court provides references to cases upholding these principles. Page 388. To have foreseen the radically changed circumstances brought about by the final military subjugation of the tribes, the successful attacks of reformers on tribalism and tribal reservations, and the later commitments to protect and reinstitute Indian rights. And it is within these new circumstances that the justices of the Supreme Court have had to read and construe the treaty provisions. It is no wonder that no incontrovertible rule of law has been established with regard to Indian rights based on Indian treaties. Instead, there have been frequent reversals of lower court decisions and numerous strong dissenting opinions in the Supreme Court itself. Of the 25 Supreme Court cases between 1959 and 1986 that turned in some way upon treaty provisions, 19 reversed lower court decisions. Only 12 of the decisions were unanimous, 6 cases had 3 dissenting justices, 5 had 2 dissenters, and 2 had a single dissenter. The outcomes thus rested often enough upon a somewhat shaky base. Land questions. Because the Indian Claims Commission had been set up in part to adjudicate Indian land issues, few Indian cases dealing specifically with land reached the Supreme Court. But those that did were of considerable importance. The most important, at least in terms of the size of the compensation awarded for loss of lands, was the case dealing with Sioux claims to the Black Hills, United States v. Sioux Nation of Indians, decided on June 30, 1980.6. The issue was whether the Sioux tribe was due compensation with interest for the taking of the Black Hills by the agreement of 1876 in violation of the 3/4 vote provision of the Fort Laramie Treaty of 1868. The Black Hills was a region of special value to the Sioux because it was considered a religious site. 7. 448 U.S. 371,437. 7. The court treats the history at considerable length, Ibid. 37,484, and there is a brief account in Francis Paul Prucha, The Great Father, the United States Government and the American Indians, 2 volumes, 2:63233, which I follow here. See also Stephen Cosby Hanson, United States v. Sioux Nation, Political Questions, Moral Imperative and the National Honor, American Indian Law Review 8, No. 2, 45984. A recent study, which treats the complex legal maneuverings and the varying Indian views in the long history of the case, is Edward Lazarus. Page 389. The Sioux carried on a long struggle to get just compensation for this loss of land. In 1920 Congress passed a special jurisdictional act allowing adjudication of the claim, but the Court of Claims dismissed the case. After a good deal of legal sparring, involving the Indian Claims Commission and the Court of Claims, Congress authorized the Court of Claims to review the merits of the case, and that court held in 1979 that the Sioux were entitled to an award of interest at an annual rate of 5% on a principal sum of $17.5 million, dating from 1877. In the same year, the Supreme Court agreed to accept the case in order to review the important constitutional questions presented by this case, questions not only of long-standing concern to the Sioux, but also of significant economic import to the government. 8. Much of the court's opinion concerned questions of court jurisdiction and procedure, but the substantive issue was at last decided. Sioux Nation, the court recognized, closely paralleled Lone Wolf v. Hitchcock, which had been decided against the Indians. Now it was at pains to show why the Sioux case differed from Lone Wolf. In the earlier case, the court had found that Congress had purported to give adequate compensation and that it had merely changed the form of investment of Indian tribal property. The court had then relied on the principle that Congress had full power and had acted in good faith, and it said that the Indians should seek relief from Congress, not the courts. In the 3/4 of a century between the two cases, a new atmosphere had developed that made impossible a repetition of such findings. By an 8-1 majority, the justices in 1980 accepted the Indians' plea and supported the earlier conclusion of the Court of Claims by declaring, "The terms of the 1877 Act did not effect a mere change in the form of investment of Indian tribal property. Rather, the 1877 Act effected a taking of tribal property, property which had been set aside for the exclusive occupation of the Sioux by the Fort Laramie Treaty of 1868. That taking implied an obligation on the part of the government to make just compensation to the Sioux Nation, and that obligation, including an award of interest, must now, at last, be paid." 9. Black Hills, White Justice, the Sioux Nation versus the United States, 1775 to the present. 8448 U.S. 390. There is a discussion of the jurisdictional questions, 38490. Lazarus, Black Hills, White Justice, is especially good on this matter. 9448 U.S. 42324. Page 390. The determination that United States acquisition of the Black Hills, to the value of $17.5 million, was a taking under the terms of the Fifth Amendment and required interest as well as the principal, meant that the Sioux were awarded $105 million. Ironically, after the decades of complicated and frustrating struggle by the tribe's lawyers, who had finally won out against the lawyers of the Justice Department, the Oglala Sioux refused to accept the award. They demanded the return of their sacred land and would not give up that claim in return for money. 10. A quite different land issue from that in Sioux Nation was at stake in Choctaw Nation v. Oklahoma, decided a decade earlier, on April 27, 1970.11. Here the court had to analyze early treaties to see what the intent of the United States government had been in granting lands to the Choctaws and the Cherokees in what is now Oklahoma. Did the treaties and subsequent patents based on the treaties convey ownership of the riverbed of the Arkansas River to the tribes, or did that ownership remain with the federal government for conveyance to Oklahoma when it became a state in 1907? Oklahoma argued that by accepted standards of ordinary conveyancing, the land descriptions in the treaties, standing alone, actually exclude the riverbeds. The court, after a long discussion on the provisions of the Treaty of Dancing Rabbit Creek with the Choctaws, the Treaty of New Echota with the Cherokees, and the nature of the grants of land to these tribes, retorted that these treaties were not to be considered as exercises in ordinary conveyancing. The Indian nations, the court said, did not seek out the United States and agree upon an exchange of lands in an arm's-length transaction. Rather, treaties were imposed upon them and they had no choice but to consent. Because of such circumstances, the justices insisted that the treaties had to be interpreted as the Indians would have understood them and that any doubtful expression in them should be resolved in the Indians' favor. It noted, moreover, that the Treaty of Dancing Rabbit Creek itself had provided that in the construction of this treaty, wherever well-founded doubt shall arise, it shall be construed most favorably towards the Choctaws. 12. Much of the opinion was devoted to an examination of the historical record to determine how the Indians would have interpreted the treaties. To counter the claim of Oklahoma that the United States had reserved 10. See Lazarus, Black Hills, White Justice, Chapter 17, for a discussion of the post-decision history and the Oglala refusal to give up their claims to the Black Hills. 11,397 US 62,054. 12 Ibid, 628, 63,031. The court cited earlier opinions on this same point. Page 391. The riverbeds of navigable rivers to itself so that it could convey them to a future state. The court relied on a provision in the Choctaw Treaty that no part of the land granted them should ever be embraced in a territory or state. In the light of this promise, the court asserted, it is only by the purest of legal fictions that there can be found even the semblance of an understanding, that the United States retain title in order to grant it to some future state. 13. The court was split 4-3, however, and a vigorous dissenting opinion argued that numerous precedents supported the principle that navigable rivers and their beds were under the sovereignty of the federal government, and that for the Indians to prevail in the case there must be found in their grant a very plain basis for concluding that the United States intended to convey an interest in the river bed. The dissenting justices declared that neither the patents nor the treaties satisfied that standard. 14 The difficulties in interpreting intent arose because the treaties and other documents are silent about the precise point at issue. Neither the treaties nor the patents mentioned the riverbed of the Arkansas River. The problem arose again in a similar case, Montana v. United States, which was decided on March 24, 1981, against the Indians. Here the question was whether the Crow Indians owned the riverbed of the Big Horn River. The majority of the court argued that title to land under navigable rivers could be presumed to rest in the United States, which held it in order to give it to future states. 15 The Treaty of Fort Laramie of 1868, which had initially set up the Crow Reservation astride the Big Horn River, did not expressly refer to the riverbed, and the court this time found that whatever property rights the language of the 1868 treaty created, its language is not strong enough to overcome the presumption of federal ownership. The court held that because a riverbed was within the reservation boundaries did not automatically mean tribal ownership of it. Nor did the treaty provision granting absolute and undisturbed use and occupation of the reservation give the Indians exclusive right to occupy all the territory within the described boundaries. 16. 13 Ibid, 635. The Choctaw Treaty provision is in Kapler, 2:311, a similar phrase was included in the Cherokee Treaty, Ibid, 442. 14,397 US 648. The full dissent covers pages 64,354. 15,450 US 54,481. 16 Ibid, 55,455. Page 392. The majority of the court, of course, could not avoid considering the opposite conclusion reached a decade earlier, and in a footnote to the opinion argued that Montana differed from Choctaw Nation v. Oklahoma. Neither the special historical origins of the Choctaw and Cherokee treaties nor the crucial provisions granting Indian lands in fee simple and promising freedom from state jurisdiction in those treaties, the justices said, have any counterparts in the terms and circumstances of the Crow treaties of 1851 and 1868-17. Those differences did not convince the three justices who entered a dissenting opinion. The dissenters restated the principle that treaties were to be construed as the Indians understood them and argued that the Crows certainly thought that they controlled the rivers that lay entirely within the reservation set up in 1868.18. Other land cases considered whether or not Indian reservations established by treaties had subsequently been reduced or entirely given up. Here was a question of continuing reservation status, which demanded a careful study of the treaties that had established or guaranteed Indian ownership of land and of later acts that might have diminished the Indian lands and consequently jurisdiction over them. In 4 cases, the Supreme Court decided that reservation rights claimed by the Indians no longer existed. The first of these was Federal Power Commission v. Tuscarora Indian Nation, of March 7, 1960.19. It was a sticky case early in the new era and was decided by a 6-3 majority. The question was whether the United States under amendments to the Federal Power Act of 1935 could take Tuscarora lands for a reservoir. The argument turned on whether the Treaty of Fort Stanwix, the Treaty of Fort Harmar, and the Treaty of Canandaigua, all of which protected rights in land, applied to the Tuscaroras in this case, as the Indians argued. The court decided in favor of the Federal Power Commission against the Indians on the basis that the Tuscaroras' lands were not a reservation in the sense that Indian reservations were excluded under the Federal Power Act. 20. 17 Ibid. 55556 N. 18 Ibid. 56981. Indians have retained riverbeds to navigable rivers by decisions of lower federal courts not considered by the Supreme Court. See Wilkinson, American Indians, Time and the Law, 51 and 170, n. 90. Montana v. United States also concerned tribal jurisdiction over non-Indians and aroused strong criticism, see references below in Note 49. 19362 U.S. 99142. 20 The treaties are in Kapler, 256, 2325, 3437. Page 393. In a somewhat involved argument, tucked away in a footnote, the Supreme Court declared that the first two treaties related to other lands and principally to other Indian tribes, and that the third treaty, though covering the lands in question, had been made with the Seneca Indians. These Indians, in a contract of 1797 and with the approval of the United States, had sold their interest in the lands to Robert Morris, thus freeing them from the effects of the Treaty of Canandaigua. Morris in turn had sold the lands to the Holland Land Company, which conveyed the area in question to the Tuscarora Nation in fee simple. The Indians' title, then, rested upon the conveyance from Morris, not on any treaty. So the court decided that the Federal Power Commission was authorized to take the lands with a just compensation because the lands in question are not subject to any treaty between the United States and the Tuscaroras. 21. The majority opinion called forth a strong dissent, which foreshadowed later, more liberal interpretations of treaty rights. The minority, led by Justice Hugo L. Black, held that the lands of the Tuscaroras were a reservation and therefore protected, and it argued that the Treaty of Canandaigua did apply to the Tuscaroras. In an eloquent statement, Black wrote, "The solemn pledge of the United States to its wards is not to be construed like a money-lender's mortgage. Up to this time it has always been the established rule that this court would give treaties with the Indians an enlarged interpretation, one that would assure them beyond all doubt that this government does not engage in sharp practices with its wards." At the end Black said, "I regret that this court is to be the governmental agency that breaks faith with this dependent people. Great nations, like great men, should keep their word." 22. In later cases, less emotionally charged but still matters of controversy among the justices, the court again decided that reservation or tribal status had been ended and that consequently the treaty rights originally enjoyed by the Indians in question no longer applied. In Decato v. District County Court for the 10th Judicial District, March 3, 1975, the court decided that part of the Lake Traverse Indian Reservation had lost its Indian country status by an agreement of 1889 ratified by Congress in 1891.23, a treaty of 1867 between the United States and the Sisseton and Wahpeton bands of the Sioux had set up the original reservation. Although the majority opinion declared that this court 21-362 U.S. 12123 N. 123. 22 Ibid. 13738, 142. 23-420 U.S. 42568. Page 394. Does not lightly conclude that an Indian reservation has been terminated, it nevertheless decided that the law of 1891, providing for the sale of unallotted lands, had thereby reduced the reservation. The dissenting opinion of Justice William O. Douglas, in which he was joined by two other justices, insisted that the sale of lands had in no way altered the boundaries of the original reservation and that the tribes still had jurisdictional rights within those boundaries. 24. Delaware Tribal Business Committee v. Weeks, of February 23, 1977, involved a group of Delaware Indians who had remained in Kansas when other groups of the tribe moved to Oklahoma in 1866.25. These Kansas Delawares wanted to share in an award made by the Indian Claims Commission for violation of a treaty of 1854 with the Delawares, but the court declared that by the removal treaty of 1866 these Indians had lost their status as tribal members and become simply individual citizens. The opinion analyzed the 1866 treaty in some detail, and only one justice dissented. 26. In Rosebud Sioux Tribe v. Neep, Governor of South Dakota, April 4, 1977, the document in question was not strictly a treaty but rather an agreement that postdated the end of treaty making in 1871.27. The agreement of 1889, which reduced the Great Sioux Reserve and set up 6 separate reservations including Rosebud, was considered by the court as though it had been a treaty, and in fact twice in the opinion the agreement is called the 1889 Treaty. The court asked whether Congress in laws of 1904, 1907, and 1910 intended to reduce the Rosebud Reservation as set up in 1889. Relying on the precedent of Lone Wolf v. Hitchcock, the court declared, "We conclude that, although the acts of 1904, 1907, and 1910 were unilateral acts of Congress without the consent of 3/4 of the members of the tribe required by the original treaty, that fact does not have a bearing. What was compelling to the justices was the clear intent of Congress to exercise its plenary power in abrogating treaty provisions." As might be expected, in a decision that appeared to go against Indian treaty rights, 3 justices joined in a dissenting opinion. They maintained that the court had obliterated distinctions made in Decato and by holding against the tribe when the evidence concerning congressional intent is 24 Ibid, 444, 44,960, 46,061. 25 430 U.S. 7,398. 26 The treaties in question are in Kapler, 2:61418, 93,742. 27 430 U.S. 584,633. Page 395. Palpably ambiguous had eroded the generally accepted principles of interpreting Indian statutes. They could find no express provision establishing the reservation. 28. Treaty rights entered only indirectly, as a sort of fundamental basis for Indian land claims, in cases involving the Oneida Indians, who claimed land that allegedly had been ceded invalidly to the state of New York. The Cessians went against the Indian Trade and Intercourse Law of 1790, which prohibited sale of Indian lands to any state, unless the contract had been made at a public treaty held under the authority of the United States. 29 Treaties were relevant to the Oneida claims in confirming the original rights of the Indians to the lands in question. In Oneida Indian Nation of New York v. County of Oneida, New York, decided on January 21, 1974, the court discussed the importance of treaties at great length. 30 The federal government, it said, took early steps to deal with the Indians through treaty, the principal purpose often being to recognize and guarantee the rights of Indians to specified areas of land. This was the case with the Oneidas and other New York Indians, and the applicable treaties are listed in a footnote. In further historical analysis, the court noted that the possessory and treaty rights of Indian tribes to their lands have been the recurring theme of many other cases. 31. Yet the crux of the case was not treaty rights but whether the transfer of lands to New York had been validly made, and litigation on that point continued during the next decade. When the Supreme Court considered the matter again in County of Oneida v. Oneida Indian Nation, March 4, 1985, it upheld by a 5-4 majority the tribe's federal common law right of action for unlawful possession of the lands, which was not barred by any statute of limitations, so the tribal position that it could sue in federal courts was upheld. 32. Jurisdictional questions. The question of diminution or termination of reservation status was not always essentially one of land ownership. At stake as well was tribal jurisdiction over the lands in question, perhaps a more. 28 Ibid, 587, 618. 29 1 Stat 138. 3414 US 66184. 31 Ibid, 667, 669. A footnote cites earlier cases. 32 470 US 22673. Page 396. Important question then that of property rights. Treaties had provided not only land rights but political autonomy for the tribes, a kind of semi-sovereignty at least within the boundaries of their reservations. The Supreme Court has clearly recognized the importance of this second aspect of the treaties in its decisions. Problems arose when states extended their jurisdiction over the Indian reservations. Wanting their sovereignty to extend over all the lands within their boundaries, states taxed and regulated activities within the Indian lands. The Supreme Court from time to time was called upon to decide whether such state action was proper. In its consideration about how and to what extent state laws were excluded from reservations, two lines of thought were evident. State jurisdiction was excluded if jurisdiction had been preempted by the federal government, which had a special responsibility toward the Indians and the Indian reservations. But another question also was asked: did the state action interfere with the legitimate exercise of authority by tribal governments? In revitalizing tribal governmental authority over reservations and their inhabitants, the court's decisions played a significant role. An interpretation of treaties was a vital part of its decision-making. The treaty between the United States and the Navajo Nation signed in 1868 was the basis for a number of significant decisions upholding Indian tribal jurisdiction. This treaty had ended the Indians' exile at the Bosque Redondo on the Pecos River in eastern New Mexico and, in return for a promise of peace, had provided a reservation for the Navajos in their old homeland. In Article 2, the treaty specified in some detail the exclusiveness of the reservation. Set apart for the use and occupation of the Navajo tribe of Indians, and for such other friendly tribes or individual Indians as from time to time they may be willing, with the consent of the United States, to admit among them, and the United States agrees that no persons except those herein so authorized to do, and except such officers, soldiers, agents, and employees of the government, or of the Indians, as may be authorized to enter upon Indian reservations in discharge of duties imposed by law, or the orders of the President, shall ever be permitted to pass over, settle upon, or reside in, the territory described in this Article. 33. The first important case to rely upon the protection of tribal autonomy expressed in this treaty article was Williams v. Lee, decided on 33 Kapler, 2:1016. Page 397. January 12, 1959, a case that opened the modern era of Federal Indian Law 34. The case concerned a suit by a non-Indian to enforce a debt incurred by Indians on the Navajo Reservation, entered in the Apache County Superior Court of Arizona. The Supreme Court decided that the case, instead, fell exclusively within the tribal courts, so that tribal self-government could be protected and promoted. From a reading of Article 2 of the 1868 Treaty, the court found implicit in the treaty terms the understanding that the internal affairs of the Indians remained exclusively within the jurisdiction of whatever tribal government existed. It compared the treaty with the Cherokee treaties involved in Worcester v. Georgia, and it noted that Congress and the Bureau of Indian Affairs had assisted in strengthening the Navajo tribal government and its courts. The court expressly remarked that the 1871 law ending treaty making did not impair the obligations in existing ratified treaties and that thus the 1868 treaty with the Navajos survived this Act 35. In reversing the decision of the Supreme Court of Arizona, which had upheld the jurisdiction of the Apache County Superior Court, the unanimous opinion of the United States Supreme Court concluded, the cases in this court have consistently guarded the authority of Indian governments over their reservations. Congress recognized this authority in the Navajos in the Treaty of 1868, and has done so ever since. If this power is to be taken away from them, it is for Congress to do it. 36. It was a bold and auspicious beginning of the modern era. Williams was followed in April 1965 by Warren Trading Post Co. v. Arizona Tax Commission, which again, in a unanimous decision, reversed the Supreme Court of Arizona on an issue of tribal versus state jurisdiction on the Navajo Reservation. 37 The court denied the authority of the state of Arizona to tax the Warren Trading Post, a business run by non-Indians on the reservation. It did so on the basis that the federal government, not states, controlled Indian trade. As in Williams, the court relied on the Navajo Treaty of 1868. The Navajo Reservation was set apart as a permanent home for the Navajos in a treaty made with the Navajo Nation or Tribe of Indians on June 1, 1868. Long before that, in fact from the very 358 U.S. 21,723, the quotation is from Wilkinson, American Indians, Time and the Law, 1. Wilkinson gives reasons for considering the case a watershed on 358 U.S. 22,122, 221 N. 36 Ibid, 223. 37 380 U.S. 68,592. Page 398. First days of our government, the federal government had been permitting the Indians largely to govern themselves, free from state interference, and had exercised through statutes and treaties a sweeping and dominant control over persons who wished to trade with Indians and Indian tribes. 38. Similarly, in McClanahan v. Arizona State Tax Commission, of March 27, 1973, the court ruled that the Arizona income tax did not apply to an Indian whose income was wholly derived from reservation sources. 39 The argument was based chiefly on the self-governing powers of the Navajo Indians as set forth in the Treaty of 1868, and there was heavy reliance on Williams v. Lee. The court refused to place principal reliance simply on the sovereignty of the tribe. However, the trend, it said, has been away from the idea of inherent Indian sovereignty as a bar to state jurisdiction and toward reliance on federal preemption. The modern cases thus tend to avoid reliance on Platonic notions of Indian sovereignty and to look instead to the applicable treaties and statutes which define the limits of state power. In McClanahan, the Indian sovereignty doctrine did not provide a definitive resolution of the case but rather a backdrop against which to read applicable treaties and federal statutes. 40. Following this principle, the court ruled that Arizona had exceeded its lawful authority in taxing the appellant. Turning at once to the 1868 treaty, the justices stated, the treaty nowhere explicitly states that the Navajos were to be free from state law or exempt from state taxes. But the document is not to be read as an ordinary contract agreed upon by parties dealing at arm's length with equal bargaining positions. In such circumstances, the court adopted the rule from Carpenter v. Shaw that doubtful expressions are to be resolved in favor of the weak and defenseless people who are the wards of the nation, dependent upon its protection and good faith. 41. 38 Ibid, 68,687. The opinion cites the treaty with the Delawares in 1778 and notes similar provisions in other early treaties. It again declared that the law of 1871 left the obligations of existing treaties unimpaired. 39 411 U.S. 16,481. 40 Ibid, 172. 41 Ibid, 174. The question of limiting state jurisdiction over tribes was faced also in Metlakatla Indian Community v. Egan, Governor of Alaska, March 5, 1962, which upheld the power of the Secretary of the Interior to protect Indian fishing rights against state authority. The decision of the court was based on a law of 1891, not on treaties, but it cited at length treaties that had expressly excluded state laws, using them as an analogy in the present case. Page 399. More remarkable, because of the boost it gave to the doctrine of retained inherent sovereignty of Indian tribes, was United States v. Wheeler, decided on March 22, 1978.42. The question before the court was whether the double jeopardy clause of the Fifth Amendment barred prosecution of a Navajo Indian in a federal court because he had been convicted earlier in a tribal court of a lesser included offense arising from the same incident. Accepting the doctrine of inherent tribal sovereignty set forth by Felix S. Cohen, a sovereignty antedating the United States government and not resting on a grant of authority from Congress, the Supreme Court ruled that there was no double jeopardy because the two courts were arms of separate and distinct sovereigns. It admitted that by treaties and by statutes some elements of Indian sovereignty had been taken away, but until Congress acts, it said, tribes retain their existing sovereign powers. An examination of the treaties made with the Navajos in 1849 and in 1868 showed that neither of them deprived the tribe of its own jurisdiction to charge, try, and punish members of the tribe for violations of tribal law. The court reinforced its decision by quoting from Williams v. Lee, implicit in these treaty terms was the understanding that the internal affairs of the Indians remained exclusively within the jurisdiction of whatever tribal government existed. 43. The court also cited Warren Trading Post and laws and other previous cases that showed the same retention of tribal powers. If tribal criminal jurisdiction extended to tribal members on a reservation as a part of inherent sovereignty, however, it did not extend to non-members. In a case decided 2 weeks before Wheeler, the Supreme Court placed a sharp restriction on tribal criminal authority over non-Indians living on a reservation. The case of Oliphant v. Suquamish Indian Tribe, March 6, 1978, concerned Mark Oliphant, a non-Indian residing on the Port Madison Reservation in the state of Washington, who had been arrested by tribal authorities, charged with assaulting a tribal officer and resisting arrest. 44. Oliphant claimed he was not subject to tribal authority. The Supreme Court, overturning the decision of the United States Court of Appeals for the Ninth Circuit, voted against the 42-435 U.S. 31,332. The question of Indian sovereignty is expertly discussed in Arthur Lazarus, Jr., Tribal Sovereignty Under United States Law, in William R. Swaggerty, ed., Indian Sovereignty, Proceedings of the Second Annual Conference on Problems Concerning American Indians Today, 2846. 43-435 U.S. 32,324. 44-435 U.S. 191,212. Page 400. Tribes' contentions that its jurisdiction flowed automatically from its retained inherent powers of government over the reservation. The justices in the majority opinion in the 6-2 decision discussed at length the history of Indian courts and of laws and cases that showed a common understanding that non-Indians were not to be tried in Indian courts, taking the Choctaw Treaty of 1830 as an example of non-jurisdiction. Then they turned to the Treaty of Point Elliott, which had set up the reservation in question. Noting the Indians' acknowledgement of their dependence on the government of the United States and their agreement not to shelter or conceal offenders against the laws of the United States, but to deliver them up to the authorities for trial, the justices declared, somewhat lamely, by themselves, these treaty provisions would probably not be sufficient to remove criminal jurisdiction over non-Indians if the tribe otherwise retains such jurisdiction. But an examination of our earlier precedents satisfies us that, even ignoring treaty provisions and congressional policy, Indians do not have criminal jurisdiction over non-Indians absent affirmative delegation of such power by Congress. 45. Indian tribes considered Oliphant a damaging blow to their sovereign revival, and it showed the problems of relying on the provisions of ancient treaties to determine issues arising in very changed modern circumstances. 46. Two justices, 2, dissented from the court's opinion. Justice Thurgood Marshall, who wrote the dissent, agreed with the Court of Appeals that the power to preserve order on the reservation is a sine qua non of the sovereignty that the Suquamish originally possessed. Without an affirmative withdrawal of that power in a treaty or statute, he asserted, Indian tribes enjoy as a necessary aspect of their retained sovereignty the right to try and punish all persons who commit offenses against tribal law within the reservation. 47. But the court did not relent. In Montana v. United States, it extended the ruling of Oliphant to strike down tribal authority to 45 Ibid, 2068. The court may well have been influenced by the circumstances of the Port Madison Reservation noted in a footnote to the opinion. 63% of the land on the reservation was owned in fee simple by non-Indians, and there were nearly 3,000 non-Indians living within the reservation boundaries, compared with approximately 50 Indians. 46 references to opposition to the opinion are noted in Prucha, Great Father, 2:1189 n. 47 435 U.S. 212. 28. United States Indian Peace Commission, 1868. To ease the crisis of wars and unrest on the Indian frontiers, Congress in 1867 established an Indian Peace Commission, made up of important civilians and high-ranking military officers, which was empowered to sign treaties with the tribes. This photograph of members of the commission was taken at Fort Laramie in 1868. Left to right, it shows General Alfred H. Terry, General William S. Harney, General William T. Sherman, Commissioner of Indian Affairs, Nathaniel G. Taylor, Samuel F. Tappan, and General C. C. Augur posing with an unidentified Indian woman. The commission dealt with Southern Plains tribes at Medicine Lodge Creek, with Northern Plains tribes at Fort Laramie, with the Navajos at Fort Sumner, and with the Shoshones and Bannocks at Fort Bridger. 29. Medicine Lodge Creek Council, October 1867. 30. Satank. 31. Satanta. The Indian Peace Commission met with the Kiowas, Comanches, Apaches, and Southern Cheyennes and Arapahoes at Medicine Lodge Creek in southern Kansas and procured treaties of peace and advancement in civilization. Satank and Satanta, two Kiowa chiefs, signed the treaties, but they would not stay confined to the reservations assigned to them at Medicine Lodge Creek. 32. Peace Commissioners Camp, Medicine Lodge Creek. The Peace Commission traveled with a large retinue, and it was joined at Medicine Lodge Creek by a corps of journalists, who covered the events in great detail for their readers. This scene of the Commissioners' camp was painted by Herman Stiefel, a private of the 5th Infantry. 33. Fort Laramie Treaty Council, 1868. The photographer Alexander Gardner took numerous pictures at the Fort Laramie Council. This one shows the full commission talking with Indians under a rough canopy, or council lodge made of buffalo skins. 34. Red Cloud. The Sioux leader Red Cloud refused to sign the Fort Laramie Treaty until the United States military posts along the Bozeman Trail in the Powder River Valley were abandoned, as the treaty promised. He ultimately signed the treaty at the Fort Long, after the commission had departed. This fine portrait of the chief was taken by Gardner in Washington, D.C. in 1872. 35. Barboncito. 36. Washakie. Members of the Indian Peace Commission, after signing the Fort Laramie treaties in 1868, also made treaties in the summer of that year with the Navajos at Fort Sumner, and with the Shoshones and Bannocks at Fort Bridger. Barboncito was the first to sign the Navajo Treaty, Washakie the first to sign for the Shoshones. 37. Shoshone Delegation in Washington, D.C., 1880. Delegates from the Lemhi and Fort Hall agencies signed an agreement on May 14, 1880. With them in this formal photograph by C.M. Bell are the Indian agent and an interpreter. 38. Henry L. Dawes. Henry L. Dawes, after he retired from the Senate, headed the Dawes Commission, which signed agreements with the 5 civilized tribes in the Indian Territory for the allotment of their lands. 39. James McLaughlin. James McLaughlin, a longtime Indian agent who was respected by the Indians, was appointed Indian Inspector in 1895. In that office he concluded numerous agreements with Western tribes. 40. Muckleshoot Treaty Rights March, 1966. 41. Anti-Bolt Demonstration, 1974. On the basis of treaties signed with Isaac I. Stevens. In the mid-1850s, Indians in Washington state more than a century later began to assert their fishing rights, with fish-ins and protest marches. When Federal District Judge George Bolt upheld their rights and authorized them to take up to 50% of the harvestable fish, angry white protesters condemned Bolt and his decision. 42. Treaty Beer. In Wisconsin, federal court decisions in favor of Chippewa spear fishing in areas ceded by 19th century treaties produced a tremendous white backlash, for people objected to Indians receiving special treatment. To raise money to fight the Indians' protected rights, one group sold treaty beer, with anti-Indian messages on the cans. Sometimes violent crowds gathered to protest and obstruct the spearfishing. 43. Protest against Chippewa spearfishing, 1991. Page 401. Regulate hunting and fishing of non-Indians on reservation lands owned in fee simple by non-members of the Crow tribe. 48. It looked at the Treaty of Fort Laramie of 1851, which nowhere suggested that Congress intended to grant authority to the Crow tribe to regulate hunting and fishing by non-members on non-member lands, and at the Treaty of Fort Laramie of 1868, which arguably conferred upon the tribe the authority to control fishing and hunting on the reservation. But it concluded that authority could only extend to land on which the tribe exercises absolute and undisturbed use and occupation. If the 1868 treaty created tribal power to restrict or prohibit non-Indian hunting and fishing on the reservation, that power cannot apply to lands held in fee by non-Indians. The court noted the Indians' argument that it had inherent sovereignty, but turned it aside with the remark that inherent sovereignty is not so broad as to apply to non-Indian lands. 49. While these decisions cut back broad extensions of tribal jurisdiction over non-Indians, an earlier case, Morton v. Mancari, decided unanimously on June 17, 1974, had extended the principle of special treatment of Indians by the United States government. 50. The case was brought against the Secretary of the Interior by non-Indian employees of the Bureau of Indian Affairs who claimed that preferential hiring of Indians was contrary to the Equal Employment Opportunity Act of 1972 and that such preference deprived them of property rights without due process of law. In reversing the decision of the United States District Court for the District of New Mexico, the Supreme Court rejected the idea of racial preference and declared that the preference was granted to the Indians not as a discrete racial group, but, rather, as members of quasi-sovereign tribal entities whose lives and activities are governed by the BIA in a unique fashion. The resolution of the case turned on the unique legal status of Indian. 48. 450 U.S. 54,481. 49. Ibid. 55,859, 563. There has been strong negative reaction to Montana because of the restrictions it put upon tribal jurisdiction and because the court seemed to ignore the principle that treaties were to be construed as they would have been understood by the Indians. See, for example, the bitter attack on the decision that appeared in Barsh and Henderson, contrary jurisprudence, 68,485, and Sarah Arnott, in the aftermath of the Bighorn River decision, Montana has title, Indian Law Doctrines Are Clouded, and Trust Questions Remain, Public Land Law Review 2, 156. 5417 U.S. 53555. C. Brian Douglas Baird, Morton v. Mancari, New Vitality for the Indian Preference Statutes, Tulsa Law Journal 10, No. 3, 45462. Page 402. Tribes under federal law and upon the plenary power of Congress, based on a history of treaties and the assumption of a guardian ward status, to legislate in behalf of federally recognized Indian tribes. 51. Hunting and fishing rights. A liberal interpretation of treaty rights was nowhere more evident than in the vindication of tribal hunting and fishing rights. The most remarkable developments came in the state of Washington, where state action to limit or prohibit Indian fishing for salmon and steelhead trout brought an outbreak of protests. The famous fish-ins of 1964, in which groups of Indians determined to continue fishing in opposition to state laws. This widely publicized agitation was soon followed by a series of court decisions. 52. The basis for the Indians' claims was the series of treaties negotiated with the Pacific Coast Indians by Isaac I. Stevens, governor of Washington Territory, in the 1850s. The one principally relied upon was the Treaty of Medicine Creek, signed on December 26, 1854, with chiefs, headmen, and delegates of the Nisqually, Puyallup, Steilacoom, and other tribes, which for the purposes of the treaty were regarded as one nation. The important statement for the courts more than a century later was Article 3, which said in part, the right of taking fish, at all usual and accustomed grounds and stations, is further secured to said Indians in common with all citizens of the territory. 53. When the treaties were signed, there was a great abundance of fish and few whites for the Indians to contend with, but by the middle of the 20th century, as the resources were threatened with depletion, the rights enunciated so vaguely in the treaties assumed new and vital importance. 51 417 U.S. 551, 55,354, emphasis added. The court based this plenary power on constitutional provisions, the Commerce Clause, and the power of the President, by and with the advice and consent of the Senate, to make treaties. 52 useful studies of the fishing rights issue in the state of Washington are two reports prepared for the American Friends Service Committee, Uncommon Controversy, Fishing Rights of the Muckleshoot, Puyallup, and Nisqually Indians, and Fay G. Cohen, Treaties on Trial, The Continuing Controversy Over Northwest Indian Fishing Rights. 53 Kapler, 2:662. Similar provisions appeared in the Treaty of Point Elliott, January 22, 1855, the Treaty of Point No Point, January 26, 1855, and the Treaty of Knee Bay, January 31, 1855. Ibid, 670, 674, 682. Page 403. Two earlier decisions of the Supreme Court had pointed the way. In 1904 the court had ruled that Indians could not be barred from their usual fishing sites and that they had easements over both public and private lands to get there. And in 1942, the court had declared that the state could not regulate off-reservation Indian fishing. 54 It was a series of cases extending for a little more than a decade, however, that newly examined the treaties in great detail and in the end, by a remarkably elastic reading of the provisions, came down firmly on the side of existing Indian rights. There was continual sparring with the state of Washington, which insisted on its right to regulate Indian fishing in the interests of conservation. The first case to reach the United States Supreme Court was Puyallup Tribe v. Department of Game of Washington, decided on May 27, 1968.55. Citing the Treaty of Medicine Creek, the court renewed its vindication of the right of the Indians to fish off-reservation at accustomed sites. It quoted United States v. Winans, to construe the treaty as giving the Indians no rights but such as they would have without the treaty. would be an impotent outcome to negotiations and a convention, which seemed to promise more and give the word of the nation for more. But the court accepted the authority of Washington to restrict the type of fishing done by the Indians. It assumed that nets were used by the Indians at the time the treaty was signed and that there were commercial aspects to the fishing. But the manner in which fishing may be done and its purpose, the opinion said, are not mentioned in the treaty. We would have quite a different case if the treaty had preserved the right to fish at the usual and accustomed places in the usual and accustomed manner. But the treaty is silent as to the mode or modes of fishing that are guaranteed. 56. In 1973 the issue again reached the Supreme Court in Department of Game of Washington v. Puyallup Tribe, November 19, 1973.57. The state of Washington had barred all Indian net fishing of steelhead trout because those who engaged in sport fishing, with hook and line, caught all the steelhead that could be taken under conservation. 54. United States v. Winans, 198 U.S. 37,184, Tully v. State of Washington, 315 U.S. 68,185. 55. 391 U.S. 392,403. 56. Ibid, 397, 398, emphasis is in the original. 57. 414 U.S. 4,450. Page 404. Measures. On the basis of the Treaty of Medicine Creek, the United States Supreme Court reversed the decision of the Supreme Court of Washington, which it ruled had discriminated against the Indians. It did not deny, however, that conservation measures might be necessary to prevent the extinction of the species. We do not imply, it said, that these fishing rights persist down to the very last steelhead in the river. The police power of the state is adequate to prevent the steelhead from following the fate of the passenger pigeon, and the treaty does not give the Indians a federal right to pursue the last living steelhead until it enters their nets. 58. The conservation issue was faced once more in Puyallup Tribe Incorporated v. Department of Game of Washington, decided on June 23, 1977, which repeated much about Indian treaty rights that had been worked over in Puyallup I and Puyallup. 2.59. The new issue was the authority of the state to regulate the tribes' on-reservation fishing rights. Although the court vacated the decision of the Supreme Court of Washington that the state could regulate the tribes' fishing on the reservation, it upheld the regulatory authority of the state when regulations were reasonable and necessary for the conservation of fish. Thus the rights of Indians to fish at all usual and accustomed grounds and stations, subject to reasonable conservation regulations of the state, were well established. What was still in question, however, was the precise meaning of the treaty phrases "the right of taking fish and in common with all citizens of the territory." Did they mean that the Indians were entitled to a definite amount or percentage of the catch? In 1970 a group of Indian tribes filed suit in the Federal District Court for the Western District seeking a determination of their rights to a fair share of the fish. After 3.5 years of intensive study, Judge George Bolt wrote a long opinion that thoroughly analyzed the treaties, the migratory patterns of the fish, Indian fishing patterns, and the history of state regulation. Because his findings showed a reduction of Indian rights over the years by state regulation and non-Indian encroachment, Bolt enunciated a set of principles to govern Indian fishing. The treaties reserved fishing rights for Indians that differed from those of other citizens. Off-reservation fishing rights extended to all places that a tribe had customarily fished, and the state could regulate Indian fishing only to the extent needed to conserve fish resources. 60. 58 Ibid, 49. 59. 433 U.S. 16,585. 60. United States v. State of Washington, 384 F. Sub 312,423. I have relied here on page 405. All of that seemed reasonable enough and was in accord with previous judicial decisions. But Bolt took a further step. The Indians' right to take fish in common with the citizens of the territory, he determined, meant not only access to fishing sites but a fair share of the fish, which he ruled was up to 50% of the harvestable number of fish, exclusive of catches used for subsistence or for ceremonial purposes. Non-Indian reaction to this bombshell was violent, and much of the outcry was aimed personally against Bolt, who was accused of racial discrimination. 61 Bolt's decision was confirmed by the United States Court of Appeals, Ninth Circuit, but the United States Supreme Court at the time refused to accept the case for review. The problems of enforcing the decision of the District Court, which the state of Washington refused to do, led to demands for further litigation, and in 1979 the Supreme Court at last agreed to hear the case. In Washington v. Washington State Commercial Passenger Fishing Vessel Association, decided on July 2, 1979, the court in a 6-3 decision upheld the Bolt decision. 62 It reviewed once more the provisions of the Treaty of Medicine Creek to determine what they meant in the light of the expectations at the time the treaty was signed. The tribes did lose, however, by the court's inclusion of fish caught for subsistence and ceremonial uses as well as fish taken within reservation boundaries in the 50% figure. The court also considered the percentage as a maximum, which might be reduced under changing circumstances. That the imprecise terms of the treaty might be construed in different ways was clear from the dissent of Justice Lewis F. Powell and the two other justices who joined him. Powell's interpretation of the treaties gave the Indians access to fishing sites but not a guaranteed percentage of the fish. "I would hold," he wrote, "that the treaties give to the Indians several significant rights that should be respected. These: prucha, Great Father, 2:1188485, which is based largely on Indian tribes, a continuing quest for survival, a report of the United States Commission on Civil Rights, 7071. 61 For references to non-Indian views, see Prucha, Great Father, 2:1185, and 34. 62 443 U.S. 658,708. One can see the detailed reliance on the treaties and the documents relating to their negotiation in the brief submitted in this case. The case occasioned considerable literature, of which the following might be noted: Joe Ryan, Indian Treaties, Indian Fish, The Controversy of Fishing in Common, American Indian Journal 5, 210, Rod Vessels, Treaties, Fishing Rights in the Pacific Northwest. The Supreme Court legislates an equitable solution, American Indian Law Review 8, No. 1, 11737. Page 406. Rights, privileges, and exemptions possessed only by Indians are quite substantial. I find no basis for according them additional advantages. 63. The heavy weight of treaty terms protecting hunting and fishing rights appeared in other cases, although less dramatically than in the long-drawn controversy of the Puyallups with the state of Washington. One was Menominee Tribe of Indians v. United States, May 27, 1968, which rested upon the Treaty of Wolf River in 1854 with the Menominee Indians. 64 The treaty, by which the Menominees were provided a new reservation on the Wolf River, did not explicitly mention hunting and fishing rights, saying only that the new reservation was to be held as Indian lands are held. The court insisted that this must be interpreted to include hunting and fishing rights, for the essence of the Treaty of Wolf River was that the Indians were authorized to maintain on the new land ceded to them as a reservation their way of life, which included hunting and fishing. 65. The question at issue was whether the termination of the Menominees as a federally recognized tribe by a law of 1954 had deprived the Indians of those rights. When the Indians, who thought they had lost the rights, applied to the Court of Claims for compensation, the court found that no compensation was due because in fact the rights had never been taken away. The Supreme Court accepted that argument. It looked at the Termination Act of the Menominees and at the contemporaneous Public Law 280 and declined to construe the Termination Act as a backhanded way of abrogating the hunting and fishing rights of these Indians. While admitting again the power of Congress to abrogate those rights, it ruled that Congress had not done so, for the intention to abrogate or modify a treaty is not to be lightly imputed to the Congress. The majority opinion went further. We find it difficult to believe, it read, that Congress, without explicit statement, would subject the United States to a claim for compensation by destroying property rights conferred by treaty, particularly when Congress was purporting by the Termination Act to settle the government's financial obligations toward the Indians. A dissenting opinion argued the opposite, that the Indians had lost 63,443 U.S. 7,078. 64,391 U.S. 40,417. 65 Ibid, 406. Page 407. Their hunting and fishing rights and were due just compensation for them. 66. Other cases based on a reading of treaties have turned out less favorably for the Indians. Oregon Department of Fish and Wildlife v. Klamath Indian Tribe, decided on July 2, 1985, denied the right of Klamath Indians to hunt and fish free of state regulation on land ceded in a 1901 agreement. 67 The decision was based chiefly on the treaty signed in 1864 with the Klamaths, by which the Indians ceded all their right, title, and claim to all the country claimed by them and moved to a new reservation. Although the treaty gave them an exclusive right of taking fish in the streams and lakes, included in said reservation, and of gathering edible roots, seeds, and berries within its limits, the court found that no right to hunt or fish outside the reservation was preserved. A search of the historical record of the negotiations for the treaty disclosed no reference to continuation of any special hunting or fishing rights for members of the tribe. The court thus concluded, the language of the 1864 treaty indicates that the tribe's rights to hunt and fish were restricted to the reservation. The broad language used in the 1901 agreement, virtually identical to that used to extinguish off-reservation rights in the 1864 treaty, accomplished a diminution of the reservation boundaries, and no language in the 1901 agreement evidences any intent to preserve special off-reservation hunting or fishing rights for the tribe. 68. In United States v. Dion, June 11, 1986, the court found clear congressional intent to abrogate admitted treaty rights. 69 The case concerned a Yankton Indian convicted of hunting eagles protected by the Eagle Protection Act and the Endangered Species Act. The treaty with the Yanktons of April 19, 1858, had placed no restrictions on the Indians' hunting rights within their reservation, but that was not at issue here. What the court asked was whether Congress had clearly abrogated those rights, and it answered yes. The Eagle Protection Act permitted the taking of eagles under permit for religious purposes, and the court argued that Congress thereby had indicated its recognition that the hunting prohibition would have an effect on the 66 Ibid, 41,217. Another case of Indian hunting rights was Antoine v. Washington, which said hunting on ceded lands was not subject to state regulation. 420 U.S. 194,222. 67 473 U.S. 75,387. 68 Ibid, 755, 770. 2 justices dissented. 69 476 U.S. 73,446. Page 408. Tribe but had met it, not by exempting the Indians from the statutes, but by authorizing permits where appropriate. It concluded, Congress's 1962 action reflected an unmistakable and explicit legislative policy choice that Indian hunting of the bald or golden eagle, except pursuant to permit, is inconsistent with the need to preserve those species. We therefore read the statute as having abrogated that treaty right. 70. The decision included a long statement of principles to be followed in finding an abrogation of a treaty, as though the justices felt a bit uneasy about their action and were determined to justify it fully and show that they were not lightly agreeing to the taking away of Indian treaty rights. These Supreme Court readings of Indian treaties and of Congress's intent in regard to the rights they stipulated, while not uniformly favorable to the Indians, nevertheless help significantly to provide an atmosphere in which claims for protection of Indian rights of whatever kind could flourish. 70 Ibid, 745. Page 409. Chapter 17. Treaty Rights Activism. The stirring up of interest in Indian treaties that came with the cases before the Indian Claims Commission and the Supreme Court had wide ramifications in the 1960s, 1970s, and 1980s. While the lawyers for the tribes drew upon the treaty stipulations in presenting their clients' cases, often picking and choosing whatever seemed to have the best chances of success without much reliance on tribal wishes, Indians across the nation and their non-Indian supporters developed an increasingly active treaty rights position, which drew disparate groups together in protest against treaty violations and which furnished a vehicle for making Indian rights and the Indians' plight visible to a broad public. The Red Power movement, of course, was multifaceted and demanded Aboriginal rights and general human rights that transcended the treaties, but much of the argumentation rested upon the ratified treaties, which for many acquired a new importance. There was a widespread use of Indian treaty rhetoric. While the court cases rested on detailed analysis of historical and legal documents pertinent to the issues, many Indians and their supporters continued an often unthinking and ill-informed reliance on treaties for almost anything they thought Indians were entitled to. The word treaty was bandied about by many Indians as though the word had only one connotation: a diplomatic contract between two fully sovereign nations. There was little or no understanding of the many actions of Indians and Page 410. Of the United States that over time had legally restricted tribal sovereignty. Anything an Indian group wanted could be said to be provided in the treaties. And, conversely, every evil encountered could be blamed on the broken treaties. Such treaty fantasies may have raised ungrounded expectations among Indians and hindered the effective work that needed to be done to improve the social and economic conditions of Indians living today, but the rhetoric was pervasive enough to keep non-Indians aware that the anomaly of Indian treaties was not simply a thing of the past. 1. Early activism. The first major sign of organized Indian activism was the gathering in June 1961 of the American Indian Chicago Conference. The idea of the anthropologist's soul tax of the University of Chicago and endorsed by the National Congress of American Indians, the conference was attended by some 460 Indians of 90 tribes. The Indians voiced their concerns about their welfare and their place in American society and offered a series of recommendations. Although set in a context of working for progress on specific needs within the governmental system of the United States, the conference did call attention, but only briefly, to treaty rights. It is a universal desire among all Indians that their treaties and trust-protected lands remain intact and beyond the reach of predatory men. The conference's Declaration of Indian Purpose said, "The right of self-government, a right which the Indians possessed before the coming of the white man, has never been extinguished. A treaty, in the minds of our people, is an eternal word. Events often make it seem expedient to depart from the pledged word, but we are conscious that the first departure creates a logic for the second departure, until there is nothing left of the word too." Many who attended the Chicago Conference were young Indians, and in August 1961 they organized an activist group called the National. One interesting examples of what some have called a treaty psychosis can be found in Stephen E. Furka, Why Don't They Give Them Guns? The Great American Indian Myth, 73105. 2 Declaration of Indian Purpose, 1516. See also Nancy Estrike-Lurie, The Voice of the American Indian, Report on the American Indian Chicago Conference, Current Anthropology 2, 478,500. Page 411. Indian Youth Council. The group was prominent in the fish-ins in Washington state in the mid-1960s, protesting state fishing regulations to call attention to the Indians' treaty rights to fish, which had been repeatedly ignored or violated by state officials. 3. The next major protest was the seizure of Alcatraz Island, the abandoned federal prison in San Francisco Bay. The Indians called themselves Indians of all tribes, and they justified their occupation on an erroneous reading of the Fort Laramie Treaty of 1868, which they claimed gave Indians the right to federal property no longer in use. Other takeovers of unoccupied federal sites followed, such as Fort Lawton in Seattle and the Coast Guard Station in Milwaukee. Although the Indians were eventually evacuated from Alcatraz and failed also in their other occupations, the idea of Indian rights received a tremendous boost, for the news media gave much attention to the events, and Alcatraz became an important symbol for the tribes. Point 4. Renewal of treaty status. There developed a strong, recurring movement to restore the tribe's treaty status relationship with the United States government, which went beyond protests about specific rights. Ignoring or consciously rejecting the anomalous situation in regard to treaties that a detailed historical account depicts, advocates of renewed treaty status proposed an idealistic return to the past or some new construct that fitted a particular theory. For some Indians it was merely an exercise in nostalgia, for others, a handle with which to pressure the government for attention to the Indians' troubles, for a few, a hope for theoretical status looking back to some idea of absolute sovereignty. A striking example of this movement was the Trail of Broken Treaties in the fall of 1972. This was a caravan of Indian people originating in cities on the West Coast, gathering adherents as it proceeded toward. 3. There is a discussion of the fish-ins, in the context of the larger fishing rights controversy, in Alvin M. Josephy, Jr., Now That the Buffalo's Gone, a study of today's American Indians, 177,211. See also Stan Steiner, The New Indians, 4864. 4. Peter Blue Cloud, ed., Alcatraz is Not an Island, Richard Oakes, Alcatraz is Not an Island, Ramparts 11, 3541, 62, Jeff Sklonsky, Rock, Reservation and Prison, The Native American Occupation of Alcatraz Island, American Indian Culture and Research Journal 13, No. 2, 2968. Page 412. Washington, D.C. Its purpose was to draw Indians together in their protests, to make known in this public, eye-catching way the Indians' grievances, and to demand from federal officials a righting of wrongs. The caravan brought to the Capitol a paper containing 20 points, a list of demands drawn up in Minneapolis by leaders of the militant American Indian movement, who intended the demands to serve as a focus for negotiating with the federal government at the highest levels. 5. 7 of the first 8 demands dealt with treaties. The first one forthrightly called for the President and Congress to repeal the provision in the 1871 law that had ended treaty making with Indian tribes in order that Indian nations may represent their own interests in the manner and method envisioned and provided in the federal Constitution. It was a naive assumption if, indeed, it was meant to be a serious proposal that a century of developing relations between the Indian groups and the United States outside a treaty system could be wiped out by legislative fiat. The second point asked for the establishment by Congress of a treaty commission to sign new treaties with Indian peoples. Authority should be granted, it read, to allow tribes to contract by separate and individual treaty, multi-tribal or regional groupings, or national collective, respecting general or limited subject matter. Point 3 departed from the concern about treaties, but the fourth point demanded a special presidential commission to review domestic treaty commitments and complaints of chronic violations and to recommend or act for corrective action, in the hope that such a body could reduce the Indians' reliance on litigation to protect their rights and thus reduce the heavy costs of attorneys. Point 5 demanded that the President submit to the Senate in the next Congress the treaties that were at one time signed with Indian tribes but never ratified by the Senate, the purpose to be restoring the rule of law to the relationships between such Indians and the United States, and resuming a recognition of rights controlled by treaty relations. Next came a general statement that Congress should pass a joint resolution declaring that as a matter of public policy and good faith, all Indian people in the United States shall be considered to be in treaty relations with the federal government and governed by doctrines of 5. The 20 points are printed in Seizure of Bureau of Indian Affairs Headquarters, Hearings before the Subcommittee on Indian Affairs of the Committee on Interior and Insular Affairs, House of Representatives, 92D Congress, 2D Session, 16,271. Page 413. such relationship. The seventh point demanded mandatory relief against treaty rights violations, on petition of a tribe, by means of federal district court enjoinders or injunctions against non-Indian parties engaged in injurious actions until the court could determine that there was in fact no treaty violation and that the Indians' interests and rights were protected and secure from harm. Finally, the eighth point asked for a law that would give the Indians a right to issue a declaration concerning the interpretation of treaty or other rights that would be binding on the courts unless successfully challenged in the Supreme Court. The remaining points dealt with a variety of issues that were beyond or outside the scope of treaties, including restoration of an Indian land base, consolidation of Indian natural resources, jurisdiction over non-Indians within reservations, replacement of the Bureau of Indian Affairs by an Office of Federal Indian Relations and community reconstruction within the President's office, and provisions for health, housing, education, employment, and economic development. The tribe's dependence upon the federal government exhibited in these demands was clearly at odds with the demands for treaty status sovereignty. Vine Deloria, Jr., then riding high as a spokesman for Indian activists, gave a contemporary and very favorable evaluation of the treaty-related proposals. First, they were extremely accurate in their assessment of the feelings of Indians around the nation. Second, the points outlined a fairly sophisticated understanding of a type of relationship with the federal government that could best be defined as a quasi-protectorate status. It would have severely limited the arbitrary exercise of power by the federal government over the rights of the tribes. Most of all, the acceptance of the 20 points would have meant that the treaties which the United States had signed with the respective tribes a century earlier would have the rightful, legal status which they deserved, equal to the legal status accorded foreign treaties. Point 6. Unfortunately, there was no serious discussion of these proposals by high federal officials. Rebuffed by the officials and frustrated because of lack of provisions for food and housing, the caravan members in early November seized the Bureau of Indian Affairs building, and when they heard of threats to remove them forcibly, the Indians trashed the interior. 6. Vine Deloria, Jr., Behind the Trail of Broken Treaties, An Indian Declaration of Independence, 53. The whole book is an argument for a kind of independent status for the Indian tribes. Page 414. Of the building, fortified their positions as well as they could, and prepared to give their lives in repulsing any attack by riot police. Cooler heads ultimately prevailed. The Indians, getting a face-saving commitment that their complaints would be investigated and supplied with travel funds to return home, left the building. The destruction of the building, and the carrying away of BIA records, however, made any serious consideration of the 20 points unlikely. Point 7. The cursory reply to them in mid-January 1973 by Frank Carlucci, Deputy Director of the Office of Management and Budget, pretty much brushed them aside. The idea that the Indians should again become sovereign political entities with whom the United States would sign new treaties was rejected out of hand. Over 100 years ago the Congress decided that it was no longer appropriate for the United States to make treaties with Indian tribes. By 1924, all Indians were citizens of the United States and of the states in which they resided. The citizenship relationship with one's government and the treaty relationship are mutually exclusive. A government makes treaties with foreign nations, not with its own citizens. If renunciation of citizenship is implied here, or secession, these are wholly backward steps, inappropriate for a nation which is a union. Point 8. To call for new treaties, he said in regard to point 6, is to raise a false issue, unconstitutional in concept, misleading to Indian people, and diversionary from the real problems that do need our continued energies. He noted that the Nixon administration was sympathetic to the Indians' need to represent their own interests and that means were already at hand or had been proposed. He pointed to the Indian Claims Commission, Nixon's proposed Indian Trust Council authority, and federal action to protect Indian rights, which obviated any need for the review commission demanded in point 4. He denied a need for the judicial changes called for in points 7 and 8, for what he called the skewing of America's judicial principles or the creation of any new built-in preferences for or against specific groups or institutions. 9. The militant activists who had led the trail of broken treaties, of 7. See references on this affair given in Francis Paul Prucha, The Great Father, the United States Government and the American Indians, 2 volumes, 2:1118n. There is a brief account in Josephy, Now That the Buffalo's Gone, 23,743. 8. Seizure of Bureau of Indian Affairs Headquarters, 171. 9. Ibid, 17,374. Page 415. Course, were not satisfied by the reply, and the desperation that had lain behind the 20 points soon erupted in the seizure of the village of Wounded Knee on the Pine Ridge Reservation in South Dakota and in armed confrontation there between Indians and the federal government. The Wounded Knee occupation, however, had an additional dimension, the conflict between two groups of Indians on the Pine Ridge Reservation. One was led by Richard Wilson, the elected chairman of the Tribal Council under the governmental setup that originated with the Indian Reorganization Act in 1934, whom the federal government supported as head of the legitimate tribal government. The other was composed of opponents of Wilson AIM leaders, who despised him and his autocratic methods, and traditional leaders, who objected to the BIA government of Wilson and wanted to return to earlier days. The cry was for a return to the conditions at the time of the 1868 Fort Laramie Treaty, which the Sioux had signed as a sovereign nation and which guaranteed to the Indians a large reservation and hunting grounds to the west. It was the traditionalists' claim, echoing the 20 points, that the treaty was still in effect and that changes in land ownership and tribal government since then had been illegal. 10. This position was seen most dramatically in the proclamation on March 11, 1973, in the middle of the Wounded Knee occupation and confrontation, of the independent Oglala Sioux Nation, whose relationship with the federal government would rest on the Fort Laramie Treaty. A provisional government was planned, and the nation announced its intention to send a delegation to the United Nations and to ask for support and recognition from the Iroquois Indians. The Oglala Nation got nowhere, for the federal government stiffened its resistance to the occupiers. When United States negotiators finally met with the Wounded Knee leaders and agreed to consider their demands, the Oglala Sioux Nation faded away. The impasse, however, continued after the occupation of Wounded Knee ended, as traditionalists, under the aegis of a Teton Sioux Treaty Council, conferred in person and by letter with presidential negotiators, who had agreed to listen to Sioux complaints. The Indians harped on the establishment of a presidential treaty commission, which would negotiate new treaties and investigate existing treaties and the rights they guaranteed the Indians and Recom. 10. There is an extensive literature on Wounded Knee, and the news media gave the event full coverage. See, for example, the citations in Prucha, Great Father, 2:1119n. Page 416. Men to Congress. The repeal or amendment of statutes enacted since 1871 which conflict with and take away original sovereignty in every area. Near the end of 1973, these men set forth anew a bill of particulars regarding the Fort Laramie Treaty of 1868 and asked for the government's understanding of the legal effect of the treaty. Pointing to what they considered violations of that treaty, they asked the Presidential Task Force for specific documented answers to the violations set forth. 11. The government spokesman again rejected the Indians' position. Leonard Garment, President Nixon's special assistant, provided the federal government's answer in a letter addressed to the traditional chiefs and headmen of the Teton Sioux, an answer that the repeated recommendations of the Indians failed to shake. Garment quoted the law of 1871 that forbade further treaty making with the Indian tribes and said, "What this means is that the days of treaty making with the American Indians ended in 1871, 102 years ago. Any changes made in the terms of treaties or laws relating to Indians have since been made by agreements ratified for both houses of Congress, or by statutes of Congress. Only Congress can rescind or change in any way statutes enacted since 1871, such as the Indian Reorganization Act. He noted that committees in Congress spent much time on Indian affairs, and he urged the Indians to use that forum. Insofar as you wish to propose any specific changes in existing treaties or statutes, he said, the Congress is, in effect, a treaty commission, and you should make sure that your spokesmen appear before the Senate subcommittee and present their views as to which treaties or statutes should be amended and in precisely what way. 12. The failure of confrontational tactics and the rejection of the treaty-related items in the 20 points, the impotence of the independent Oglala Sioux Nation, and the failure of the Oglala Sioux Treaty Council to have their demands met were setbacks for Indians who dreamed of a revival of the treaty system and dealing with the federal government on the basis of newly negotiated treaties. The next general Indian policy reform movement, the American 11 Frank Fools Crow and Matthew King to Leonard Garment, June 9, 1973, and to Richard M. Nixon, November 19, 1973, in Occupation of Wounded Knee, hearings before the Subcommittee on Indian Affairs of the Committee on Interior and Insular Affairs, United States Senate, 93D Congress, First Session, on the causes and aftermath of the Wounded Knee takeover, 15,054, 31,522. 12 Leonard Garment to the traditional chiefs and headmen of the Teton Sioux, May 29, 1973, Ibid. 3023. Page 417. Indian Policy Review Commission of 197,577 emphasized Indian sovereignty and the trust responsibility of the federal government for Indian welfare and did not make treaty status a key issue. When it referred to treaties at all, it was as a vague basis for sovereignty and as a foundation for some aspects of the government's trust responsibility. Thus Task Force 1 of the APIRC, devoted to trust responsibilities and the federal-Indian relationship, wrote in its report, the treaties of protection and dependence did not divest the tribes of their national character, nor diminish the paramount obligations for health care and educational opportunities entitled to the Indian people. However, to the extent that the Indian tribes' capacities were diminished for meeting these obligations, either immediately or subsequently, the basic responsibility in some measure would necessarily shift to, or be shared by, the United States. 13. The APIRC was generally of limited impact because of its failure to provide an expert analysis of the historical and legal status of the Indian tribes and because its strong advocacy position on the questions of sovereignty and trust responsibility lost its support among moderate groups. The idea of independent sovereign tribes and a renewal of the old treaty relationship, however, was not dead, and from time to time it surfaced again in particular cases. Some Mohawks kept alive an insistence that their independence as a sovereign nation should be recognized. Thus in May 1974 Mohawks from Kaufnawega and St. Regis occupied a 612-acre site near Moss Lake, New York, in the center of the Adirondack Mountains, which the Indians spoke of as the repossession of lands within boundaries of land they claimed in New York State and Vermont. The Indians issued a manifesto proclaiming the re-establishment of the independent North American Indian state of Ganianka on lands that had been part of their ancient homeland. They denied the validity of the 18th-century treaties by which their land had been ceded. Confrontation of the Indians with state forces led ultimately to a negotiated settlement, by which the Indians moved to a new location, on land provided by the state, in the northeast corner of New York. 13 Task Force 1 of the American Indian Policy Review Commission, Report on Trust Responsibilities and the Federal-Indian Relationship, including Treaty Review, 27. Page 418. Near the town of Altona, there Ganianka continued its uneasy existence. 14. Another earnest but unsuccessful push for international status for American Indian tribes came in 1974 with the establishment of an International Indian Treaty Council at a meeting of Indian peoples at the Standing Rock Reservation. In a declaration of principles, the council asserted, indigenous nations or groups should be accorded such degree of independence as they may desire in accordance with international law and treaties and other agreements entered into by indigenous nations or groups with other states, whether denominated as treaties or otherwise, shall be recognized and applied in the same manner and according to the same international laws and principles as the treaties and agreements entered into by other states. The Council's goals were to focus international attention on the conditions of Indian people and to gain some kind of recognition from the United Nations, and in 1977 the United Nations gave the Treaty Council status as a non-governmental organization. With the aid of the Institute for the Development of Indian Law, a Washington-based public interest law firm dedicated to support of Indian peoples, the International Treaty Council organized an international NGO conference on discrimination against indigenous populations in the Americas, which met at the Geneva headquarters of the United Nations on September 2023, 1977. Some 250 delegates attended, including representatives of more than 50 international non-governmental organizations and Indian delegates or observers from Canada, the United States, and Central and South America. 15. Three commissions summarized the discussions in formal reports. The Legal Commission report noted that delegates from several indigenous nations, in particular the Six Nations Confederacy and the Lakota Nation, demanded immediate recognition as states under international 14 Gale H. Landsman, Sovereignty and Symbol, Indian White Conflict at Ganianka, especially Chapter 2. The book is primarily a study of symbols in the dispute, but it nevertheless provides an extensive discussion of the issues. A Ganianka manifesto issued by the Indians is printed in the book's Appendix A, 195,204. See also Trouble in the Land of the Flint, time, December 23, 1974, 16. 15. See Declaration of Principles for the Defense of the Indigenous Nations and Peoples of the Western Hemisphere, printed in Congressional Record, 124:2313940. Reports about the Geneva Conference are in American Indian Journal, September 1977 and November 1977. Page 419. Law based upon treaties which clearly recognized their status as sovereign nations. A final resolution pulled together material from the commissions into a series of recommendations for recognition of the concerns of indigenous peoples and ways to meet them. 16. It was a glorious time for Russell Means, the Sioux AIM leader, and for Oren Lyons, his counterpart among the Six Nations, and their associates. The city of Geneva, before the opening of the conference, held a reception for the delegates of the Six Nations in honor of Dieskhe, who was remembered in Geneva for his attempts to bring Indian issues to the attention of the League of Nations in 1923, and the Iroquois delegation triumphantly used their own passports going and returning. 17. But aside from the extensive media coverage, which without doubt alerted many people to the grievances and concerns of indigenous peoples in the hemisphere, few results came from the Conference for Indians in the United States. The demands of Indian activists for international recognition of sovereign nationhood were unheeded, and the conference had no effect on the legal status of the Indian tribes in the United States or on their treaties. This, however, has not stopped unthinking people from continuing to presume that American Indian tribes have an international status. 18. Treaty fishing rights. The emphasis on treaties that accompanied the fish-ins in Washington state in the mid-1960s and the Bolt decision in the mid-1970s was renewed with other fishing rights cases that did not reach the Supreme Court but that nevertheless got wide attention and Gen. 16 Legal Commission Report and Final Resolution in American Indian Journal, November 1977, 45, 9. 17 Ibid, 6. 18 Two recent examples. In arguing that the president should implement the domestic programs needed by the Indians, one religious spokesman said, "Of course, it is not a domestic problem at all, it is an international problem because two sovereign nations are involved, Indian tribes and the United States of America." Theodore Z. Yearn, in Bureau of Catholic Indian Missions Newsletter, August/September 1991, 3. An account of a symposium of American Indian writers in 1991 referred to the event as international in that it involved Indians representing tribes from the Abenaki in New York to the Oglala Sioux in South Dakota. Faith Be Miracle, Editor's Notes, Wisconsin Academy Review 38, 2. Page 420. Erat considerable white protest, some of it violent. The cases kept the Indian treaties and the rights they guaranteed the tribes much in the public mind. Two sets of cases were of special importance. One set concerned the Indians of Michigan and the rights they claimed to fish in Lake Michigan without observing the restrictions enacted by the state. Over the years the Indians had not pressed their rights, and Michigan eventually enacted hunting and fishing regulations. But, alert to the actions in Washington state, beginning in the 1960s Michigan Indians brought isolated cases before local courts for recognition of their rights under treaty provisions. On the other side, Michigan asserted sovereignty over the fisheries and charged the Chippewa and Ottawa fishers with destroying fish resources by use of gill nets. Local non-Indians and vociferous advocates of sport fishing increasingly challenged the Indians' actions and their rights. 19. The case of United States v. Michigan, which was heard before Judge Noel P. Fox of the United States District Court for the Western District of Michigan, became the legal focus of the conflict. It sought to decide whether the 20th-century descendants of 19th-century treaty signatories had retained fishing rights under the treaties, and if those rights were present, what kind and how many fish the Indians could take. After long testimony by expert witnesses, Fox, on May 7, 1979, strongly affirmed the Indians' rights under their treaties of 1836 and 1855, the first of which had provided the right of hunting on the land ceded, with the other usual privileges of occupancy, until the land is required for settlement. 20. His decision was wide-ranging. The mere passage of time has not eroded, and cannot erode the rights guaranteed by solemn treaties that both sides pledged on their honor to uphold. The Indians have a right to fish today wherever fish are to be found within the area of cession as they had at the time of cession, a right established by aboriginal right and confirmed by the Treaty of Ghent, and the Treaty of 1836. The right is not a static right today any more than it was during treaty times. The right is not limited as to the species of fish, origin of fish, the purpose of use or the time or manner of taking. It may be exercised utilizing improvements in fishing techniques, methods, and gear. 19. The Michigan events are recounted in Robert Doherty, Disputed Waters, Native Americans and the Great Lakes Fishery. 20. Kapler, 2:454. Page 421. Fox emphasized the treaty basis of these rights. Because the right of the tribes to fish in ceded waters of the Great Lakes is protected by treaties. That right is preserved and protected under the supreme law of the land, does not depend on state law, is distinct from the rights and privileges held by non-Indians and may not be qualified by any action of the state, except as authorized by Congress. Although the state appealed the decision, the United States Court of Appeals, 6th Circuit, refused to revise the decision, and the United States Supreme Court would not review it. 21. A second set of cases concerned Chippewa spear fishing in Wisconsin, which generated a tremendous amount of white backlash from persons devoted to sport fishing and from resort owners. The public controversy arose with Lac Court O'Reilly's band of Lake Superior Chippewa Indians v. Voigt, which dealt with the arrest of 2 Indians of the band for spear fishing in ceded territory. The band sued Lester P. Voigt, Secretary of the Wisconsin Department of Natural Resources, and other individuals for interfering with off-reservation fishing rights of the Indians under their treaties of 1837 and 1842. Judge James Doyle of the United States District Court for the Western District of Wisconsin on September 20, 1978, ruled against the Indians on the basis that the 1854 treaty had extinguished the rights granted in the earlier treaties. But on appeal, the United States Court of Appeals, 7th Circuit, in 1983, reversed the Voigt decision of Judge Doyle and restored the treaty rights, and the United States Supreme Court refused to review the case. 22. After a complicated series of legal maneuverings involving the District Court, the 6 Chippewa tribes of Wisconsin, and the state of Wisconsin all carried on in the midst of violent and abusive protests from non-Indians, Covered extensively by the media, the Indians' rights were vindicated. On March 19, 1991, Judge Crabb issued a final judgment, which 21-471 F sub 28081. There is a long discussion of the case and the arguments on the two sides in Doherty, Disputed Waters, Chapter 6. Note also Doherty's treatment of subsequent negotiated settlements in regard to management of the fisheries. The actions of the Court of Appeals are in 623 F.2d 44850 and 653 F.2d 27780. 22-464 F sub 131676, under the name of United States v. Bouchard, 700 F.2d 34165, 464 U.S. 805. The whole affair and its historical background are treated in Ronald N. Satt's Chippewa Treaty Rights, the Reserved Rights of Wisconsin's Chippewa Indians in Historical Perspective, Transactions of the Wisconsin Academy of Sciences, Arts, and Letters, Volume 79, Number 1. Page 422. Summarized and clarified the complicated litigation. The usufructory rights of the tribes arising from the treaties of 1837 and 1842, Crabb said, included rights to those forms of animal life, fish, vegetation, and so on that they utilized at treaty time, and the right to use all of the methods of harvesting employed at treaty times and those developed since. The Indians were denied the right to harvest commercial lumber on ceded lands, but they could gather miscellaneous forest products, namely, such items as firewood, tree bark, maple sap, lodge poles, boughs, and marsh hay. The fruits of the exercise of these rights could be traded or sold to non-Indians. The Indians were granted the right to regulate their own off-reservation harvesting of walleyes and muskellunges. The tribal harvestable natural resources to which the Indians retained a usufructory right were to be apportioned equally between the Indians and all other persons. These rights, however, did not apply to sections of the ceded territory that were privately owned. 23. The 6 Chippewa tribes in Wisconsin and the state of Wisconsin formally accepted the final order on May 20, 1991. Both sides agreed to restrictions on some rights for which they had originally contended, but they did this in the interests of peace. The long legal struggle was over. 24. By that time there were few citizens of Wisconsin or of the nation who did not know of the continuing treaty rights of the Wisconsin Indians, and that the federal courts would stand firm against great pressures in vindicating those rights juridically. 25. Backlash. The growing strength of tribal governments after 1960 and the recognition by the courts of their still existing, though partial, sovereign powers caused a backlash, which some observers friendly to the Indians have seen as an anti-Indian movement. The opposition rested on two principal grounds. One was the fear of non-Indians who. 23. The final judgment is printed in Satt's Chippewa Treaty Rights, 18,791. 24. Ibid, 193, 19,597. 25. All opposition to the Indians' rights, of course, did not disappear, and an organized protest movement continued. See, for example, an article in the Milwaukee Journal, April 6, 1992, about plans for peaceful demonstrations against spearfishing. The anthropologist James A. Clifton has argued at some length that the court decisions were flawed. See Clifton, Information Concerning the Lake Superior Chippewa, Their Treaties with the United States, and the Voigt Case, pre-publication draft supplied me by the author. Page 423. Lived within reservation boundaries on land owned by them in fee that tribal jurisdiction would be extended over them and their property. A second was opposition to treaty-grounded rights held by Indian tribes to fish on off-reservation sites or lands ceded in the treaties. The arguments were couched in terms of equal rights and equal opportunities for all American citizens, and Indians were denounced as super-citizens because the courts recognized rights for them that were not accorded non-Indians. There was a great deal of heat generated in the attack on Indian rights and often little clear understanding of the historical and legal basis for special tribal rights. As non-Indians attacked these rights, many Indians reacted, naturally enough, by strongly exercising their rights and by campaigning to win support for themselves in Congress and in the courts. As the anti-Indian groups organized to support their own positions, so too did groups form to counteract them and to proclaim support for treaty rights. Each side saw its position clearly, and there was little appreciation of the anomalies that underlay the conflict of views. It was difficult for the white protesters to grasp and accept the fact that tribal governments exercised jurisdiction over reservations whose boundaries now included non-Indians and non-Indian land, to admit that Indian citizens had legal fishing rights that non-Indian citizens did not have, and to live with the fact that a state's jurisdiction did not fully extend over Indian lands within the state. The backlash reached an early peak in the 95th Congress in 1977 and 1978, as bills were introduced that were intended to destroy or weaken Indian treaty rights. The most damaging bill was deceptively entitled the Native American Equal Opportunity Act. It would have unilaterally abrogated all Indian treaties, broken up Indian communal assets, and terminated the special services guaranteed to Indians. It was introduced in 1977 by Representative John E. Cunningham, a freshman member of Congress from Washington state, who had run on a platform that called for abrogation of treaties, especially those that guaranteed Indian fishing rights. After his initial measure made no progress in the House, Cunningham introduced a similar bill in 1978, which was more detailed on how the bill would be implemented and which called for the abolition of the Bureau of Indian Affairs. He declared, "While we encourage diversity in this country, we must not have two classes of citizens, whether black or white, immigrant American or Native American. It is for this reason that Congress must act to end." Page 424. The confusion caused by judicial interpretations of treaties and executive orders. Two other bills were introduced by a longtime representative from Washington, Lloyd Meads, who once had been an active advocate of Indian rights but who drew the line on extending tribal sovereignty. His bills would have weakened tribal powers by extending state and local jurisdiction over tribal lands and other resources and would have severely limited Indian rights to water. Other bills sought to extinguish land titles of Indians in Maine and New York, change traditional hunting and fishing rights, and increase state criminal jurisdiction on reservations. 26. The Indians' response to this proposed legislation was a public march of Indians from the West Coast to Washington, D.C., dubbed the Longest Walk. It was led by traditionalists, AIM members, and a group who declared themselves to be spiritual elders. While the old motivation of calling public attention to the injustices suffered by Indians was still evident, the immediate rationale was to unify protest against the impending legislation, which would have weakened the Indians' status in American society. The congressional initiatives against Indian treaty rights were enough to frighten tribal heads and councils into giving hesitant support to the Longest Walk, even though it was managed by their traditionalist and AIM rivals. 27. The movement sputtered and failed, but it was the occasion of a public debate about the nature and status of the tribal governments. Some alert observers of the Indian scene who were sympathetic to Indian needs in modern American society denounced the Longest Walk, considering its demands a futile attempt to turn back the clock. They argued that the democratically elected tribal governments were a fact of life and here to stay, that the future welfare of the Indians and their 26 Cunningham's bills are printed in Congressional Record, 123:29777, and 124:2084849, together with his remarks about the measures. For introduction of Meads's bills, see Congressional Record, 123:37033. Meads justified his position in an opinion piece in the Washington Post, October 22, 1977. See also Emma R. Gross, Contemporary Federal Indian Policy Toward American Indians, 8791, and the articles cited in the next footnote. 27 Peter Munkrays, The Longest Walk, An Indian Pilgrimage, Christian Century 95, 35052, Phil Schenck, The Longest Walk, Marching for Indian Self-Preservation, Sojourners 7, 1012, Teepees on the Mall, Newsweek, July 31, 1978, 27. A manifesto and other statements from the leaders of the longest walk are printed in Congressional Record, 124:2313440. Page 425. Push for a degree of political autonomy depended on strengthening, not weakening, those governments. Traditionalists countered that the elected councils had capitulated to white mainstream pressures and neglected or repudiated traditional Indian cultures. 28 While treaties and treaty rights did not always get explicit attention, it was returned to a treaty status relationship with white society that the traditionalists wanted and, at the least, protection against congressional action that would abrogate all treaties or in lesser ways eat into the recognition of tribal sovereignty that had been gained in recent years. The legislation proposed by Cunningham, Meads, and other like-minded persons did not get enough backing to be enacted into law, but groups of citizens opposed to special rights for Indians continued their campaign. Although these equal rights groups sought to appear as national organizations with broad countrywide support, they in fact were generated by local issues, and their broader appeal and action seemed to come chiefly from the fact that the same few leaders appeared on the boards or advisory committees of the several groups. The strong focal points were the states of Washington, Montana, and Wisconsin. The drive had begun with the organization by white protesters in 1976 of the Interstate Congress for Equal Rights and Responsibilities, which had been sparked by non-tribal landowners and by non-Indian sport and commercial fishing interests in Washington state, who fought the extension of tribal sovereignty on such reservations as Quinault and Port Madison, who condemned the bold decision of 1974, which they felt exalted Indian treaty fishing rights out of all proportion, and who influenced the congressional backlash in 1977 and 1978. New organizations with the same agenda appeared from time to time, as some faded away, others took their places. Thus the issues in the state of Washington were agitated by Steelhead and Salmon Protection Action Washington Now, organized in 1983 with a slight name change in 1985 to widen its appeal, and by the new 1989 group called United Property Owners of Washington. In Montana, beginning in the late 1970s, Montanans Against Discrimination opposed assertion of tribal powers within reservation boundaries, to be succeeded later by All Citizens Equal. Mean. 28 See the exchange of views between Wilkelmy Washburn, who attacked the longest walk and its arguments, and Joseph de la Cruz, head of the National Tribal Chairmen's Association, who condemned Washburn's views, in the op-ed pages of the New York Times, July 20 and August 2, 1978. Page 426. While the successes of the Wisconsin Chippewa Indians in protecting their rights to off-reservation spearfishing brought to life Protect Americans' Rights and Resources and a more violently confrontational group, Stop Treaty Abuse. In 1988 a new umbrella organization, Citizens Equal Rights Alliance, appeared, which assumed much of the leadership for anti-treaty rights activity, with a concentration on court cases. There was also a limited attempt by the Wisconsin Counties Association to organize a national coalition on federal Indian policy, but its organizational meeting in Salt Lake City in 1990 came to nothing, and most responsible county and state officials ignored or condemned the attempt. 29. The continuing proclamations and actions of these groups spawned coalitions of organizations that support Indian treaty rights and spend a good deal of time monitoring the activities of the protesters. Churches have been especially busy and have issued pastoral letters and other statements in support of Indian treaty rights and Indian sovereignty. Although misunderstanding about the history of Indian sovereignty weakens the force of their appeals, they emphasize the importance of morality and justice in the issues and appeal to the latent guilt complex among liberal Americans in regard to the Indians. For example, the Washington state Indian fishing question occasioned the formation in Seattle of a national coalition to support Indian treaties, with the following institutions among its membership: American Friends Service Committee, Lutheran Church of America, Jesuit Conference, Office of Social Ministries, United Methodist Church, Office of Emerging Issues. United Church of Christ, Minnesota Conference. Washington State Catholic Conference. Seattle Fellowship of Reconciliation. Seattle Unitarians for Social Justice. Church Council of Greater Seattle. National Lawyers Guild, Seattle and Portland. 29. A comprehensive account from a pro-Indian perspective is Rudolph C. Reiser, Anti-Indian Movement on the Tribal Frontier. Reiser sees a linkage of the anti-Indian organizations with extreme right-wing groups. See also Paleface Uprising, Newsweek, April 10, 1978, 3940, and, For the Wisconsin Story, Sats, Chippewa Treaty Rights, 10124. Page 427. Tacoma Dominican Sisters. National Ministries of American Baptist Churches 30. A more recent coalition, with headquarters in Milwaukee, Wisconsin, is Honor, which seeks to promote justice through affirmation of treaty rights, respect for tribal sovereignty, and recognition of government-to-government relationship. Its initiative comes from the Evangelical Lutheran Church of America, and it has institutional membership similar to that of the Seattle Coalition. 31. From the past to the future. The treaties came out of very mixed sentiments on the part of whites. The avarice of whites for rich Indian lands was reflected to a large degree in their representatives in Congress and in the executive branch of the federal government, although it was frequently expressed in terms of promoting the spirit of enterprise and the proper utilization or exploitation of the resources of the earth. The Indians had no right, it was asserted, to hold in sterile embrace the vast lands that they used only casually or not at all. But on the other side, there was strong support in the federal government and outside for the aboriginal rights of the Indians to the land, and even stronger support for property rights embodied in the treaties. The treaties were seen as contracts which no nation could violate without losing its honor and its good name among the other nations of the world. This was an especially sensitive point among those who considered the United States the great experiment in republican government and an example or beacon for the rest of the 30. See questions and answers on treaty rights. 31. Sharon Metz, The Anti-Indian Movement, and Honor Brochures. See also the statement issued by the National Conference of Catholic Bishops, 1992, A Time for Remembering, Reconciling and Recommitting Ourselves as a People, Pastoral Reflections on the Fifth Centenary and Native American Peoples, which among other things, renewed a commitment to press for justice in the prompt and fair adjudication of treaty rights. Origins 21, 49399. Page 428. World. And the sanctity of property and of contracts that supported it was a principle of faith that dominated American legal history. The history of the treaty system contains a debate between those who pointed to the plighted faith and national honor that permeated the treaties and those who argued that treaties with the Indian tribes were a fraud and a delusion because the Indian communities were not political entities of such nature as to warrant consideration as sovereign nations. There were high-minded and honorable men and women on both sides of the question. Many felt deeply that Indians should be treated as wards of the nation until they were acculturated enough to be fully assimilated into white society. But only a few argued for breaking the contracts made in officially ratified documents and abrogating the treaties without the proper consent of the tribes. The varying sentiments are intermixed and provide a rich context in which the treaties and their history must be viewed. The failure of either extreme to win out perpetuates the anomaly. Elements of sovereignty survive in the tribal governments, and the federal government accepts a trust responsibility to protect and otherwise care for the Indians. To add to the confusion, Indian leaders claim that one of the main obligations of the federal government under its trust responsibility is precisely to protect and strengthen Indian sovereignty and the rights that come with it. This is the real world, the world resting on historical decisions and historical accidents. It is clearly a world in flux as new decisions are made and new unexpected events occur. Indian sovereignty and treaty rights, in practice, extend only as far as they are recognized by the federal and state governments and the people they represent. It is not impossible, though at the present highly improbable, that the demands made by advocates for a return to full sovereignty and the old treaty status might someday be recognized. One thing, however, seems sure: Indian treaties and the rights they guarantee will remain, whatever the makeup of the various components of the anomalous whole. Page 429. Appendix A. Treaty documents and their promulgation. The original treaties were manuscript documents hand-drafted by the secretaries of the Treaty Commissions. Point 1. Written in black ink on heavy paper, they spelled out in final form the agreements reached during the often drawn-out negotiations between the United States commissioners and the Indian chiefs and warriors present. Although most of the treaties have headings indicating a treaty of peace and friendship or articles of a treaty, from time to time other terminology was used, such as articles of agreement and convention, articles of treaty and agreement, or, more simply, a convention. The treaty with the Senecas in 1802, by which the Indians sold land to private individuals, was called an indenture. There was some attempt, on occasion, to ornament the document with bold headings or subheadings, but in general the treaties are plain but legible documents. There was no effort to have the treaties engrossed by a skilled scribe, and in some cases 2 or 3 different hands are distinguishable in the writing of the treaty. Point 2. Occasionally a treaty was turned out in poor physical shape, with items crudely blacked out, corrections inserted, and writing showing through the sheets from the reverse side. To the Wyandotte Treaty of January 19, 1832, an explana. 1. These documents, which formed the State Department ratified Indian treaties file, are now in General Records of the United States Government, National Archives Group 11. 2c, for example, Choctaw and Chickasaw Treaty of April 28, 1866, and Cherokee Treaty of July 19, 1866. Page 430. Shin was appended noting that an article in the first draft of the treaty was rejected by the Indians and therefore eliminated, but that circumstances did not admit of time to remodel and copy the whole treaty. And a note was added before the signatures on the Osage Treaty of September 29, 1865, indicating that the interlineations and erasures on the 7th and 10th pages were made before signing 3. The proclamation forms drawn up for the President's signature were generally better prepared, and a large seal with ribbons was prominently attached. The forms for James Buchanan's administration are notable for their fine calligraphy. Although the Indian treaties had the same legal force as treaties made with European nations, they were in general prepared with much less attention to elegance and decoration. The European nations and the United States exchanged ratification copies of the treaties that had bindings of cloth or leather, with gold or silver skippets containing large wax impressions of the official seals. Point 4. Treaties with foreign nations other than Great Britain had official versions in both languages, while Indian treaties were issued only in English, for the preliterate status of the tribes precluded an Indian language version. The Cherokees, however, since they had developed a written language using their syllabary, did attempt to have their 1866 treaty issued in their language. The State Department was agreeable, provided the Cherokee version was issued with a statement that would preclude the inference that the United States are committed to, or bound by anything except the original English of the treaty. The Interior Department agreed to pay for translation and publication in the Cherokee language and characters, but it is not clear whether, in fact, such a version of the treaty was published. Point 5. Signatures. At the end of a treaty document, the signatures of the United States Commissioners appear first, followed by the names of the 3 ratified treaties. 4. See photographs of the seals and skippets in The Art of Diplomacy. 5. Henry Stanbury to O. H. Browning, August 4, 1866, and James Harlan to William H. Seward, August 4, 1866, typed copies in ratified treaties. Page 431. Indian signatories, to which are appended his X mark, unless, as on rare occasions, the Indian signer was literate and could sign his own name. The marking of the X, whether done by the Indian himself or by the secretary, with the Indian touching the pen, was usually a solemn affair. Point 6. On some of the treaties, each signature had a seal attached, but if materials for seals were not on hand, a seal was crudely drawn in. Often ribbons were attached in order to add a note of importance and formality. The treaty with the Western Cherokees of May 6, 1828, was signed by the Cherokees using the Cherokee syllabary, each name marked with a small cross geared to a note below that read, written by the signers in their language, and in the characters now in use among them, as discovered by Geo. Guess 7. In some early treaties with Western tribes, the Indians' names and marks are followed by roughly drawn symbols or totems, an animal, a bird, or a turtle. Point 8. The treaties were also signed by the witnesses, sometimes in parallel columns with the Indian signatures, sometimes at the very end. These witnesses included the commission secretary, the interpreters, army officers, and a variety of other personages. There was no set practice about the number of copies of a given treaty that were formally signed. While it seems reasonable that the Indians as well as the United States would want an official copy of the documents, the written document, for the Indians, was of less importance than the exchange of speeches at the council. In fact, there are few recorded cases in which multiple copies were signed at the treaty ceremonies. This was done, however, even in some early treaties. The first of the treaties, that with the Delawares in 1778, was signed in 3 copies, with 1 copy sent to the Continental Congress, 1 given to the chiefs, and a third left with General Lachlan McIntosh, commandant at Fort Pitt. The treaty negotiated with the Cherokees at Hopewell. 6. See Raymond J. Damalley, Touching the Pen, Plains Indian Treaty Councils in Ethno-Historical Perspective, in Frederick C. Lubke, ed., Ethnicity on the Great Plains, 40, 42. There is a dramatic account of an Indian signing a treaty in George A. McCall, Letters from the Frontiers, written during a period of 30 years' service in the Army of the United States, 241. 7. Ratified treaties. 8. See Treaty with the Chippewas and Other Tribes, November 18, 1808, Treaty with Wyandots and Other Tribes, September 8, 1815, Ratified treaties. Similar signatures on the Treaty of Greenville, August 3, 1795, are shown in Herman J. Viola, The National Archives of the United States, frontispiece, and 131, the original is in Ratified Treaties. Page 432. In 1785 was signed in duplicate so that each of the negotiating parties had a copy. 9. The sale of Seneca lands to Oliver Phelps and others in 1802 was done in triplicate of both the treaty and the attached indenture so that the United States, the Indians, and the private purchasers would each have a copy. And the Choctaw Treaty of 1803 was also signed in triplicate. Similar multiple signing and distribution was done in 2 treaties of 1854 and 1855, in which the United States witnessed land deals between the Choctaws and the Chickasaws, and one in 1856 between the Creeks and the Seminoles. In these cases, the treaty text itself indicates the signing in triplicate. The United States Commissioner of the U Treaty of 1849, James S. Calhoun, wrote at the bottom of the original treaty document signed in duplicate 10. Even though treaties were not signed in duplicate or triplicate, copies of the treaties were written out. How often cannot be determined. One clear case was the Cherokee Treaty of 1804, in which the government mislaid the original treaty and a copy of the treaty in the possession of the Cherokees was used for ratification, finally, in 1824. Other manuscript copies are extant in government archives. Ratification and Proclamation. The United States in its dealing with the Indians by treaty quickly developed a set format for perfecting the treaties according to constitutional requirements after they had been negotiated and formally signed. The treaty commissioners sent the treaty to the Secretary of War or the Secretary of the Interior, usually through the Commissioner of Indian Affairs, following the creation of that office in 1832. There was a letter of transmittal and often a report on how the negotiations had been conducted and an explanation of the terms in the treaty. Frequently a journal of proceedings was included, in some cases very brief summaries of each day's proceedings, in others a long and detailed account with nearly verbatim transcriptions of the speeches of the commissioners and of the Indians. The Commissioner of Indian Affairs sent the treaty. 9 Council minutes published in David I. Bushnell, Jr., The Virginia Frontier in History 1778, Part 5, The Treaty of Fort Pitt, Virginia Magazine of History and Biography 24, 176, Aspia, 143. 10 Kapler, 2:61, 62, 653, 711, 763, Ratified Treaties. Page 433. To the Secretary with recommendations about ratification, the Secretary in turn sent the treaty, with the Commissioner of Indian Affairs report and sometimes a report of his own, to the President. The President, at his discretion, submitted the treaty with the reports and other pertinent documents to the Senate for its constitutional action of advising and consenting to its ratification. Point 11. Now it was the Senators' turn to put their stamp upon the treaty, and the treaties themselves contained explicit notations about such ratification, most of them specifying that the articles would be binding on both parties as soon as they shall have been ratified by the President of the United States of America, by and with the advice and consent of the Senate of the said United States. 12. But there were a number of variations. The peace treaty of May 13, 1816, with the Sacs of Rock River put the stipulation negatively, "This treaty shall take effect and be obligatory on the contracting parties, unless the same shall be disapproved by the President and Senate of the United States, or by the President only, and in the meantime all hostilities shall cease from this date." The Treaty of Prairie du Chien of 1825 specified that the treaty became obligatory on the tribes at the date of signing and on the United States only after its ratification. The Apaches in 1852 signed a treaty that was to be binding on both parties from the date of signing, subject only to such modifications and amendments as may be adopted by the government of the United States. 13. The treaties with the Potawatomis and with the Miamis in 1826 had the unusual notation, "This treaty, after the same shall be ratified by the President and Senate, shall be binding on the United States," a reflection, no doubt, of the principle that the Indians were represented at the negotiations by their chiefs, the United States only by appointed commissioners, whose work was subject to ratification. 14. Unexpectedly, for a body that under the Constitution had joint responsibility with the President for treaty making, the Senate, except in a few instances, acted perfunctorily. Following a run-in with George Washington about what advice and consent meant, the Senate backed. 11. These documents for a good many of the treaties are assembled in Senate. Some appear among the documents indexed in Sys Index to U.S. Senate Executive Documents and Reports, covering documents and reports not printed in the U.S. Serial Set, 18171969, 2 volumes. 12. This precise formula is from the treaty with the Chickasaws, July 23, 1805, Kapler, 2:80. 13. Ibid, 128, 254, 599. 14. Ibid, 275, 280. Page 434. Away from taking an active part and regularly approved treaties with a unanimous or nearly unanimous vote after receiving the treaties in completed form. Not counting the 7 treaties completed under the Continental Congress and 7 more for which there was no division of votes into yeas and nays, the action can be followed on 354 treaties. Of these, the Senate unanimously approved 191 without amendment and 25 more with 1 or 2 negative votes. In addition, it unanimously approved 57 treaties to which it had added amendments and 12 amended treaties with 1 or 2 negative votes. This makes 285 treaties ratified by the Senate almost unanimously. There were 69 others that were approved with 3 or more negative votes, but close decisions were exceptional. 15. At times, to be sure, the Senate stopped the treaties altogether. It tabled some of those it received from the President, and sometimes it voted to reject them outright. 16. The formal action of the Senate was sent to the President in the form of an attested copy of the Senate's resolution, with the original treaty attached. The President returned the treaty with the Senate's resolution to the Executive Department from which he had received it. There was a further anomalous procedure, for, although responsibility for Indian affairs, including treaty negotiations, fell to the War or Interior Department, the filing and safekeeping of the treaties and their promulgation were duties of the Department of State. Eventually, then, the original treaty with the Senate's attested resolution of advice and consent was forwarded to the Secretary of State, who had a formal ratification/proclamation document drawn up for the President to sign. A set form was adopted at the very beginning of the national government, which was used with slight variations until treaty making ended in 1871.17. The document of ratification was then printed for distribution. Occasionally a special proclamation by the President urging proper 15. This compilation is based upon a careful scrutiny of Senate Ex. Proc done by Mark Ferrara, who aided me as a graduate research assistant at Boston College in 198,384. Senate action on treaties was done in executive session and recorded in Senate Ex. Proc. From time to time, in individual cases, the Senate lifted the secrecy from the treaty ratification proceedings at the time of its action, and ultimately, after a lapse of time, it authorized publication of the executive proceedings. 16. See Appendix D, Unratified Treaties. 17. See, for example, the Cherokee Treaty at Halston in 1791, Ratified Treaties. Page 435. Enforcement of the treaty was used also at the beginning of the document, as in the case of the Creek Treaty of 1790, which was then issued as a broadside. 18. The treaties antedating 1790 in the State Department file do not have a presidential ratification attached to them, but there has been little question of the validity of these treaties on that account. 19. From the Creek Treaty of 1790 on, with few exceptions, all treaties have a clear ratification/proclamation by the President. 20. As the practice developed, the presidential statements at the beginning and the end were on separate pages of paper, but in some cases the statements were pasted onto the treaty proper. George Washington also entered his ratification statement for some treaties on the treaty paper itself when there was room at the end. 21. Beginning with the 1820s, the ratified Indian treaties file generally has printed copies of the treaties, which include the ratification by the President. There are printed copies of some earlier treaties, but not all of them found their way into the file. Senate amendments. The ratification process was more complicated when the Senate amended a treaty and advised and consented to its ratification only with the amendments. The amendments were sometimes made on the initiative of individual senators or by the Committee on Indian Affairs, to which the treaties and accompanying documents were routinely referred, but often the amendments had actually been suggested. 18. Ibid. Frame 222. 19. The statutes at large indicates ratification on September 27, 1789, of the Fort Harmar Treaty of January 9, 1789, with the Wyandots and other Western tribes. Clarence E. Carter argues that the Treaty of Fort Harmar with the Six Nations of the same date was never completed by Senate ratification and presidential proclamation and was, therefore, not a valid treaty, even though high government officials later assumed its validity and acted accordingly. The treaty was sent to the State Department in 1797, however, and it appears as number 16 in the ratified treaties. See Ter. Papers, 2:183n, 186n, John Stagg to George Taylor, May 9, 1797, ratified treaties. 20. For some reason the statutes at large indicates ratified rather than proclaimed for the treaties at Portage de Sioux in 1815 and some others of the same period, but the form of the President's action is the same as that for other treaties. 21. See Treaty with the Sacs and Foxes, September 3, 1822, ratified treaties, Treaty of Greenville, August 3, 1795, Ibid. Page 436. By the Commissioner of Indian Affairs or the Department Secretary and sent to the Senate in their reports accompanying the treaty. The President and the Executive Department officials did not consider themselves authorized to change a treaty once it had been signed by the treaty commissioners and the Indians. When they decided, on receiving the treaty, that changes were in order, they suggested amendments with the hope that they would be incorporated by the Senate. The Senate regularly acceded to the suggested changes and approved the treaty only with such amendments. 22. Considerable difficulty arose in resubmitting an amended treaty to the Indians for their assent to the changes. A number of treaties were ratified and carried into effect without any attempt to get the Indians' approval. But the injustice of such unilateral changes was apparent, and the government regularly sought assent to the amendments by tribal leaders. In some cases, the Senate specifically required it. Thus the Senate on February 25, 1841, in amending a treaty with the Miami Indians of November 28, 1840, included in its resolution the proviso, that the assent of said Indians shall be properly obtained to the same. The Indian assent was obtained on May 15, 1841, and President Tyler ratified the amended treaty on June 7, 1841.23, and in the treaty with the Delaware Indians of July 2, 1861, the Senate added to its resolution of amendment, and provided, that this treaty shall not go into operation and be binding on them until accepted by the Indians thus amended. President Lincoln specifically designated Commissioner of Indian Affairs William P. Dole to present the amended treaty to the Indians and to record their acceptance. 24. Congress, too, in making appropriations for carrying out treaties, could protect the right of the Indians to approve Senate amendments, as it did in 1836 by adding this provision to the section of the Indian Appropriation Act dealing with the Ottawa and Chippewa Treaty of 22. This action can be followed best in the Senate's treaty ratification files. See, for example, actions of the 24th and 25th Congresses, Senate, Sen 24B and Sen 25B. I at first misunderstood the Senate's action in amending so many treaties. The considerable number of such cases led me to believe that the Senate played a major part in the final form of the treaties, but after studying the Senate's treaty ratification files, I had to revise my judgment. 23 Ratified treaties. The Senate resolution and the Indians' assent are printed in 7 Stat 58586. 24 Ratified treaties. Page 437. March 28, 1836, that no part of the above appropriations for carrying into effect the treaty with the Chippewas and Ottawas, shall be drawn from the Treasury except what may be necessary for the expenses of collecting and subsisting the Indians, and for the expenses of concluding the treaty, heretofore incurred. Until the assent of the said Indians shall be given to the changes proposed by the resolution of the Senate 25. As the Senate made amendments with increasing frequency, considerable care was taken to get Indian approval. Sometimes, when the treaty and Senate resolution with amendments were sent to the State Department for promulgation, the Secretary of State returned the documents to the Department of the Interior with such a notation as to the end that the Senate's amendments to said treaties may be duly submitted to the respective tribes of Indians for their ratification. When the form for the President's ratification of amended treaties was drawn up, it included a copy of the Senate's amendments and the Indians' assent thereto. In the case of the treaty with the Western Band of Shoshones of October 1, 1863, the Indian office neglected to fill a blank in the treaty concerning the number of thousands of dollars worth of provisions and clothing to be given as presents at the conclusion of the treaty. When the Senate got the treaty with the blank not filled in, it formally amended the treaty to insert the word 5. The acting Secretary of the Interior sent the treaty to the Secretary of State for promulgation, with the note, "I would respectfully suggest in connection with the amendment, that the blank in the 8th article was an oversight, intended to have been filled by this department, and therefore it is not necessary to send it to the Indians for the assent to the insertion of the word 5. Should you concur with me in this view, I will thank you to insert the word 5 in the blank of the 8th article and promulgate the treaty." 26. The State Department was not prepared to change a treaty so casually, Secretary of State Seward replied. In my view, this department is not invested with the power of making the correction suggested, more especially as the Senate has formally required the reference of the treaty again to the Indians by its resolution advising the ratification thereof with a proposed amendment. If, therefore, in consideration of the clerical omission before 25-5 Stat 75. 26 W.T. Otto to William H. Seward, June 29, 1866, typed copy in ratified treaties. Page 438. The treaty was submitted to the Senate. It is now by you deemed inadvisable to send the instrument back to the Indians for their assent. The next best course would seem to be for the Department of the Interior, through the Executive, to remit it, with the accompanying resolution, back to the Senate, filling in the wanting word and making explanation of the facts, when the Senate could modify its resolution accordingly. The treaty with the resolution is herewith enclosed. Point 27. The Department of the Interior chose to seek the assent of the Indians, which was given on June 17, 1869, and the treaty was proclaimed on October 21, with the document of assent included. Point 28. A treaty with the Great and Little Osage Indians of September 29, 1865, contained a provision that should the Senate reject or amend any of the above articles, such rejection or amendment shall not affect the other provisions of the treaty, but the same shall go into effect when ratified by the Senate and approved by the President. The Senate on June 26, 1866, approved the treaty but with certain amendments, and Secretary of State Seward saw problems in spite of the proviso. He told Secretary Harlan, "It will be perceived, however, that if, under these circumstances, the treaty were promulgated at this time, it would be in a very incomplete and indeterminate state until the consent of the Indians concerned should have been given to the Senate's amendments." He suggested that the assent of the Osages be obtained before the promulgation of the treaty, and that was done. Point 29. When the United States dealt with the Northern Plains Indians at Fort Sully in the fall of 1865, it removed the need for Indian assent to Senate amendments by adding at the end of each of the treaties the remarkable provision, "Any amendment or modification of this treaty by the Senate of the United States shall be considered final and binding upon the said band, represented in council, as part of this treaty, in the same manner as if it had been subsequently presented and agreed to by the chiefs and headmen of said band." 30. Secretary Harlan declared that the clause had been inserted in pursuance of the direction of the 27 Seward to James Harlan, July 3, 1866, typed copy, Ibid. 28 Ratified treaties. 29 See documents in ratified treaties. A typed copy of Seward to Harlan, June 28, 1866, is filed with the treaty. 30 See, for example, Treaty of October 10, 1865, with Dominican Josu, Kapler, 2:884. Page 439. President, with the concurrence of his cabinet, and delivered by this department to the commissioners who negotiated with the Indian tribes respectively, for the purpose of obviating the necessity of resubmitting them, should the Senate ratify them with amendments. 31 The Senate used this authority sparingly. On rare occasions, the Indians refused assent to amendments. Then the Senate was asked to withdraw from its amendments and approve the treaty as originally submitted. One important case was the treaty with the Nez Perces in 1863. The Indians hoped that by refusing to accept the amended treaty they might regain the lands ceded in the treaty, but Commissioner of Indian Affairs Nathaniel G. Taylor realized the impossibility of getting back the ceded lands already in the hands of white miners and settlers. He argued in 1867. In view of the long agitation induced among the Indians by the delay in ratification of this treaty, the constant encroachment by the whites upon their lands, the time necessarily occupied in communicating with that distant region, and the fact that Congress had already appropriated the amounts stipulated under the treaty in question, both for the current and next fiscal years, I am induced to recommend that the Senate be requested to reconsider its amendments, and allow the treaty to go into Effect without alteration or amendments. The amendments proposed were doubtless in the interest of the Indians, but they do not appear to be of such an important character as to outweigh the good to be gained by putting the treaty into immediate operation, and closing all agitation upon the subject. 32. The Secretary of the Interior sent the treaty to the Senate on April 8, 1867, with the request for ratification without the amendments, but there was still another obstacle. The Senate, as a matter of protocol, sent it back to him with the notation that the treaty might be transmitted to the Senate, if deemed necessary, by the President of the United States. Accordingly, President Johnson sent the treaty to the Senate on April 11, and the Senate promptly ratified it in its original form on April 17.33. 31 Typed copy of Harlan to Seward, March 8, 1866, in ratified treaties, Senate Ex. PROC 14, PT 2, 58,183. Kapler failed to pick up the amendment in his printing of the treaty with the Upper Yankton A, where the phrase eliminated by the Senate still appears. Kapler, 2:905. 32 Taylor to Orville H. Browning, April 5, 1867, Senate, Sen 40 BC 10. 33 Senate Ex. PROC 15, PT 2, 662, 74,849. Page 440. The case of the Fort Laramie Treaty of 1851. The most notorious and complicated case of seeking Indian assent to a substantial change made in a treaty by the Senate was that of the Treaty of Fort Laramie of 1851. It shows how haphazard the treatment of a treaty could be and how convoluted the process of formal promulgation. After the Senate reduced the annuity payments promised in the treaty from 50 years to 10 years, the process of getting the Indians to approve the drastic change began. A suggestion that it was unnecessary to obtain such Indian consent was strongly rejected by Commissioner of Indian Affairs Luke Lee. A treaty is a contract. The word has a definite and well understood meaning. X6 to many it imports the idea of an agreement, and necessarily implies mutuality of assent. How then can that be considered a contract, a treaty which contains provisions prescribed arbitrarily by one of the parties without even the knowledge of the other? I am aware that there are several instances in which Indian treaties have been amended and promulgated as duly ratified without submitting them to the Indians for approval, but how such a proceeding, in view of the legal principles involved, can be considered anything but a mockery of the highest and most solemn form of contract it is difficult to perceive. 34. Directions were sent to the agents to obtain tribal approval, and 3 agreements were eventually made, 2 by Thomas Fitzpatrick in 1853 and 1 by Alfred J. Vaughan, agent of the Upper Missouri Agency, in 1854. Then, no doubt because of the delay, confusion arose about whether such approval had indeed been attained, and the treaty was never proclaimed by the President, even though the annuities were duly paid for 15 years. 35. The confusion is well documented. One of the copies of the treaty in the Indian Office file has an endorsement that reads, "This was to be submitted to the Indians, but they were never got together for the purpose." The amount has, however, been appropriated and distributed annually in goods this year, 1865 being the last of the 15. This view obtained for many years. When treaties from the 1850s were printed in the United States Statutes at Large in 1867, the Fort Laramie Treaty was omitted, with an explanatory note that said in part, "This assent of all the tribes has not been obtained, and consequently, although Congress appropriates money for the fulfillment of its stipulations, it is not yet in a proper form for publication." Charles J. Kapler in his 1904 compilation of Indian treaties printed the amended treaty in its proper chronological order, with a footnote, "This treaty as signed was ratified by the Senate with an amendment changing the annuity in Article 7 from 50 years to 10 years, subject to its acceptance by the tribes. Assent of all tribes except the Crows was procured. And in subsequent agreements this treaty has been recognized as in force." In 1929 Kapler admitted his error and printed an array of documents about the treaty ratification, including a copy of the Crow approval of the amendment. He included a long undated Indian Office memorandum from the mid-1920s about the matter, which gives a detailed account and which concludes, through oversight or inadvertence the Indian Service and the Department of the Interior neglected to formally advise the Secretary of State of the assent of the Indians to the ratification of Article 7 of the 1851 Treaty, and for that reason it would seem the treaty was never formally promulgated by the President of the United States. 36. Did the oversight or inadvertence invalidate the treaty? Some persons thought it did, because the treaty had not been perfected, and as a result the treaty was never added to the State Department ratified Indian treaties file. Then in the 1920s the Interior Department made a new attempt to get the treaty proclaimed. It sent its copy of the treaty with the 3 amendment agreements to the State Department, with the request that the treaty be laid before the President, at long last, for formal ratification. In reply, Secretary of State Francis B. Kellogg rejected the proposal on the basis that the Act of 1871 had prohibited further treaty making. And he questioned whether, as a matter of law, the treaty has been duly ratified by all the signatory bands and tribes of 36 Ibid, frame 756, 11 Stat 749, Kapler, 2:594, 4:106581, quotation on 1073. A detailed account of the approval of the amendment is given in Harry Anderson, The Controversial Sioux Amendment to the Fort Laramie Treaty of 1851, Nebraska History 37, 20120. Page 442. Indians so as to warrant ratification by the President, if that action were otherwise unobjectionable. He returned the documents to the Interior Department. 37 The Interior Department on its side argued, there is no question as to the lack of ratification by the President of the United States, nor is there any question as to the ratification by all the signatory bands and tribes of Indians. However, the provisions of the treaty have all been fulfilled, and the only purpose in obtaining a ratification by the President at this time was to obtain its publication in the statutes at large. In the end, no action was taken. Thus did the treaty remain in limbo. 38. Printing the treaties. Printed copies exist for a number of the earliest treaties, but whether they were printed by order of the government or issued by private printers cannot easily be determined. Some of them furnish simply the text of the treaty, while others, often in the form of a broadside, contain the President's proclamation and were intended to promulgate the treaty to the public. The ratified Indian treaties file has 37 Kellogg to Secretary of the Interior, May 11, 1928, documents, Roll 4, frames 8056. 38 There was considerable argument about whether or not a formal proclamation by the President was necessary for the validity of the treaty. Secretary of the Interior to Secretary of State, May 11, 1928, Memorandum of John R. Reeves, May 15, 1928, Memorandum of E. B. Merritt to Assistant Secretary of the Interior John H. Edwards, May 17, 1928, Ibid, frames 807, 81314. A legal opinion cited the Supreme Court decision of April 11, 1898, in New York Indians v. United States, 170 U.S. 23, in which the court decided that a proviso added to the Treaty of Buffalo Creek of 1838 was not present in the treaty as proclaimed by the President and was therefore unratified and not operative. The Indian Office in 1928 was apparently unaware of 2 decisions of the United States Court of Claims that had declared that ratification by the President was not necessary for the validity of the Fort Laramie Treaty. In Roy v. United States and Ogallala Indians, the court affirmed the validity of the treaty. It could find no provision in the Constitution or in subsequent laws that required proclamation by the President. Certainly, the court said, as to Indian treaties the contention that proclamation is necessary to give them binding force as between the parties is without reason. The Indians were our wards, and we thus occupied a fiduciary relation to them. The Sioux signed the treaty in the first instance, and when ratified and amended by the Senate they agreed to it as amended. They afterward received annuities under it, and their rights to the lands described in it were repeatedly recognized. To now hold that the treaty never had any binding force on the United States or its citizens would be contrary to good faith and common honesty. 45 CT. CL 183. A somewhat similar decision but of less general applicability was Moore v. United States and the Sioux and Cheyennes, Ibid. 32, 59398. Page 443. Printed copies of some early treaties and a broadside of the Creek Treaty of 1790.39 beginning with the Sac and Fox Treaty of August 4, 1824. The file generally includes a printed copy of the President's proclamation of the treaty, including the Senate resolution with amendments and the Indians' assent to the amendments. In the 1850s and 1860s, the State Department printed multiple copies of the treaty proclamations, regularly sending a batch to the Indian office for its use. 40. Congress, in a law of April 20, 1818, directed the State Department to cause the laws and treaties of the United States to be published in newspapers in the District of Columbia and in the states and territories. That this was meant to include Indian treaties was clear from an amendment to the Act in 1820, which specified that Indian treaties shall be published only in one newspaper and that to be within the limits of the state, or territory, to which the subject matter of such treaty shall belong. In 1842 such publication of laws and treaties was limited to newspapers in the District of Columbia only, but in 1846 the publication in state and territorial newspapers was reinstated. 41 Indian treaties were especially designated in the Appropriation Act for fiscal year 1856, Section 14, that the treaties made during the present Congress, with the Indian tribes, and those to be made in future, shall be published as the laws and other treaties in the newspapers of such states and territories. As the Secretary of the Interior may think expedient. 42. In the 1850s and 1860s the Secretary of State frequently wrote to the Indian Office asking for the state or territory in which given treaties should be published in newspapers and then got the names of particular papers from the Clerk of the House of Representatives or from the Secretary of the Interior. Whereupon he sent the editors of the designated papers printed copies of the proclaimed treaty. 43. In more permanent form the treaties ultimately found their way into 39 ratified treaties. A good many other early prints, some of them broadsides, appear in the microform publication Early American Imprints. See Clifford K. Shipton and James E. Mooney, National Index of American Imprints through 1800, the short title Evans, under U.S. President and U.S. Treaties. 40 ratified treaties. John Appleton to Charles E. Mix, April 14, 1859, typed copy, Ibid. 41 3 Stat 439, 576, 9 Stat 77. 42 10 Stat 671. 43 See numerous typed copies of letters on this matter in ratified treaties. Page 444. Print in published volumes of collected treaties. As early as June 14, 1790, Congress resolved that all treaties made, or which shall be made and promulged, under the authority of the United States, shall, from time to time, be published and annexed to their Code of Laws, by the Secretary of State. 44. In 1826 a preliminary volume of Indian treaties was prepared under the direction of the War Department, followed by an extended revision in 1837, whose title page indicated that it was compiled and printed by the direction, and under the supervision, of the Commissioner of Indian Affairs. In 1846, treaties through 1842 were issued in Volume 7 of the Statutes at Large, a volume devoted only to the Indian treaties. Subsequent treaties and a few earlier ones not included in Volume 7 were printed at the back of appropriate volumes of the statutes, although not always in correct chronological order. The irregularity in the chronological order was due in part to delays in ratification of the treaties by the Senate and proclamation by the President. Thus the treaties with Indians in the Pacific Northwest that were signed in 1855 and should have appeared in Volume 10 of the statutes were not proclaimed until 1859 and thus published out of proper order in Volume 12. In part, also, the delays resulted from inadvertence or clerical neglect. In early 1859 the Indian Office notified the Senate that 3 treaties of 1837, 1839, and 1842 had never appeared in the statutes at large, and the Senate, after referring the matter to the Committee on Printing, which was charged with determining the authenticity of the treaties, ordered that they be printed. They thus finally appeared in Volume 11.45 and as late as April 1870, the Indian Office told the State Department that the supplementary treaty with the Cherokees of April 27, 1868, upon which this office has based and will continue to base its action in its relations with the tribe, had not appeared in its proper place in the statutes. The Secretary of State replied that the omission had already been called to his attention and that it would be corrected in the next edition of the laws, as it was point 46. Finally, in 1904, a full compilation of the treaties, carefully prepared and edited by Charles J. Kapler, clerk to the Senate Committee on Indian Affairs, was published by the Government Printing Office. It reproduced the texts from the statutes and has become the standard. 44.1. Stat 187. 45 Senate Journal, 35-2, Serial 973, pages 18990, 285, Congressional Globe, 35th Cong, 2d Sess, 602, 877. 46 E. S. Parker to J. D. Cox, April 5, 1870, Hamilton Fish to W. T. Otto, April 8, 1870, typed copies in ratified treaties. Page 445. Reference work for treaty texts. Whereas the earlier printing, including the statutes at large, generally printed the original treaty and then appended a notation of the amendments made by the Senate and ratified by the President, Kapler usually, but not always, prints the treaty as amended. Point 47. The various published versions do not display great uniformity in their handling of the treaties or in their concordance with the original manuscript in matters of spelling, capitalization, and punctuation. Standards for exact reproduction in printed form of manuscript originals, which modern editors follow, were unknown in earlier times, and each editor or publisher tended to follow the spelling and punctuation rules of his own time. Thus the editor of the 1837 treaties between the United States of America and the several Indian tribes, from 1778 to 1837 noted in the preface, it was originally intended to have collated each treaty with the original manuscript in the Department of State, but upon making the trial it was found that the differences were altogether unimportant, and were occasioned, principally, by the punctuation, which was generally incorrect. The volume followed the printed copies of the treaties that came after Senate ratification. Clarence E. Carter, the meticulous editor of the Territorial Papers of the United States, collated the original copy of the 1789 Treaty of Fort Harmar with the printed text in the statutes at large and in Kapler's treaties. Although he found no important differences in words, he found more than 170 punctuation discrepancies. He wrote, "In these two versions more than 60 marks of punctuation found in the original treaty were omitted, more than 60 new points were inserted, and over 40 original punctuation marks were altered, many of which changes tend to obscure the sense." In the 1795 Treaty of Greenville, Carter found more than 100 changes in punctuation between the original manuscript and the statutes. Point 48. One element of inconsistency in spelling was Indian tribal names, for which no standardized spelling was established in the 19th century. Thus in Kapler's printing of treaties with the Potawatomis, the tribal name is entered in 27 different ways, none of which agrees with the standardized form used by Kapler in his titles to the treaties and by later editors. 47 citations to both Kapler and to the statutes at large for each treaty are given in Appendix B. 48 ter. Papers, 2:174n, 525n. Page 446. Appendix B. Ratified Indian treaties. Formal and solemn as treaties are, those made by the United States with American Indian tribes are not free of irregularities that make it difficult to prepare a definitive list of them. The original ratified treaties in the State Department's Ratified Indian Treaties file are arranged chronologically, with a serial number assigned to each. These serial numbers are given in the list below in square brackets. This list follows largely the compilation of ratified treaties printed in Charles J. Kapler, Compiler, Indian Affairs, Laws and Treaties, Volume 2, Treaties, which takes its text from the official publication in the United States Statutes at Large. Although the list depends heavily on Kapler's treaties, other compilations and lists of treaties, discussed below in Sources for the Study of American Indian Treaties, have been used, as well as an unpublished list of ratified Indian treaties, prepared by Robert M. Kvasnikoff for Volume 4 of the Smithsonian Institution's Handbook of North American Indians but not published in the handbook. The date of proclamation is the date when the President formally confirmed the treaty, signed it, and affixed the Great Seal of the United States. This date, sometimes called date of ratification, is provided in most cases by Kapler. Where there is a question, the original document in the Ratified Indian Treaties file, Record Group 11, has been followed. 6 treaty documents not included in the list are considered at the end. Page 447. A bar graph displays the concentration of treaty making in chronological order, but it shows only the number of treaties each year and does not distinguish between important treaties and minor ones. A map shows the council sites for the treaties. Sources for the map: each ratified treaty, usually in the title and sometimes also at the end of the treaty, indicates the place at which the treaty was signed. Some of the locations, for example, established cities and well-known military posts, were easy to pinpoint. But many, like shifting Indian villages, Indian agencies, or temporary encampments in the Indian country, were more difficult to determine. Modern commercial atlases and state maps were useful if the old place names continued. Especially helpful were the maps in Charles Royce, Indian Land Scions, and the maps in James Truslow Adams, Atlas of American History. Edward E. Hill's The Office of Indian Affairs, 1824-1880, Historical Sketches helped to trace the location of Indian agencies at which treaty councils were held. I have also used the files of old maps of the American Geographical Society, now located at the University of Wisconsin-Milwaukee, and was helped in some especially difficult cases by Ralph E. Ehrenberg, Chief of the Geography and Map Division of the Library of Congress,